Commissioner Makwasha, Commissioner Madlingozi, Mr. Dladla, the colleagues from the Human Rights Commission, members of the media, and any other stakeholder that is available in the room. We are going to start. Our time is now 9:05, and according to our program, this is the time when I'm just opening, but I will still go back to a recap and really purpose of the day. So before I do so, may I request that we all stand to observe a moment of silence. Thank you so much. You may take a seat. Welcome to the second leg of the inquiry that began yesterday, wherein we had the Minister of Police, Mr. Kachalia, the National Commissioner, General Masemula, Major General Asane, Colonel Madiba, and Ms. Ramurena Cheu. The presentation was delivered by the General on behalf of SAPS. SAPS submitted that food access was limited based on reports alleging that sufficient food supplies were stored underground and controlled by the so-called kingpins. However, SAPS could not produce affidavits, written intelligence reports, or any documentary evidence to substantiate their allegations. This absence of supporting documentation significantly weakened the credibility of their submissions. As a result, the Commission requested SAPS to provide proof of engagements, attendance register, and any additional documents that could assist in the inquiry in order for the Commission to be able to assess the factual basis of their actions. The Minister of Police requested that the Commission make findings on whether there were violations of human rights and further sought guidance that could assist SAPS going forward, particularly to prevent similar situations in the future. It also became evident during the proceedings that UMGODI project was operational despite the fact that no one could clearly account for its origin, authorization, or formal establishment. The name itself appears to have been derived from operational usage rather than any formal approved policy or legal framework. The General was not operationally involved and consequently deferred majority of substantive questions to Major General Asane and Colonel Madiba. Their responses confirmed that no protocol or guiding framework existed to regulate the so-called UMGODI operations. Court orders were presented which demonstrated that the extent of SAPS non-compliance and contempt, notwithstanding the fact that the same SAPS officials remained argumentative during proceedings. This further highlighted a troubling disregard for judicial authority and procedural accountability. The second witnesses were from COSATMA. During the or rather maybe before I go there, it is important to mention that the MEC had sent an apology to say that he was involved in a car accident, and that is MEC Morweng Vessels. He had been involved in an accident the day before yesterday, and that is why he could not avail himself, and he was attending to his medical condition. We were then faced with the official, Mr. Rantuna, whom we had to wait for almost a period of an hour just for her to source delegation, because in the letter of apology, we did not get a delegation of authority from the MEC to say that she has been authorized to testify. She ultimately was able to get the letter, which was submitted before the commission, where she accepted that whatever that she's going to testify, it is in line with what would have been testified by the MEC, and the MEC has accepted that whatever she's going to put on record is going to be binding on him. So during her testimony, it became evident that while COSATMA asserted that it has an oversight role over subs, it was unclear whether the organization fully understood their scope, their limits, or the legal basis of their role. Their submissions lacked precision on how such oversight is exercised in practice or grounded in law. Civilian Secretariat Police Service Act of 2011 was then alluded to, and of course they were engaged on it, and became clear that whilst, yes, they know that's the act that guides them, but they were not able to articulate themselves in the act. The COSATMA maintained the position that the denial of food constitutes violation of human rights. This assertion was presented firmly, though it was not accompanied by a detailed legal framework or reference to constitutional or statutory provisions that would substantiate, contextualize the claim beyond its moral force. The inquiry had evidence from both departments, and as I've said, and it is clear that we still have to probe some more, and that is why ultimately at the end of it, we have requested that a number of documents be presented, which documents we hope they will be presented in the next 5 days from yesterday, which will then assist in order for the commission to arrive at findings that will assist in taking this inquiry forward. And that is the short summary of what happened yesterday. We'll then move over to the presentation by the Department of Social Development, which we really appreciate that it is in person, especially because yesterday we had to struggle with the virtual platform as the minister was testifying online with his officials. The camera that is before me is blocking my view of the minister. Is it possible that it can be moved? Thank you so much. We need to just also mention this. We do have language operators that are with us this morning before I introduce everyone else. And they are Fortune Madlala as well as Sarah Klaas. Because I represent persons with disabilities, I always find that we forget about them. And it's okay for them to interpret, but we never seem to know their names. So I thought I should put it out there. I've already said that I think I forgot to introduce myself. My name is Nomahlubi Kwinana, Commissioner in the Human Rights Commission, with a number of focal areas. I'm going to ask the room to represent, to put their names on record. Individually, I would not be able to do it properly. So can we just do that? Commissioner, let's move to your side, and then we'll come to Mr. Dlala.
Good morning, Chairperson of the panel. Good morning to my fellow Commissioner, Commissioner Madlingozi. Good morning to the Honorable Minister who has joined us and her team. I am Commissioner Sandra Makwasha from the Human Rights Commission.
Thank you, Commissioner. Good morning, everyone. My name is Sifiso Dlala. I'm a panelist here today with more than 10 years experience in working in artisanal mining space. Thank you.
Thank you. Let's move over to our team. Or maybe before you do that, apologies, may I just have Commissioner Madlingozi put his name on record, please? May you just avail the mic to him?
Good morning, Commissioners. Good morning, Chairperson of the Inquiry. Good morning, Honorable Minister, DG, once again. My name is Commissioner Tsepo Madlingos. Thank you.
May we have the team?
Good morning, Chairperson, Commissioner Kwinana, Commissioner Makwasha, and Commissioner Madlingos, Mr. Dlala, Minister and your team, colleagues. My name is Emmanuel. Surname is Nkonde. I work for the Commission. I'm based in the Northwest Provincial Office. Thank you very much.
Good morning, Honourable Minister, Commissioners. My name is Advocate Afika Ngaito, and I'm also from the South African Human Rights Commission. Thank you.
Good morning, Commissioners, Minister and the team. My name is Tunoko Mudise. I'm the Provincial Manager in the Free State Provincial Office of South African Human Rights Commission.
Thank you so much. That concludes our team, Minister. We are now going to hand over to yourself to then introduce your team, and with the same breath, then you can proceed to the presentation, or of course the preliminary issue that you've alluded you'd want to canvass. Thank you.
Thank you very much, Commissioner Kwinana, and all the other commissioners present here, the senior officials of the Human Rights Commission, our senior officials of the Department of Social Development led by the Director General, Mr. Peter Nechipale, members of the media present, ladies and gentlemen. Commissioner, I'm just going to do introductory remarks and allow the DG and his team to get into detail of our report. And that's all that we'll request from yourselves. If it's allowed, can I proceed?
Oh, Minister, maybe just the names on record first, because we will then have to move over to issues of oath and affirmation before we get into the order of the day. Thank you.
Thank you very much, Commissioner Kwinana, once again. My name is Sisisi Nokuzola Tolashe, the Minister of Social Development in South Africa.
Good morning, Commissioner, Chair, and other commissioners. My name is Peter Nechipale. I'm the Director General of the Department of Social Development. I also wanted to clarify something before we start. Now that I've got the mic, before I hand it over to anyone, I think there were some issues of communication breakdown because we were in, we realized, yes.
Those are issues that we'd won under oath or affirmation. So we are only going to take that part as at the time we are done with the affirmation. For now, let's just get the names on record.
Good morning, Chair, Commissioners. My name is Cesar Mahangwe. I'm the Deputy Director responsible for Social Welfare Services in the Department of Social Development. Thank you.
Is that the team, Minister?
Yes, Commissioner, I have the team behind me. Thank you.
Good morning, Commissioner and Minister and other commissioners and colleagues. My name is Dr. Tebogo Mabe. I'm the Director responsible for adoptions and international social services by the Department of Social Development.
Good morning. My name is Lillian Nzenge. I also work under the program International Social Services at National DSD. Thank you.
Ki rata go dumedisa the commissioner. My name is Abraham Patla Mutlaka in the Ministry, Social Development.
Thank you, Chair. Good morning, Commissioners, Honorable Minister, DG. My name is Simpiwe Figlin, the PA to the Minister of Social Development. Thank you.
Thank you so much. We'll now move over to our formalities, Honorable Minister, and may I request that you stand. Honorable Minister, according to our procedure, maybe just on a summary view, we take evidence under oath or affirmation, and this is informed by Section 15 of the South African Human Rights Commission Act 40 of 2013. So what I would want to know from yourself, Minister, is that you're going to testify under oath or affirmation.
Affirmation.
Thank you so much. May you please state your full names once more for the record?
My name. Apologies. My name is Sisi Nokuzola Gladys Tolashe, a Minister of Department of Social Development in South Africa.
May I please have your age on record?
I'm 64 years old. Thank you.
It is so that you have elected to do an affirmation.
Thank you very much, Honorable Chairperson. I stand here and affirm that I'll give lead evidence on the matter before us as Department of Social Development. I do that according to the Constitution of the Republic. Thank you very much.
Thank you, Minister. Do you then solemnly affirm that the evidence you're about to give will be the truth, the whole truth, nothing but the truth? If that is so, please raise your right hand and say, I do solemnly affirm.
Thank you, Chair, once again. I do solemnly affirm.
Thank you so much, Minister. You can take a seat. May I also confer with you that the colleagues that are with you are next to you now. Are they also going to testify, or are you the only one who's testifying?
Chair, thank you very much, because they will be diving deeper into our responsibility. Therefore, I think it will be wise for your process for them to take that oath or affirmation. Thank you very much.
Let's then move over to the DG. DG, your full names on record, please.
My name is Pumulani Peter Nichipare.
Your age, please.
I am 64 years old.
Is it the oath or the affirmation?
Is oath.
Do you have any objection taking the prescribed oath?
No, I don't have any objection.
Do you regard the binding oath to be, do you regard the oath to be binding on your conscience?
Yes.
Do you swear that the evidence you're about to give will be the truth, the whole truth, nothing but the truth? If that is so, please raise your right hand and say, "So help me God."
I swear that the evidence that I'm going to give is the truth, nothing else but the truth. So help me God.
Thank you so much. Please pass on the mic. Your full names, please, and maybe your age as well.
My name is Sizakele Mahangwe. I'm 57 years old.
Is it the oath or the affirmation?
It is the oath, Commissioner.
Do you have any objection taking the prescribed oath?
No, I don't.
Do you regard the prescribed oath to be binding on your conscience?
Yes, it is.
Do you swear that the evidence you're about to give will be the truth, the whole truth, nothing but the truth? If that is so, please raise your right hand and say, "So help me God."
So help me God.
Thank you. That is the team minister. We're now going to then hand over to Minister to then deal with any issues that you deem fit. Thank you.
Can I make a request that DG does what he is supposed to do on the communication between your good office and ourselves on the earlier arrangements? Thank you.
Thank you very much, Minister. Thank you very much, Commissioner, Chair. I just wanted to set the record straight and also to make the Commissioner aware that there are communications that were sent in September, October, as the ministry and the department, we did not get those because they were sent to officials that were no longer in the department. So we did not, the gesture is that it is not that we didn't want to come and appear before the commission. As you are aware, each year when we are called here, we come on time and we come to testify or to give a report. So that what happens in October, we didn't get that. That's why in the subsequent communication, we were able to get it when the officials have changed, and the communication was sent to the relevant officials who were in the department. We were able to get that, the ones that were supposed to be in December, and it was moved to now February, which is today. That's what I wanted to set straight, that I think the department cooperate and is always available for the human rights anyway. You realize towards the end we were in Eastern Cape doing the same on the issues of malnutrition, which shows that we are always available. We respect this Chapter 9 institution, and we will always abide as prescribed in the law. Thank you very much.
May we have you then state for the record who are these officials that were no longer in the employment of the department, and which emails are those that were used? And maybe going forward, you can also state which emails are then in use.
Thank you very much. Let me state that the two officials that were not in the department, it was Zanele Simons, who was the chief of staff of the minister, and Eliseidi Mabileja, who was the private secretary of the minister. Then we have now Simpiwe Figlen, who is on my right here, who is now the secretary of the private secretary to the minister. We have got an acting chief of staff, Mr. Abraham Pakamklaka, who is at the back, who was communicating with your administration from December on the communication that we have. The emails are the departmental emails that are available. We will also, before we leave here, give the administration the emails, including the emails in my office. Thank you very much.
Thank you. Commissioner Makwasha?
Chair, I'm covered by the presentation from the DG. I have nothing to say, thank you, except to note it with thanks.
Mr. Dladla?
Thank you, Commissioner. No, I'm good. I'm covered.
Mr. Nkonde? Advocate Nqetho?
Covered, Commissioner, thank you.
Mr. Modise?
I'm also covered. Thank you so much, Commissioner. Thank you.
Minister, the panelists as well as the legal team does accept your submissions, and of course an apology that accompanied the submissions, and of course we're looking forward to then receiving a proper notice as to the relevant emails that should be used to communicate with the office going forward. We'll now then move over to the presentation. Thank you so much.
Once again, Commissioner Kwinana, the chair of the panel, all commissioners, senior officials of the Human Rights Commission, our senior officials of Department of Social Development led by our DG, members of the media, ladies and gentlemen, we really appreciate your understanding, and we are quite thankful that you understand where we're coming from with this kind of a very technical glitch, but that could create a very wrong perceptions. Thank you so much. Once again, good morning to you, Commissioner, and thank you for affording us the opportunity to make inputs into the South African Human Rights Commission. into its national inquiry into the policy framework around artisanal mining, the impact on the human rights of surrounding communities, and the scope and tactics employed in the Operation VALA. Director General Mr. Peter Nechipal and Deputy Director General for Welfare Mrs. Mangongo will make a detailed presentation on the mandate of the Department of Social Development in relation to the key questions this inquiry has posed to us. The presentation will look at the human rights implication and give an account on intervention that Department of Social Development implemented during Operation VALA in the Northwest and Mpumalanga province, respectively. Before the Director General and the team make the presentation, allow me, Commissioners and Honorable Chair, to say a few words. At the outset, I must state that we welcome this national inquiry by the Commission, as we believe that it will shed light on the risk and vulnerabilities confronting mining communities due to this growing national phenomenon. Commissioners, as this inquiry is by now aware, and as per the National Commissioner of South Africa Police Services General Fani Masimula presentation yesterday, Operation VALA is a coordinated net joint police-led initiative aimed at combating illegal mining and associated crimes across South Africa. Launched, of course, in November 2023, the operation targets the criminal networks and environmental degradation linked to illegal mining activities. South Africa is one of the countries in the African continent that has rich endowment of critical minerals such as gold, diamond, chrome, and other critical minerals that hold immense potential to drive sustainable development and economic prosperity. Yet, these minerals also bring with them profound socio-economic challenges and pose serious threats, not only for the immediate mining communities, but also for the country. Addressing these challenges demands a collaborative, multi-stakeholder approach and inter-country cooperation. While we do not have a full knowledge of the scale of this problem, we are primarily concerned about the involvement of underage children in the illegal mining activities. Operation VALA has uncovered widespread involvement of minor children, especially underage children from neighboring countries. This is a serious violation of children's rights that puts their health, safety, and prospects at risk and deprive them of their childhood. In the face of this, there are growing demands for a whole government and whole of society approach to address this challenge. Honorable Chair, Section 28 of Constitution of the Republic of South Africa provides for the rights of all children in South Africa, including unaccompanied and undocumented migrant children who may be victims of child trafficking. The Palermo Protocol defines child trafficking as the recruitment, transportation, transfer, harboring, or receipt of child for the purpose of exploitation. In addition, the Constitution of South Africa has enacted national laws and various international treaties that put an obligation on the state to intervene on matters relating to the protection of children within its borders, including children involved in illegal mining. Chief among these is the Children's Act number 38 of 2005 as amended, and the Child Justice Act of number 75 of 2008, like the Constitution. The Children's Act protects all children within the borders of South Africa, and Section 151J of the Act provides that migrant children are children in need of care and protection. The Children's Act and the Child Justice Act mirror the United Nations Convention on the Rights of Children, commonly known as the CRC. There are 4 core principles of the CRC relevant for this inquiry, namely non-discrimination, best interest of the child, survival and development, and views of the child. Article 22 of CRC relates directly to the protection of assistance of irregular migrant children, whilst Article 37B states that no child should be deprived of liberty unlawfully or arbitrarily. Social development is the lead government department for development and implementation of measures for the protection of the most vulnerable groups, children, persons with disability, and older persons, among others. I work together with that of our social sector partners, civil society organizations, communities, and faith-based organizations, and other agencies is essential for this purpose. Based on the mandate and the legislative framework that I alluded to earlier, the department worked closely with the provincial departments in both Northwest and Mpumalanga. The presentation will outline some of the intervention we implemented in collaboration with law enforcement agencies and foreign embassies based in South Africa. At the regional level, Honorable Chairperson of the province, of the panel, South Africa has signed several cooperation agreements with some of the Southern African development communities, which is SADC member states, to protect unaccompanied and undocumented child refugees against modern slavery and other forms of exploitation. To date, we have concluded cooperation agreements with the Kingdom of Lesotho, Republic of Zimbabwe, and the Republic of Mozambique. Negotiations are currently underway to conclude similar agreements with other SADC member states. We maintain regular dialogue with these member states through the quarterly cross-border forum, comprising of key departments such as Home Affairs, Health, Basic Education, and Border Management Authorities, amongst others. United agencies such as the UNICEF and United Nations High Commissioner for Refugees and civil society organizations, including Save the Children, International Red Cross Society, Center for Child Law, and Lawyers for Human Rights, form part of the cross-border forum. As I conclude, Honorable Chair of the panel, we strongly believe that strengthening policies and legislative framework is key to preventing illegal mining. We must also look at ways of empowering local mining communities. These communities are often the first and most severely affected by illegal mining, facing health, social, and economic impacts. With these few words, allow me, Commissioner, to hand over to the Director General to take you through this presentation. I thank you very much.
Thank you very much, Chair and Commissioners. This is how we will want to provide our report to the Commission. Our purpose here, as Minister have already alluded to in the main, is to present the comprehensive report in view of the questions that were asked. There are 5 questions that were asked that we need to respond to, which are very, very, very important from the Commission and for the country as a whole. So we will, our report into the inquiry of the policy framework around artisanal mining, the impact of artisanal mining on the human rights of the surrounding communities, and the scope and the tactics employed in Operation VALA UMGODI. As Minister alluded to our role in relation to the acts, children all over the world, especially those coming from the poor families, are very vulnerable in many ways that affect their welfare, well-being, and the social justice. And that's where the Department of Social Development comes in. Due to their vulnerability of these children, they are used and abused by adults, including their own families. They are in this way prevented from fully enjoying their childhood completely. The forms of abuse that they experience include being trafficked across countries, lured into unsafe work situations, and they are also sometimes guided to work as breadwinners in other areas due to some challenges that they experience. The country response, including social development, to these incidences and prevalences of child rights abuse are reported at an international and local fora to ensure compliance with the prescripts. And this also ensures us as a department to take the responsibility. So what I'm going to do now, Chair, is to request the DDG responsible for welfare to take us all the questions, question 1, question 2, question 3, question 4, question 5, and then we come to the conclusion to embellish the summary report that the Minister has provided. We appreciate this questions as they guide in terms of how, and I think to guide also us as a country, that we are concerned about what is happening in the country. And those are the things that each and every one of us as government department implement our policies to ensure that our children are safe, to ensure that we take care as articulated in the our Children's Act 38 of 2005 and the Criminal Justice Act of 2008. Let me hand over to Member Hawa to give us a full report starting from question 1 on the on your inquiry. Thank you very much. Over to you, Member Hawa.
Thank you, Minister and DG, and thank you once more, Chairperson and Commissioners. Let me start by contextualizing as well our involvement as far as the law enforcement agencies are concerned. Yes, as a Department of Social Development, we are mandated to deal with children that are in need of care and protection, as well as children that are in conflict with the law. So because of that mandate, we do serve on both clusters. There's a cluster called Criminal Justice System Cluster, the JCPS, as well as the social cluster. So under the JCPS cluster, that's where all the law enforcement agencies are serving, and that's where the project VALA UMGODI is also being, managed. So as a department, because we're a member of the clusters, we do attend the meetings, we do provide feedback in terms of, what is it that you are expected to do as a Department of Social Development. So as I move on with the first question that talks to how the department got to know about this and what was our involvement. We are saying as a Department of Social Development, firstly, we are mandated to provide services based on the two legislation that both the Minister and the DG has alluded to, which is the Children's Act as well as the Child Justice Act. So what happens, it was alleged that children were part of, were part of the people that were found to be involved in illegal mining, and those children were apprehended by police. And based on the protocol that is already in place, once children are apprehended by the police, what police normally do, they will then refer them or inform us as a department to say, we have children here, they have been apprehended for, the following, offenses. Based on those, a referral will then kick in and do our work as a Department of Social Development. So as soon as it was alerted to us through our provincial department, which is Mpumalanga as well as Northwest, we then dispatch our social workers as well as probation officers. What they have done, they then looked at what is it that we need to do in terms of, our mandate as a social development. We then, maybe let me go to Northwest. With Northwest, they have received 32 children that needed to be assessed and confirmed that they are children, because there were no documentation whatsoever. So the court needed to know whether we're dealing with children or not. So the Department of Social Development, through the work of the Intersectoral Committee, we requested the Department of Health to assist us and do the age determination. They've done that, reports were sent, and it was indeed confirmed that 32 children are they found to be children under the age of 18. Same applies in Mpumalanga. 16 children were confirmed and they were found to be children. As soon as the confirmation came through, we then started with our mandate, which was to conduct the assessment. So we've conducted the assessment of all those children. The purpose of us conducting the assessment was to make sure that at the end of the day, we are able to come up with we call it IDP, development plan. It's a plan where you look at a child individually to say, what are your needs, what are the issues, what are the home circumstances, what led the child to be where he is. Was the child coerced? Did he understood what he was doing, whether it's crime or not? We go through that entire assessment process. There's a tool that we use to actually do that, and it is a standardized tool. All the social workers as well as the probation officers, they use the same tool so that we make sure that we have a standardized report. Since that report, we share it in the main with the whole cluster. For instance, the courts depend on that court. Police, as they are doing their further investigation, they depend on that report. So it is quite a comprehensive report, and it has to be, as I'm saying, standardized. And with the cases at hand, we were challenged with the issues of language because those children were coming from Mozambique, so language was a barrier. So in order for us to have a proper assessment report, we had to solicit the services of the interpreters. We did get interpreters on board. They were able to assist us with the language so that children are able to express themselves and we are able to really understand what transpired. Like I said, that the age determination was also done. That also assisted us, and that was also part of the assessment report that we did. Immediately after the assessment, as a Department of Social Development, we're expected to provide the shelter. We're expected to provide basic needs of the children like food, security, and any other needs depending on what are the needs of the children. That's what we did. In the case of Northwest, at the time of this incident, the facilities that we have, the CYCCs, were all the beds. There was no beds available, but because of our mandate and our obligations, we had to find a way of ensuring that children are still, kept in a safe place, and children are not found in prisons, because the Child Justice Act is very clear that no child must be found in prison. So the Department of Social Development is given the responsibility to make sure that we provide the shelter that is safe, that it's not a prison setting. So with those challenges, the Department of Social Development, together with the province that was affected, which is Northwest in this case, took it upon themselves to make sure that a temporary safe place of safety is established to make sure that the children are accommodated there. That's what has happened. And then, we went through that whole process. Children's needs were met, their food, their security, and so on. As we continue with the services that we've rendered, we as a department, we are also responsible to provide international social services. These international social services help us to link with social workers globally. If we're dealing, and it's not only focusing on children, even adults, we do assist them. We're able to link with agencies outside our borders and be able to trace families, to deal with the situation and make sure that we assist the vulnerable groups as much as we can. In this case, our International Social Services Unit, we began to engage with the repatriation process, because we're dealing with children who were coming outside the borders of South Africa. The department liaises with the Mozambique. We've engaged the Mozambique consulate, and we had some interviews, some engagement with them. The purpose of engaging them was for them to ascertain the nationality of these children. So they've really assisted us with that. At the end of that process, they were able to, provide us with the repatriation certificates to confirm that indeed these children are their citizens and, normal processes have been followed. Then after we began to deal with the social workers from that side, we're requesting them that all the 32 children, can they assist us to trace their families? Because for us as a Department of Social Development, we also have a white paper, we are custodian of the white paper on families that says children belongs to families. Yes, alternative care placement are there, but the priority is to build families, is to strengthen families, is to make sure that children belongs to families, no matter what challenges are there. Of course, as the Department of Social Development, we will intervene, we will provide psychosocial services, we'll do what will assess the family needs and intervene. But at the end of the day, we are saying children belongs to families. So that is why our first point of call is to identify family and assess their state and say, are you in a state where you'll be able to receive your family member? If not, while we are placing a child in a temporary places of care, what is it that we can do for the family so that at the end they know that they are still responsible for their family member, and whatever the challenges that they are faced with, there must be a solution so that they are able to be reintegrated again. So those are some of the things that we're able to do, which was family tracing through the services of the ISS, the International Social Services. It's important to also indicate, Chairperson, that tracing families was a tedious process. It was not an easy process. So before families could be identified, we had the social workers on the other side had to identify places of safety where they were going to keep children while they are looking for families, while they are, confirming that indeed these are their families and so on. As soon as they identified, they gave us a go-ahead that now you can release the children, even though they were still in a process of, confirming, validating the information that they've received. They were able to, place children at the place of safety on the other side. So we're quite satisfied with the process that was undertaken. And I must indicate that 27 children were repatriated safely on the 17th of December 2024. We had 5 remaining because we still had to confirm. We still had to wait for them to give us the confirmation. As soon as they were done, the remaining 5, it was also they were also repatriated. So as we speak, Chairperson and Commissioners, all those children we received confirmation from the Mozambique. From the Mozambique authorities that children have been reintegrated with their families, which for us, it was a good story because we're happy that exactly what we believe that children belongs in families, indeed they ended up in families, not in places of safety. There was also a question around coordination, and as to say, do we have coordinated structures? Do we recognize that the issues that we dealing with are highly intersectoral, meaning that not only one agency can be able to successfully intervene and deal with them. So we are here to say, yes, indeed, we are part and parcel of the intersectoral committees that are out there. The first committee that we serve as a Department of Social Development, where we are able to render our services, is not joint. We have a structure which is led by SAPS as well as state securities called not joint. At a provincial level, we have the very same structure that mirrored the national one, is called Prof Joint. That's where anything that has to do with crime related around issues of children, we are there, and we are meeting on a monthly basis to give progress in terms of the issues that we are dealing with. The second structure that we participate is called Intersectoral Committee on Child Justice. It's also a structure where again it's issues of crime, it's issues of how do we protect children from crime, those children that are already have committed crime, how do we ensure that they are diverted, they don't go further deeper and end up with criminal records, but we rather divert them to services and make sure that they get, for instance, things like maybe find that there's an assault, there was fight. Do we really have to, take children through that system and make sure that they become criminals? No, we don't. So we divert such cases and, make sure that they attend compulsory anger management programs, depending on what are the needs or the presenting problem. But that's a structure where we actually go and say, this is the diversions program that we are doing, this is how far we are doing. And we also have an annual report that is tabled in cabinet on an annual basis to inform the cabinet how far are we doing as far as issues of a child in conflict with the law. The third one is the Illicit Mining Priority Committee. This committee is led by SAPS. It's part of NAJOINT. We do serve from time to time to give, for instance, in these cases, like the cases that we've alluded to earlier on, we were expected to come and give feedback and say, how many children did you manage to assess? How many children we managed to ensure that there's safe repatriation? So in that structure, that's where we give progress. The other one that we participate is called Cross-Border Management Committee. It's a quarterly one where we are also meeting with our counterparts from the SADC region, and we come together with integrated programs and say, how do we provide services to all the children irrespective of where they come from, so that there is that kind of safety that we are providing. The other critical one is the National Steering Committee on Management of Unaccompanied Minors. We also provide services there. And the very same structure is also mirrored in the province. In terms of the roles, yes, we are playing different roles, but as a department, let me maybe zoom into our role as a Department of Social Development. What is important for us as a Department of Social Development is to provide child protection services. That's what we do. And it is outlined. We have protocols that say what is that. Like I said, we do assessment. As soon as a child is found to be in need of care and protection, we do a thorough assessment. We develop the plan. We place them in a place of safety if they are not able to go back home because of maybe the home circumstances are not favorable. We make sure that they continue with their education. It's very important. We make arrangements with education to say if our facility does not offer education, we then arrange homeschooling. We look at various needs. Others, you find that they've been out of school for many years, so we don't force them to go back to school, but we look at alternatives like vocational skills. We provide those kind of vocational skills like plumbing and so on and so on. We're working with sitters, to assist us to put those programs in place. So that is what we do in the nutshell as the Department of Social Development. And we also work with outside social workers to assist us and assist the families, because as we are saying that children belongs in families, and these problems that children are contending with, they come from families. So it's important that as much as we have received them in our facilities, we also do some work with their families at home, because we want to make sure that they are reintegrated with their families. Then there was also a question around the implications of human rights, as well as whether our policies are safeguarding the needs of our children. So I want to indicate, without going through the whole slide, to say that the services that we are providing are human rights based. We very much aware of that, and make sure that the services that we provide, they do not really violate the rights of our children in South Africa. And we are working with. There's also the issue of Mandela rules. Since we are running those facilities, we've got CYCCs, and we are part of the Mandela rules, where we make sure that human rights instruments are adhered to. So that's what we normally do through that. So we can safely say we are safeguarding the rights of our children in South Africa. Almost the last one is around, the last two is around the kind of the policies and the legislations that we are having. Oh, sorry, I've already alluded to. We are on a recommendation. What is it that we are recommending in terms of the policies and the legislation? Chair, I must say that South Africa is known as one of the countries that have best policies and legislation. We have written so many policies to make sure that really the rights of the children are safeguarded. We have protocols in place that make sure that children are not, their rights are not violated. In any event where their rights are violated, there is a way of us intervening and making sure that we remedy those situations. Having said that, Chair, there is still a room for us to strengthen our services. As much as we have the policies in place and we have the protocol in place, there is still a room for us to strengthen our services, especially when it comes to prevention work. Because, for example, the services that I have alluded to is services that we are expected to render when a problem has presented itself. So we are not so strong when it comes to prevention work on this area. So these are the areas that we are working on to say we already have a 365 child protection program, but that program we are saying we need to upscale it, we need to strengthen it and make sure that it becomes more inclusive and focus on those areas that are affected by illegal mining. Furthermore, we are also proposing that we need to strengthen the regional coordination on migration because we feel that it's an area that is lacking. As much as we have cross-border management committees, but there's still a room for us to further strengthen that area. We are also saying we need to strengthen family preservation policies to make sure that children do not leave their families. They remain with their families irrespective of the challenges that they are facing. In terms of the conclusion, Chair, we are saying based on the Department of Social Development mandate, we continue to commit ourselves to provide care and protection of our children, and we continue to work with the vulnerable groups and make sure that we contribute as far as the Operation VALA program is concerned. The last part, which is recommendation, Chair, we are saying it is recommended that the Human Rights Commission note the Department of Social Development's national inquiry into the policy framework around this matter and also receive our report, Chairperson. I thank you.
Thank you very much, DG and DDG. Honorable Commissioner, the Chair of the panel, this is our presentation as Department of Social Development. Thank you so much.
Thank you so much, Honorable Minister, to the DG and the DDG. Thank you so much. We are now going to allow our legal team to then engage you with regard to the presentation. Advocate Ngqetho, over to you.
Thank you, Chairperson. Just before I begin, Chairperson, I think I'd just like to be guided like I was yesterday with regard to who are we asking questions to in particular. Would I direct them to the Minister directly or to the whole team? Would that be appropriate? Okay, thank you so much. The first question that I would then like to ask, I think, relates to slide number 12 of your presentation. You advise, and it speaks to the coordination with law enforcement and interdepartmental mechanisms. And one of the committees that you referred to is the Committee on Illicit Mining, which forms part of NAT joints and PROV joints. Now, Operation VALA obviously wouldn't have started with Stilfontein as its primary sweep site, for example. So before we get even into Stilfontein itself, how long has the department been part of those committees before the Stilfontein tragedy occurs?
Thank you, Commissioner. Maybe let me start with the NAJoint. We've been with the NAJoint from inception. It's more than what, I don't know, maybe 10 years or so. Yeah, we've been there for long with them. But NAJoint, they've got different subcommittees depending on issues that are emerging. For instance, the illicit mining one, it has been there, I don't know, maybe 2 years or 3, I can't remember. But with us, they just roped us in not so long. We've been serving there for about 12 months. The reason why is because when it started, children were not involved. It was just adults only. So they felt that the department is really not needed because it was purely adults that were engaged in that activity. But as soon as they started, picking up issues of children, they then realized that we are needed. They need to extend the invitation to us to come and participate, not only, doing our work, but also giving strategic direction in terms of how can we cap this problem of children that are being used. So that's when we got involved. So as a department, it's not been long being called to this. So I can safely say 1 year to maybe 18 months being involved in it. Thank you. But before, it was ad hoc. So for us to be permanent members, it was around 1 year, 8 months. Thank you.
I think I just want to then unpack part of the answer that you just gave, which speaks to strategic direction. And I think I want to zone in on the strategic direction now as it relates to Stilfontein specifically. When that particular incident was happening, was the department made aware of the fact that there are potentially children underground? Because I also think it needs to be made clear that the narrative that we understand from SAPS is that this is obviously a multinational syndicate, and trafficking is one of the ways that they go about to actually getting people underground. So if that's the understanding that we work with, I would understand how they would rope in the department from that perspective. But I then want to understand, was there any strategic guidance given to SAPS during Stilfontein in particular?
Yes, it was. We discussed the whole issue of saying yes, of course, much as we know that we will respond at that time when this incident happens. But then we said, since it's becoming a trend, it's something that is becoming common. One of the things that we are recommending that we need to do is that we need to do joint awareness campaigns where we are creating awareness around these issues, and also getting involved the entire community, not only the area that is affected, but everyone, so that everyone knows that it is wrong for communities to be involved in this kind of activities, and also raising the issues, the important, issues of children, to say children must be protected at all costs, because we've realized that people are using children simply because they know that children cannot be charged, children cannot be sentenced to prison. So therefore, it's easy to use them as a front and continue to commit crime. So we therefore spoke about that to say, very, very important that as part and parcel of our intervention, much as yes, there will be that immediate intervention where people are arrested, where we are doing assessment, but over and above that, we need to have an integrated strategy where all of us are going there in one voice and say, as a social development, what are the children's rights and why it's important that children must be protected at all costs, and what is the role of the community when they see these things happening, and what is the role of other NGOs in the sector to make sure that all of us, at least we have one understanding around how do we protect the rights of the children. So for us, the strategic issue was when we raise the issues of getting the community involved, so that it does not only end with law enforcement agents, but it becomes a whole community matter. Everyone must commit, and everyone must come around and understand that they've got a role to play, and they will be able to assist us to resolve these challenges. Thank you, Commissioner.
Thanks very much. Thanks also for the question in terms of the strategic directions, actually, from the department as a whole. Department is organized in many fora that we have. We have a fora for all the HODs that comes into a meeting. And as a department, we require a department to report on any incidences that is reported, either on the media that we pick it up or any incidences that will be reported. When this matter arises, one of the things that we do in the department, we request that Northwest actually remember asking them to send a report and the intervention that they're doing. Also requesting that the Premier's office assist so that those kids can be obtained. So we provide that direction in terms of the mandate, in terms of the role that the Department of Social Development must play. From national, we provide that direction that it must be, and they become accountable for that, and they provide us with a report based on the direction that I've given. Thank you very much.
In that regard, we can, Honorable Commissioner, boast to say, as a department, we are always in the center of challenges that children are facing in the country, especially in the hands of police, because we have a constitutional responsibility to make sure that children are not exposed into situations that are illegal, but that are devastating to them as children, even during, especially during festive season, because these people are taking advantage of that time. So our officials are forever alert to make sure that when that situation arises, they are in the loop and they are able to assist, because police sometimes get overwhelmed by this and they rely on us. And they now know that they must talk closer to us using the structures that exist in order for us to rescue children and process them accordingly, whether they are from our country or they are from other countries in the SADC. Thank you very much, Honorable Chair.
Honorable Minister, I'd like to then springboard off of that answer in particular, because at least from the presentation that we received, we get the idea that between NAT joints and Prov joints, the department is aware of the fact that there's an illicit mining committee as well that you now sit on beyond just being ad hoc. So the reason I want to focus on Stilfontein in particular, and I think I'm also going to respectfully request the Northwest report that was submitted to you, is because we then have allegations of, or at least we understand that there were children underground. We have that confirmed now. There were allegations of SAPS reducing rations that would be going underground for people. Now, the reason I want to ask about this is because I note that on the judgment, the department was served with the application that originally asked the police to please allow for people to be able to send down provisions. So, and this was the minister cited as the fourth respondent in that matter. So I just want to understand, what role did the department then play in that particular litigation, noting that the issue at hand was that there was limitation of rations, crucial rations, water, food, and medication, down to people who were in the shafts that were now identified as children. What role did the department then play in that particular litigation? Also noting that on the 3rd of December, there was a contempt application brought, which was also successful because SAPS continued to block food and water from going down into the Stilfontein mine. So I just want to understand the role then, given the background that you've given us of the oversight, the strategic direction that you're meant to be giving SAPS in this particular issue. What role did you play? Did you file a notice to abide? Did you support the application? What role did the department play in that matter?
DG will give the detail, but we can safely say we're not part of that process.
Yeah, no, thanks very much. I think I'm aware what was happening in terms of that when there were issues of human rights, that despite what happened, illegality and others, people need to be fed, and those even children need to get food. But I think we didn't get involved in terms of that. I remember in one of the reports that we received, those are some of the issues that we have. We might have to look at what was the role, especially the Northwest participation from the Premier's office. We at the present, I can't say exactly national what was our role in support or against the findings. Thank you very much.
Just to add on that, in terms of the report that we received from Northwest, the role of the department is reflected when we were informed, when children were formally referred to us. That's where we started kicking in. Prior to that referral, the role of the department was not visible. So when you look at the report starts saying SAPS are the one that alerted us as soon as when those people that were on the ground resurfaced. SAPS then alerted us that there are children that have been found, but we are not sure because we don't have the documentation. We are handing them over to you. Can you facilitate with the Department of Health to make sure that you get the age determination and confirm that indeed these are your clients or not? And if they are found to be children, then you'll start rolling out the services. That's exactly what happened. So we're not involved prior, but we're involved as soon as children resurface, according to the report that we received from Northwest. Thank you.
So I want to keep talking about this particular issue in particular because I think in as much as we are speaking about children, which is absolutely correct, and I think they are paramount, which we know is Section 28 of the Constitution and the Children's Act, the department's role, though, is not only limited to children, it's also focused on social welfare, reducing poverty, and protecting vulnerable groups. So if we understand that there are, and at the stage now, an unidentified number of people trapped underground, you're being made aware that SAPS is limiting rations, right? And in as much as I hear that, you're saying that the Northwest report, there's a bundle on your table, and I believe it's bundle 2 of 3. If you go to page 699 of that bundle, so it should be the big blue one on top, right? 699. So then it should be that third one, apologies. Yeah, that's the correct file. Have you found the page?
Yeah,
699. All right.
699 is only the cover page 2222. Let me see.
Because I'm looking for a court order in particular. Yes, have you found it? All right. Please, can you just identify who on that particular court order the fourth respondent is?
Oh yes, working now. The fourth respondent is the Minister of Social Development. Yes.
So again, I think this is what we're trying to raise, is that the department is in effect being made aware of the fact that vulnerable people underground, trapped underground, were being rationed food, water, and medication, right? The department is made aware of that because you are served the first application, and that order comes out on the 1st of December 2024. So then after that, on the 3rd of December, there is a contempt application that was successful. The department is still cited in this application. So my concern is that if at the minister's level, who is the primary custodian who was served, these papers is unaware of the fact that there are children and other vulnerable people stuck underground not getting necessary life-saving humanitarian aid, it's a bit of a concern, because we can't just necessarily only rely on the Northwest report, because your department in particular, the national department, is cited, and it's cited because of its role to protect vulnerable and marginalized groups. So again, I'm going to try to ask, what role does the department then play in this matter? Do you abide? Do you oppose? Because again, the issue is very clear, and it's an undisputable issue. And if you read the judgment, the order is very clear what the order stipulates. So that's also an order that the department would have been served. So I want to go back again, noting the background that you've given us as the department and the role that you should be playing at NAT joints and PROV joints. What role did you play in this particular litigation, noting what the issue was that was actually being litigated before the court?
No, thanks very much. I think I see what you're saying about, but I think I haven't seen this order myself. It might be an oversight or something, which I think we might have to provide you with the written report on what we have done on this from the legal point of view, from the legal unit of the department. I'm seeing it for the first time. Even the minister is seeing for the first time.
So then just to confirm, nobody at the department at a senior level is made aware of a matter that cites the Minister of Social Development in her capacity as minister. So that is, I think, an area of grave concern, because if the role that you've already told us you should be playing at NAT joints and PROV joints and the illicit mining committee is true, then would you not at least concede that there is a failure on the department in this particular instance to fully discharge their duty?
Thank you very much, Honorable Chair. Whilst we don't want to make excuses that both of us were not in the office at the time, which is, it's a fact. However, there should be records that point to that direction. I must then say, ours was the matter of children's rights. At the time this matter was raised to us through NET joint. And hence we today are articulating the work that we did in that regard. We might have to go back, maybe, DG, and seek for the legal unit of the department and the handover report on what did they do in that regard. But we really want to say this is what we can report today on what we did, and we can then go back and send that report written on what then was done at the time by the department itself in 2024. This was brought to us during the time when children were identified by the process of police, and this is when we came in as the department only. Thank you very much.
Thank you, Minister. Look, I understand that, officials do change office and things sometimes get left hanging in the balance. My concern, though, is that this wasn't just one matter. This was something that drew public attention across the country. All right? So whilst I understand that, certain officials might not have been in office, it cannot be that the department is unaware of what was going on at Stilfontein, given how much media coverage it was receiving. There were statements being made by various ministers on the matter. So in as much as I hear you, I unfortunately don't think I can accept the department's response in this matter, at least in this regard on this matter, because this is a legal matter that also affected children, but not only children. And I think that's why I want to clarify this. I understand the department's role in how you've assisted the children, but it's not just children that the department is responsible to. It's also vulnerable communities, marginalized people, people facing poverty, i.e. the people who would have been stuck down that hole, unable to access food and water. So I think it is crucial that we then request that the department submit a detailed report around what it did, and in particular, as it became aware of the legal ramifications that now come with this, i.e. a court order and a court application that would have still been correctly served, I believe, on the department. So I would, like, commissioners would humbly request that we get that detailed report, not just about the role the Northwest played, but the entirety of the department, given that it was served as a department and the minister was served. Follow-up question now I'd like to ask is, now that you become aware that there are children involved, and again, actually, let me backtrack a little bit. When do you officially get involved in Stilfontein? At which stage does the department then send people to Stilfontein, whether it be the Northwest office? When does the department actively then set foot on Stilfontein to intervene or to assist?
It starts by that site being declared a crime scene, ne? And once police declare that site as a crime scene, then there's a protocol that is involved, activated by SAPS, to say you can't just go there because you'll tamper with evidence. So we are guided by them in terms of what is it. That is why we have these monthly meetings where then on a monthly basis they will then give report and say this is how far they are with the investigations, and various departments will give feedback. And for us, that's when the need will be, will be raised to say, this is where we are, or maybe the information so far it's indicating 1, 2, 3 would need your services as the Department of Social Development. Be ready with your probation officers. As soon as we are ready, then you must be ready to be able to provide those services. So we are not the first respondent. We are not because it's a crime scene. The police and all the law enforcement agencies are the first one on the scene. We are secondary because we depend on the police to say, to what extent can you come? How do you come in? We only come once those children have been apprehended and they have been, have been declared as people that they have committed some crime, even though there's still going to be a court process that they follow, but we wait for SAPS to give us a go-ahead in terms of those issues. It's different from a situation where, for instance, if it's not a crime situation, a person is vulnerable, he needs DST services, we then intervene straightly, we become the first respondent. But in this matter, it is the police who are the first respondent, is them who will call us and say, this is it. That's what even the report of Northwest confirmed to us, that we waited for the police to confirm to us that indeed there are children. We would want you to be ready with your services as a Department of Social Development. And as soon as the numbers were given to us, we started releasing our services. So we wait for SAPS. Thank you.
I'll accept and I absolutely agree that your department's not a first responder, and especially if we're dealing with the crime scene, it make no sense. So I completely accept that assertion. I'm interested then to say, once the report comes, because if you're having these monthly meetings and SAPS is reporting back to the department, one, SAPS would have at least had to have reported that they're being taken to court. And secondly, what does that particular December 2024 report then say post your engagements with SAPS? Because by now the litigation is through. There's 2 court orders already out. What role does the department then play once, December 2024, once that first report comes out? And I'll even take it a step further and say January 2025, because then these issues of limitation of resources cannot be a surprise to the department. So then what does the department do post Stilfontein? And what policy recommendations, and this is the second part of that question, what policy recommendations does the department then have in place to avoid another situation such as Stilfontein from happening again, given that there are a number of mines and UMGODI is a national operation? And so we can at least accept now that children are being trafficked, there will be children. What is the role of the department going forward? What policy plans have you put in place? Sorry, just to clarify, there were 3 questions I loaded in there. The first one was December, January reports, because it's important that you would have been made aware as the department what those monthly meetings that you're attending with the department is. Secondly, what was the role of the department once it receives those reports in putting together a policy plan going forward, noting that VALA is a national operation that is continuing, and by your own submissions, you are a part of that NAT joints and PROV joints that speaks to this issue?
Yeah, I think I will answer one of that questions in terms of the once we experienced the Stelfontein, which was the main areas where we get involved at a later stage. Then within the committee, we requested that one of the things that need to be done within these committees is for the police, immediately they hear something, they need to involve the whole committee members, including ourselves, so that we were able to identify those children. Second thing is that at NAT joints, there was a request that we, as a department, we need to be part and parcel. We attend NAT joints throughout. Sometimes it's every week you need to go there, even during the night, to be part of the NAT joints. We might have heard that we have established teams that are at the cross border most of the time, not only in mining but also whenever there is an incident of anyone who is illegal, has been a migrant who has been apprehended or reported. Social worker need to be part within the ISS, the International Social Work Services that we have. We have created that structure to make sure that we respond promptly in terms of that. And we also, within our PROV joints, we request that we need to get report much more promptly and ensure that we are able to get the report. You might have seen that in our presentation, one of the proposals that we are saying we need to have is to improve on the policies on the issues of prevention and awareness creation. Because it's not only sometimes to prevent it, is to make sure that communities are aware and they report those children that they will come across. So in terms of what we need to do and what we've done, that's what I can say for now. Thank you very much.
Thanks, Chair. Once again, as DTG alluded to the fact that the area is being declared a crime scene, and as the department, you are unable to come in. Like, it's not like in a disaster, like it will happen in Limpopo and Mpumalanga, as well as in Namtata. Because in there, our policy is very straightforward. We are the first in the line to go and respond on a disaster that has been declared, because us and our entities, we are expected to assist in that regard. This has been a new experience altogether, and our policies limit us to get closer there. It is only when the children were identified, then because we have a clear policy on what do we do and what is expected of us when that situation arises. And we did exactly that to implement our mandate. The DDG then said in her report, there's a quest in reviewing of policies with now the new experiences, that as you are articulating, Advocate Commissioner, that this has been reported and this has been happening. And unfortunately, we've just as a country got to realize this sometime at the time it is being recorded. And our policies, even though we sit in all these structures, they limit us to get involved before the responsible people with this substance in this case can give us a direction to exactly what needs to be done. I hear you that the issues of people not being able to get what is basic food, water, and so on is a concerning matter. Yes, we all agree. However, we're unable to come closer there because our policies limit us in that regard. We should then say we might have learned out of this process and make sure that now we come closer to the net joint to say, what do we do then in a situation where there are people that unfortunately are being found to be in need of food and water, but because of your operations, they are unable to get that, because we don't want to create an impression that the police, we did not know what the police were doing. We knew, and we were really looking forward for that operation to be concluded, because it was dangerous in many ways. However, we needed to wait from them to advise. So now that we got to realize that there are issues that for us are closer to a disaster when you look at it, we should maybe come closer and look at our policies to say, how best can we then assist in that regard if the need arises at any given time. Thank you very much.
If I may add, Commissioner. Yes, you asked the question post the time, what did we do as a department? On the 31st of October, we had our last cross-border management meeting with Mozambique. They're part of the meeting. We can submit the minutes of that meeting, where we spoke about this, and we said we need to strengthen a safe migration process for children. So the matter was discussed with the Mozambique team at that meeting on the 31st. And we are going to still meet with them further to come up with or sort of to unpack the strengthening, because we spoke and agreed that we need to strengthen the safe migration, but we didn't come up with the how part. So as we will be continuing, because we've got quarterly meeting, that was our last quarter meeting. So we are going to have not last quarter, it was the third quarter meeting in October. So for this year now until March is going to be the last meeting for this financial year. So we are going to further discuss that strengthening and say how the strengthening should look like, and get contributions from other countries. That's what we are planning to do, and that's what we did post our intervention, Commissioner. Thank you.
I'm going to ask my last two questions now, but I would just like to highlight to the commissioners my concern around the fact that Stilfontein took place over a year ago, and if I'm not mistaken, 2024. We're in 2026, and the department's answers concern me because they only speak to strengthening border controls, which is absolutely correct. It makes all the amount of sense, but also just awareness to stop trafficking. The last two questions I think are critical now. How does DSD ensure compliance with constitutional and legislative protections during standard raids? So you know that VALA is happening. You're part of those particular committees. What guidelines has the DSD now put in place to ensure that there is a constitutional legislative framework that the police are aware that they need to exist in to not violate any rights of potential children or other people who've potentially been trafficked and are going through a difficult time while stuck underground? That's the first question. And the last question is, what monitoring and evaluation framework does the department have, or what complaint redress mechanisms does the department have for harms suffered during these operations? Because the department is aware that these operations are happening. So there's got to be a point where someone can say this is where there's been a constitutional violation by SAPS in conducting these raids. What role would the department then play in these particular issues?
All right, thank you, Commissioner. Remember the Department of Social Development, we said we draw our mandate from the Child Justice Act, that talks about managing children that are in conflict with the law. And it is very specific. It outlines exactly what to do, one process to the other. So as far as we are concerned, as soon as the police have apprehended the child, then the child is immediately handed over to us. And then that child, we deal with the child in terms of the Child Justice Act. So police are not violating the rights of the children, because once they found the children on the scene, what they do, they don't even charge them. All that they do, they apprehend them, and then hand them over to our probation officers. And then our probation officers, in terms of the Child Justice Act, they start the inquiry. One, by doing the assessment, like we said earlier on. And then that assessment report is the one that would guide the whole justice system in terms of how should they manage, how should they deal with this case, whether they need to divert the case or whether they need to further charge the child if they, according to the legislation or the offenses, you know, where does it falls into. So as far as we are concerned, we are not aware if police are violating the rights of the children, because for us, we get involved as soon as they hand the children over to us, since they know that the Child Justice Act is very clear that no child must be found in police station. So as soon as a child is arrested, according to the Child Justice Act, we are given 48 hours to come up with an assessment report that will guide where is that child going to be, you know, where is the child going to be, you know, located, and what kind of services do we need to play, and so on and so on. So as far as we are concerned, the Act has really assisted us to make sure that all the role players, they know their role very well, they do what they're supposed to do, and making sure that they do not violate the rights of the children. So where we are standing is that as a department, we are able to provide that support immediately within 48 hours as prescribed by the Act. Thank you.
So I'm just going to quickly jump in because there's a slight contradiction that you've just made. You said that the children weren't charged, but on slide number 6 of your presentation, it states the children were charged with illicit mining and possession of gold and consequently arrested by the police and taken through the child justice process. But I just wanted to make sure that you understood that that's a bit of a contradiction given what you've just said and what your submission state. But I would be interested to quickly just find out, would the department then be willing to concede that they have neglected their role as it relates to vulnerable people by only focusing on children in this particular instance?
Commissioner, no. Remember, I think we must contextualize the role that the department play. I will just give an example of something that other departments do. If you are not sick, you don't go to a clinic, right? And in instances in social development, remember we are the social services, we come after the effect in most instances. I think I heard you talking about the guideline that we give to the police. We do not direct police how they need to do their policing. That's why we will make sure that if anything happens to children, let us be involved. Let us get the report. We receive information after the effect. And this is what social development is trying to say. Maybe what we should do, we must have prevention so that those people are not found to be on the wrong side of the law. So you could see even in issue of where the children dies, the tavern issues and others. We get the after effect of what has happened, then we act according to our mandate. And that's why even in Stelfontein, the referral came a little bit later. But even after it has come, we jumped to and do what we're supposed to do, make sure that they are safe and they are repatriated as we describe what we're supposed to do. So I think there's that issue where, or in the country the same, that I think the social services part of it happens, is an after effect of things that happens and everything, then then you jump to react, like what happens in disaster, what happens in everything. And even with the police, they will go and do even wrong things, but in the name of trying to, it's a crime scene, and they do, sometimes they kill, you have seen a lot of things, but we then come in to make sure that we quell the situation, we come in to provide the social services. You must also remember that what we provide, nobody does it. Psychosocial support is something that we do. It's our mandate. welfare services, social services that we do. If our children, we put them into the safe place and make sure that they receive the best, all the basic needs that they have. But the issue that I'm raising is that we come in when things has happened, and that's the nature of how social development is. We don't like it. It's the nature of what it's supposed to be. Thanks very much.
DG, please avoid this lengthy answer that, unfortunately, to a certain extent, it's like you've digressed. You're no longer talking about what was asked of you. The question was really into that you have failed. You're talking about children. But as a department, you've got a responsibility to look at social security of our marginalized group, of the most vulnerable members of the community. And with regard to Stelfontein, those that were underground, they are regarded as the most marginalized because issues that found them underground are issues of bread and butter. Now, this is the mandate of the department, and you do not seem to locate yourself in those issues. You are merely saying we take a back seat and we wait for SAPS to call on us, and then we act because only of children. Now, that's the part that we wanted you to articulate. Are you able to answer just that question without referring to these other issues? Your mandate that you are seized with, which is explicit in terms of the Constitution, Section 12 is clear. Everyone has got the right to social security, which is the mandate of the department.
Thank you very much, Honorable Commissioner. Indeed, I will say no. I will get to understand when the commissioners are advising whether there's a need for us to review our mandate and our policy, because at the moment, that's what is in our purview. We could not get closer because that was determined as a crime scene. So we could not come closer until there's an indication from SAPS through the committees that are existing. I hear you clearly when you say, don't you think that policy of yours is limiting your mandate and the implementation of the Constitution in its totality, which is something that we can take home to say, now that the country is now overwhelmed by this kind of a situation of illegal mining, now it talks directly to all the issues that the social development is supposed to do, regardless of the situation. Because the situation, the crime scene, we don't come closer. So I can take home an advice and counseling that says, don't you think it's time for you to review and look closer into your mandate to get to understand where the country is and find a way to extend and it be budgeted for in the process? Because it has got its own limitation. We would want to do everything, but you'll be limited by the budget sometimes because it's not in your mandate. Whilst we understand, as the Advocate Commissioner is articulating, as the chair of the panel is articulating, that it does not stop the fact that you are a department responsible in looking after the vulnerable. However you want to look at it, those who are underground, the circumstances that took them there are the issues that makes people to receive grants, for an example, those who are outside those homes. So we think we can take home that maybe the time of reviewing our policy has just come, and we must start to look at that and start to sell and be able to say, how do we then extend, of course, going through all other processes that are known and accepted when you review a policy. Thank you very much, Honorable Chair.
My last request, I think, would then be to maybe just request in terms of the report that we're going to be getting from DSD, can it also just consider the fact that now we've made this assertion too that human rights violations took place at Stilfontein. They did. And those human rights violations were done against children and vulnerable people. So based on this information that we are now submitting to you, and that you should be aware of as a department based on the fact that you were served with these court papers, we would also like to understand a detailed response to then what DSD's response is to SAPS's tactics of food limitation, noting that we are dealing with vulnerable people and potentially children. So that's what I would like to then request that the department also canvasses, is a consideration of the tactics SAPS has used in Stilfontein and relating to food and water rationing in your report and your consideration on those tactics, because it's important for us to understand in terms of your departmental engagements, what role are you playing to advise each other about the constitutional rights of parties involved in whatever situation. With that, I thank you and I hand over to my colleague.
Colleagues, it is now 10:55. May I request that we take a comfort break for 10 minutes? And please do find food in the other room. And then it can be a working comfort break because it's only 10 minutes. So grab what you can and come back into the room so that we can be able to proceed. It is just to ensure that we observe the right to food, but also, of ensuring that no one is pressed in the process. Thank you.
Yes, they're all still binding on my questions.
Thank you so much. DTG may also confirm that the affirmation you took in the morning still binding on your conscience.
It is the oath, Chair. It's still binding. Thank you.
Thank you so much. Mr. Modise, over to you.
Thank you, Commissioner. My colleague has really covered quite substantial, important questions that I feel repeating them will be unjust and wasting your time, Minister. But I just want to go back to the fact that your attention was drawn to two court orders that were issued against the respondents, which were given by courts. I want to request you to just give me your take. What is the view of the Department of Social Development regarding the fact that the Constitution guarantees the right to dignity, access to food, and to treat people in a humane way? What is the view of the department as far as the conduct of South African police services limiting or rationing food that was intended to go down to miners who were trapped underground? Thank you.
Is it coming to me? Okay. Thank you very much, Honorable Chairperson of the panel and the Commissioner raising the question. Under normal circumstances, that will not be acceptable. However, I've never been closer to the detail of what really transpired and why police got into that situation. Hence, we said for us, on behalf of the department, it was a crime scene that we could not come closer and make any conclusion on the matter. Thank you very much.
Perhaps another question to DDG. Upon being invited by SAPS that there are possible, I think 32 miners that were apprehended in line with how you reported. Where were these miners kept after apprehension?
They were they alerted us and handed them over to us. We checked the bed capacity or availability of the secure care centers in Northwest. At that time, as I've said earlier on when I was doing the presentation, that all our secure care centers were full. However, as soon as we realized that we have this problem and we need to solve it before the end of the day, then Northwest was able to, immediately open a temporary care facility to make sure that children do not sleep in police station, but they are kept in a temporary place of safety in terms of the Children's Act as well as the Child Justice Act. So they were kept in a temporary place of safety that was immediately established to accommodate them.
We want to capture this correctly in our report. Do we understand you to be saying, DDG, that these children were not kept at the police station? You did not find them at the police station cells or in any other such places, but as soon as you were involved, these children were not at the police station cells, they were somewhere else at the child care center, because that is what we really want to really establish here. Thank you.
Maybe let me further provide this background. All the over 1,000 police stations in the country are served by the probation officers. Ne? We have probation officers that are in those police stations. They may not be physically there 24 hours, but they are linked in those police stations. So as soon as a crime is reported, the station commander or the management of that police station, they would know who is responsible from social development, who is attached to that police station. They'll then immediately call they will or make us aware through that probation officer that probation officer, we've apprehended so many children. Can you please start working? Because remember, the act is very clear that within 48 hours, DSD must have intervene, ensure that they do the assessment and provide or furnish the court with the assessment report. So that is why it was important that we make sure that we deploy the probation officers in all the police stations so that there's no, we save on time and not necessarily dealing with unknown officials who are assigned with this work. They must be known and the police know them. So because we already have that system in place that assists us to meet the deadline here 48 hours, that is why even in this case, as soon as the police apprehended them through that system of the probation officers, we were alerted and we were able to dispatch help. And that's why we're even able to make sure that we at least reopen a temporary facility to make sure that we comply and children, they don't find themselves in police stations or police cells. Thank you.
Thank you. What I also want to establish, because this is very important, as soon as your probation officers were at police stations, remember in your earlier presentation you said these children were charged. And I take it that once they are charged, they have a right to appear before court and to be assessed as you correctly assess them. Were they provided with attorneys to assist them, to represent them in a form of legal aid? Now that charges for illicit possession of diamonds and gold were presented to them, were they being afforded legal representation whilst your probation officers were also there, just to guarantee their rights? Thank you.
Yeah, let me clarify further, even though the issue of charging is the mandate of the NPA, it's not us who does that, the NPA. Because of the lack of documentation, they didn't know, the police at that time, whether these are children or not. So they therefore charged them. And then they alerted us that when we look at it, at the face value, when we look at it, it could be children, but we don't have evidence, we are not sure, because there's no documentation. So kick in and do your assessment, facilitate with the Department of Health to do the age determination so that we are able to know whether these are children or not. And as soon as the age determination report was sent to them, they then convert those charges and they change the charge into the children's court inquiry. It became the children's court inquiry. It was no longer a criminal matter. Hence, then we were able to begin the process of dealing with the council and make sure that we start the repatriation process. So it was converted as soon as the age determination report was submitted by the Department of Health.
After how long, DDG, was the charge converted? Because we need to be sure as to whether at that stage and where were they kept. I understand you said they were you still needed to determine their age, but we want to really make a determination as to after how long was the charges then converted to being removed from being a criminal, but to be related to this other opportunity that gave you the right to assess them in that process.
I can provide it. I don't have it now, the kind of the data to say when and whatever, but what is important, Commissioner, that I can report here is that the very same day, children never slept at the police station, even though they were charged. They never slept at the police station. We do have the secure care center. Remember, the secure care centers are done in such a way that a child would not be able to abscond if a child is sentenced or a child is, located to a secure care center. They are highly secured and all of that. So as long as court knows that that child would not abscond, they will then release them to us. So I don't have those timelines, but all I know is that they were not at the police station, and we were able to provide that secure environment until their matters are further clarified.
I am interested in your assessment that you conducted. You said it's an IDP and it's a developmental plan. Would I be correct, DDG, to think that perhaps, but you'll advise the Commission whether your findings could have really been, amongst others, that these children were trafficked against their will, and they were used to be minors, you know, which is contrary to the constitution of this country.
I'm a bit reluctant because, Commissioner, because the IDP also has confidential issues that we picked up when we are assessing a child. It talks about the family background. It talks about, you know, who you are, what are home circumstances. It exposes quite a lot of vulnerability that the client or the child will be presenting at that time. But what I can safely say is that from the reports that we have read, a summary reports that were summarizing what transpired when our officials were doing the assessment, was that some of these activities are highly organized activities. They're highly organized. That is why in our background, I think where DG was trying to give the situational analysis of this issue, we mentioned that some of the children that are illegally participating in these things are part of the families are involved. They are very much aware of what is happening, and they are using the children, even though children may not understand the seriousness of this thing, but they are used by adults. Those are some of the issues that emerged, that not that everyone was coerced, but there was some agreement. There's some kind of organized crime that is happening that includes children without them maybe to fully appreciate the consequences of those actions.
I think this information, DDG, is very important, you know, for the Commission to understand the complexity, you know, of these, you know, issues that the country is facing. And we appreciate, you know, the fact that, you know, despite confidentiality of some of these issues, you managed to give us at least a response that can give the Commission something to work with. Just in conclusion, what could be the problem? And I know it's not your mandate, but we just want to hear, also, Minister, from your side, what could be the challenge that we, you know, from your side as a department, we find, you know, our country been flooded by so many children, whether they came willingly or not, and whether they are trafficked, you know, or they knew what they were doing through, you know, family facilitated processes. In your own observation as a department, I think that information will be very helpful to the Commission, because we want you to speak, you know, as an outsider, you know, dealing with border management, I understand that. But we want to gather your thoughts and really, what is the department's view on this issue? Thank you.
Thank you very much, Commissioner. As we said earlier on, in the center of all this, as we are seated as the department, the issues of laws that determines immigration. We were, if we may, myself and DG were in the cabinet Lekutla, where this matter was raised sharply, that there's a need for the country to look closer into our immigration laws and find a way on how we can tighten those that are working, but also identify gaps where we've identified, because as we engage with the countries around us, as we have indicated, we pick up that some of those countries, rightly or wrongly, have different perceptions on how they must be treated by South Africa. Some are historical reasons on where we are coming from as a country, and that creates sometimes expectations that sometimes are not legally correct insofar as South African laws are concerned. But sometimes they take advantage of the fact that for the longest time, the border management has not been properly funded and has not been able to do its work effectively. And now that the cabinet has taken this matter up to look closer in it, we guess in the next 6 months we'll be able to come up with great progress and ideas and the strengthening of our laws that can make sure that this problem that we are facing as a country is in fact mitigated. We might not be able to solve it like tomorrow, but if we can start in earnest to say these are the challenges, these are the gaps, let everybody be ushered in the right direction for us to be able to deal with this. Because yes, in the center, it's crime. It's crime because, as we were insisted to say, these areas were declared crime scenes. And as such, when it's a crime scene, you can't come closer until police will indicate. So this is what, as the department, we can say to say, we are happy that the cabinet has taken up the issue of immigration laws that sometimes are not very clear to our sister countries and sometimes are being taken for granted. And hence there's a need to strengthen them, and where there are gaps, we can make sure that those gaps are filled. It is a problem, indeed, and the Stilfontein and Mpumalanga brought that to ourselves in a manner that is and is still unprecedented. So this is what we can say as the department to say it needs to be looked at, it needs to be resolved. We need to bring a little bit of agility because it creates more problems than what we can see at a distance, as you have articulated that some people got there without knowing. However, they remain criminals in the face of the police until they are proven otherwise, as the process the DDG was articulating. Thank you very much, Commissioner.
Thank you, Commissioner. That was my last question. Then I'll hand over to you, Commissioner.
I'm so distracted by the movement. Apologies for that. Thank you so much, Mr. Modise. I'm now going to hand over to Commissioner Makwasha.
Thank you so much, Chair. I just want to thank the Minister for appearing in person before us, as well as her respective officials. I think for me, what is quite concerning is that in the midst of this, in the midst of dehumanifying the people that were victims in terms of Stilfontein, we did not speak about the children. I don't recall media outcry that 32 children from Mozambique were found underground. Now, in the presentation, you do speak about your engagements with your counterparts in Mozambique, but in terms of the fact that we are noting that it's an increasing trend. We're seeing children and we're finding children in, of course, Mpumalanga and as well as Northwest. Is there a conversation with our counterparts in SADC to ensure that, one, children are protected, but also that there is a rapid response around these issues? Is that conversation happening? That's my first question.
Thank you very much, Commissioner. Indeed, you are correct to say these matters needs the necessary attention with the necessary speed. And we can safely say, indeed, children were found, and hence our intervention. Pity that the media houses could not pick that up, which was a fact. Hence the process that we followed to the latter. In interaction with our sister countries, according to the protocol and all other relationship that we have, our last meeting with Mozambique in particular was around the 5th of December 2025. This is how serious we take this matter. With Lesotho, the biannual was around November. The biannuals are meetings between ourselves and these countries that are led by the president himself, where he leads the entire cabinet to go and interact with these countries, its leadership, and panels deals with these matters, so that by the time the both presidents sit, you would have been able to sit and look closer into what are the challenges and bring recommendations on what needs to be done. I want to confirm that, Honorable Chair and the Commissioner, that as South Africa, we are very hard at work in resolving this matter. We are dealing with countries that have got their own sovereignty. And we are, I can safely say, seated here, we are nudging them towards a situation where we can resolve the matter. I must also, in conclusion, indicate that as the country, we are quite ahead in the implementation of the laws that are friendly to our children. From our constitution and all other pieces of legislation, we are ahead. And now, us being ahead, sometimes we speak above everybody else, which now we need to come closer and talk to them in making sure that they understand where we are, they understand where we would want to go, and they become part and parcel of that, which I can say there's no resistance. There's no resistance. The only thing that we can really pray is the pace of resolving these matters. But these matters are forever on the table in making sure that we resolve them between ourselves and other countries. We were experiencing schools opening was also a challenge between ourselves and Lesotho. Again, we had to be there, our officials had to be there in making sure that the right procedures are followed. You can imagine with Lesotho, they are in the belly of the Republic of South Africa. Sometimes they think there's no reason for them to follow the law, because they are in the belly, they cannot get anywhere without getting to South Africa first. And consistently, we have to explain to them that there is no other way except for the legal way and the constitutional way. So I want to assure the panel that we are very hard at work in making sure that these matters are being resolved between ourselves and the sister countries. But as the sister departments, we have picked up that there's a need of looking at our policies through, and when the need arises, we can be able to review them in respect of all other sister departments, because we cannot undermine each one's responsibility, because everyone is moving according to his or her mandate. We in fact must celebrate the fact that we were brought into these structures just a year ago, and which for the longest time we were not part of them. So this, for me, determines that now that we are there, we are able to resolve. I don't want to imagine if we were not part of that structure at all, how would we know that there were children that were found in Stilfontein in particular. So I want to assure the Commission that we are in the learning, but we are very hard at work in making sure that we resolve these matters. Thank you very much.
Thank you so much, Minister, for that. Now, we talk about children. Can you perhaps give those who are listening the ages of those children, if you do have the youngest and the oldest? Because when we say below the age of 18, we don't have an understanding of the ages of the children involved.
Commissioner, yeah, we don't have them now, we can provide that information to you in, chronologically. The 32 and the 16 from Mpumalanga. We'll be able to provide that to the Commission. Thank you very much.
Thank you. In terms of your analysis of the policies, could you perhaps, in terms of how Operation VALA was implemented, do you think that it's time for policy recommendations from the department to ensure that it aligns with, one, your constitutional mandate in ensuring that the children that are found there, whether they are victims or alternatively participating in illicit mining, are protected?
Thank you very much, Honorable Chairperson of the panel and Honorable Commissioner. In line with the laws that exist, informed by the Constitution, but also the fact that we are working with all other sister departments, we are saying there's a need maybe to look at our existing mandate, but should not undermine at any given time the roles and the responsibility of other departments. All this should be done within the laws that exist and within the policies that directs all of us as individual departments, but as government as a whole. You, the chairperson, said earlier on, these people, some of them might be there not because they were in a situation of wanting to be there. Therefore, as long as you have not been able to resolve that matter, then you are undermining your constitutional responsibility. We are saying, as long as we are relying to the SAPS, that must determine and do its work for us to understand and be able to come closer and be part of this. Therefore, there's a need for us to relook at all this in order for us to be relevant to the Constitution of the Republic, which binds every policy in the country, and that leads the government. Thank you very much.
My last question to you, Minister. You actually said, you spoke about budget allocation. Now, given the trend analysis that you said there's a growing increase of this issue of children participating in illegal mining, is there a budget allocation to address this issue, or alternatively there isn't at this particular moment?
I must assure the Commission that we are funded insofar as this mandate is concerned. Our issue is the mandate is expanding given the challenges that we are going through as a country. It was the first time that we were exposed on this kind of a situation, both in Northwest and Mpumalanga. And already we are able to say it now talking, that all is talking to the extension of our mandate. Therefore, it will automatically needs more money. So when we do that review, we'll have to engage in a process that is known to say this is what we think should be done and interact with the relevant departments, and in this case it will be National Treasury, to say how best can we assist us in the implementation of this, of course informed by the Constitution and our case DG extending the mandate that we have at the present moment. Therefore, we'll definitely need more money. So that process, when we've agreed, will have to unfold, but within the existing legislative framework, working as a department, but together with our sister departments. Thank you very much.
Thank you, Minister. I'm handing over to you, Chair. Thank you.
Thank you so much, Commissioner Makwasha. Mr. Dladla, over to you.
Thank you, Commissioner. Good afternoon, Minister and the whole team. For the record, when did you assume office?
I assume office after the 29th of June, June 2024, after the South African general elections. Thank you.
Thank you, Minister. Commissioner, I would like to bring the inquiry into the fact that the minister was sitting when Stilfontein happened. as she did allude in the beginning, that they had not been in or somewhere around there. So, taking into consideration that you were in office, Minister, did you receive any updates at cabinet level around Stilfontein, because it was a massive, it received massive media coverage?
The cabinet works through its committees, its subcommittees. And as DDG indicated, the fact that there are different committees that deal with these matters, not only this one. And for a year now, over a year, we are sitting in the very strategic committee that deals with this matter. So the cabinet, through its subcommittees, did receive reports on the matter, and it has been able to advise. Thank you.
Thank you, Minister. Amongst the matters that you were updated about, as you did say in your presentation, that Stilfontein as well as Barberton hit your department in an unprecedented manner. Which issues did really affect or touch your department?
Honorable Chairperson, what touched our department, as we have just alluded to, is issue of children, because we are the only department that has got a constitutional responsibility to deal with issues that affect children directly. Of course, this commission has just given us another angle of the fact that even people who are languishing into those holes, they still have the rights. Therefore, do look at that. But when we receive all this, our target were children, because it is our responsibility and within our mandate. Thank you.
Thank you, Minister. You keeps coming that Stilfontein was a crime scene, therefore protocol did not give you an opportunity to go there. And in your presentations again, it did come out that you sit in the net joints and also the prof joints. What is the process? Are you informed at net joint level before it's declared a crime scene, or it's declared a crime scene, then you are informed at net joint level? What is the process?
Individual departments are always expected to implement its mandate without hesitation. And this was the case with SAPS. You come and report on the progress that you are making in the implementation of your mandate and challenges thereof. And in this case, this is what we got, that the SAPS were engaging into this, and this is the report that we're getting from those subcommittees. Thank you.
Just my last one, Minister. Are you exposed as to how many lives were lost in Stilfontein?
I cannot give you the exact number seated here. Thank you, Commissioner.
Thank you, Commissioner. Thank you, Minister.
Thank you so much, Minister. I'm just going to go back to the question that I had to articulate. Section 12 is very clear on social security. Whilst you have been concentrating more on children, but the community of Stilfontein was equally affected by Zamazamas. Did the department then do which that they are mandated to do, which is to provide social security for the marginalized? Did you do an impact assessment on those communities of Stilfontein Or are we again going to come up with an excuse like we did to say, by the way, SAPS must call us in. If SAPS does not call us in, then we take a back seat.
Thank you, Honorable Commissioner. SAPS must call us in a crime scene. Communities are being serviced by us, working closely with our entities. And this is when we provide with grants, those who eligible, they get from 350, 370, which is a SRT grant, the children's grant, the grant for the aged people and people with disability. This is what is done by DSD both in provinces and working closely with the SASSA in this case, because it's the entity that is responsible to process people's grants. So that's what we are doing on a daily basis to these South African people in provision of those grants to mitigate the poverty that they are going through. Thank you, Chair.
Maybe just a short answer to this question. Once you would know that there are children involved in illicit mining, you would not get involved because you wait for SAPS, because it is a crime scene. Just a short answer to that question.
It's police who would inform us about people whom they've found into that process and make us to determine whether they are children or not, and us working with the Department of Health. There is no other way, Honorable Commissioner. Thank you.
I'm going to go back to the question again. I'm saying, once you would know, there's reports that are making the rounds, that there are children that are underground. As a minister responsible for children, or social security, do you still take a back seat and say, I am waiting for SAPS?
Honorable Chair, it is SAP's responsibility to rescue those people in the first place and determine whether they are human beings or not. And it's only in that process when they will suspect that they are children, then they bring us on board. Other than that, you are unable to give any kind of assistance until that time, unfortunately. Thank you.
So we have got a department that is earmarked with a mandate to protect children, the most marginalized, and also to provide social security. But looks like your policies are such that your hands are tied. You only have to wait until you are called in. Other than that, as a department, you sit and you wait.
Because we serve in these subcommittees, I'm not sure if we can really say we sit and wait, because we get their briefing whenever that time comes. So we don't sit, but we get the information, because we sit. Before the Stilfontein, we were sitting and we were still sitting. So we get that. But unfortunately, this time, we cannot do anything because the Stilfontein and what happened in Mpumalanga, it has been determined to be a crime scene. And we cannot come closer until informed by police. Therefore, have to do our responsibility. However, as we said earlier on, there might be a need for us to look at our policy to say whether, with the experience of Stilfontein as well as Mpumalanga, whether there's a need for us to review our policy to make them relevant with that experience that the country for the first time went through. Thank you.
Minister, when did you realize that there might be a need for you to really look into your policies? Was this as a result of the questions that have been posed to you the entire morning of this engagement?
we wouldn't want to lie, Commissioner. This came more than once into our attention. However, we're tied to say there's a need for us to do something now because the steel fontaine is taking place now. Now that you've asked us direct questions to put us into that situation, we got to agree to say you have made it very clear now that there's a need for the reviewal of those policies. Thank you.
Minister, according to your report, the last 5 children that were left in the custody of South Africa, they were sent in April. From that month in April until now, it is only now that you realize that there is a need to re-look into these policies.
The time that we took in between of the identification of the kids and taking them back is a process that is beyond us. It's not something that we can agree to say, oh, these are Mozambicans, let them go. We need to interact with the Consul General of Mozambique and take each other step by step to reach that stage to say then they can now be taken back home. It doesn't matter how you would want to speed it up, but you still have to follow each and every legislative framework so that you can be able to reach that. Hence, they are not being allowed to be in the prison or in the cells. They must be kept in our own institutions because sometimes the time takes longer, as it is the case now, than anticipated. However, it's not something that you can do alone. You should have to follow all the legislative framework that informs that process. Thank you, Chair.
Minister, the processes we understood that you have alluded to, but that's not the question. The question is around the fact that it was in April when you had the last bunch of children sent to their respective country. But it looks like even then you did not think that it was imperative upon you as the accounting officer of this department to start looking at how do you ensure that these policies are in line with the spirit of our Constitution, the spirit of our Constitution that looks at human dignity at Section 10, the spirit of our Constitution which says that you need to do that which is in the best interest of the children at Section 28. So did it really have to take probing by the commission that you would realize the mandate that you are empowered to attend to? Did it have to wait for a date such as this, which is the 3rd of February, 2026, Minister?
As I said earlier, Honorable Commissioner, that it has been something that we are thinking about, but it has never been interrogated like it was the case today. Today you have brought it home to say there's now a need for us to speedily look at our policies and make sure that we review them for them to be relevant with the Stilfontein experience. Thank you.
Thank you, Minister. I'll just step off that question. And the Minister will then want you to take note of the different reports that would have to be submitted. The first one will be the report of Northwest, issues around your engagement with the Premier's office that you have alluded to. I believe there should be a report that can then assist us in making findings. The second report, Minister, relates around, especially now that Mr. Lala has put it on record that you were in office as at the time when Stilfontein happened. The issues around that report are going to be the role played by the department insofar as dealing with the papers that were received in relation to the applications, as to what is it the department did insofar as those papers are concerned. I remember that another question was posed to you to say, maybe did you file a notice to abide? What is it that you did as a department? If you can speak to that, but over and above that, go further and deal with the court orders. I would imagine, Minister, that as soon as you get papers, one is always concerned of what are the prayers that you are likely to be faced with as a department. And those are the issues that should concern you, and then you should be able to unpack those prayers so that you're not caught with a situation that is untenable. So if you can speak to that, just explain yourself why you did not deal with them at the time. If you didn't, if you did, what is it that you have done insofar as ensuring that is attended to? The third one, Minister, is in the minutes of the meeting that happened in December with the border management, wherein you have said, as a department, and this is what you've been alluded to all the time. I do appreciate that you've said that you want to strengthen the policies of the department. But I just think that it's like you're taken aback, and that shouldn't have been the case. If you can speak to that and have those minutes submitted, which will then show us what was actually done. Also, the question was asked of the DDG of the guidelines that you have as a department to ensure that the children would never again find themselves in this situation. If you do have the guidelines, if there's something that you have already thought of, if that can be provided, it will assist us also in us making our findings, but also the recommendations that we are likely to come up with as the Commission. The other report is on tactics that were used by SAPS in rationing food. If that can also just be unpacked, one would expect that whilst it was unfolding, you would have taken it upon yourself to look at Section 27, that is clear, on the right to food, and you would have been able to then articulate the section vis-a-vis what was happening on the ground. So if you are able to go into that, zoom into that, also look at Section 10, which talks about dignity. Minister, I think your mandate is very broad. You've got a mandate where you need to look into the dignity of our people. We can't have a situation where you can't even tell us what has become of people in Stelfontein. There are a number of stories that came out of Stelfontein. Some of the people in Stelfontein, we are told they were involved in this Zama issues. And I've already said to you, the people that depend on your department are issues of bread and butter. Just food on that table. So if you can look into that, Minister, and also be able to locate the department in that discussion and give us that report. The next one, Minister, is on the report that you must provide was the assessments and the issues around the fact that you made sure that the children did not sleep the next day. If you can talk to the timelines, because it did not come out clear from what DDG was saying. So at this stage, we are not sure whether these children did not sleep for 48 hours in that police station. They only left for 24 hours, if that can be spoken to. But over and above that, what assessments were done, and the so-called child court that she alluded to. that was the diversion process, I suppose, because she was saying that whilst they would have been charged, but that process was changed into how they are supposed to be dealt with in terms of the Child Justice Act. The other report that I'm picking up, and colleagues, if you do have others, please make me aware. The last report that I'm picking up here, Minister, it is just to inform us of the ages of the children that were arrested, so that we can look at the challenges around that issue. Minister, there's something so profound that you said. You said this department is well budgeted for. If you can speak to that as well, just to showcase if indeed this budget looks into issues of illicit mining as well, and children that are likely to find themselves in that space. What does that look like? You have not really confirmed, Minister, in the question that I asked you about the impact assessment, if it was done for Stilfontein. I'm not sure if it does exist, but one would think that it's supposed to be there. But in case it is not, please speak to that as to why was it not done? Why do you not locate yourself in those communities that are affected by illegal mining? Why is your mandate not showing itself even in that space? Because the issue is not about just the policies, Minister. It's about how everyone else involved gets affected by this. And it looks like my time is up, but before that, there is another report that Minister, it probably might be located in some of the reports that I've alluded to, but this is on socio-economic factors that contributed to the children being involved in illegal mining. The trafficking of the children for illegal mining purposes. I think this could also be informed by some of the committees that you have alluded to that you have with SADC region, where these are discussed, and maybe you'll be able to give us more insights into this, that your counterparts in their soliciting information as to why children find themselves having to cross the border illegally and come and get themselves involved in zamazamas. If you can look at that, colleagues, let me maybe start with you. Mr. Mrise, from your side, is there anything?
Nothing from my side, Commissioner. Thank you so much.
From yourself, Advocate Ngato?
Nothing from myself. Thank you, Commissioner.
Anything you have picked up, Mr. Nkonde? Mr. Stebe? Mr. Dladla?
I'm covered, Commissioner.
Thank you so much. Commissioner Makwasha?
I'm covered, Chair.
Thank you so much, Minister. We've come to the end of our engagement with your office. Once more, we want to take this opportunity to appreciate the fact that you did come. As I said yesterday, it was very difficult engaging the Minister of Subs online. Thank you so much. To the extent of your ability, I suppose we've tried to deal with the questions that were posed. And I do know that sometimes we give you questions and you might not foresee that there would be further questions that will be asked of you, even from the ones that would have been given to you. And that is why we usually give you time to then make further submissions in order for them to be encapsulated into our report. We thank you so much with the entire office that was here this morning. And you only have 5 days within which to please submit these reports. We would request that you please stick to the timelines, because we want to ultimately provide a report which will have our findings that can then be taken forward in order to cap issues around Zamazama. And thank you so much. You are all excused.
Thank you very much, Commissioner, and your panel. We really appreciate the time you gave to us, and we commit that we'll submit our reports. Thank you so much.
Left-hand side, it is Commissioner Makwasha, who's also the panelist. And on my right-hand side, it is Mr. Lala, who is an expert in issues of mining. We also do have in the room Commissioner Madlingozi, whom I believe we have met. And we do have our team that is also going to be asking questions of you, and that is Mr. Emmanuel Nkonde, and that is Mr. Kenneth Sitebe, who are going to be probing. We do have other colleagues of the commission in the room. Our communications manager was taking a picture of you, and that's Mr. Wisani Baloy. We do have Betty Mabusela. I don't know who am I leaving out, but Minister, I think it is also important to mention the colleagues that are assisting us with the language operation. They are, okay, what happened to my names? I've been writing the whole morning. Minister, my name is also Nomashubi Kwinana, a commissioner in the Human Rights Commission, who's also chairing this session. Thank you so much, Mr. Lala. That was so quick of you. So they represent the members of the persons with disabilities, and that is Fortune Madlala and Sarah Klaas. Minister, as you know, that is the 12th official language in our country, and that is why we have made sure that there's sign language interpreters. Thank you so much, Minister. We are going to hand over to you just for you and the colleagues to put your names on record before we administer the oath or the affirmation. Thank you.
My name is Samson Kwaede Mantash. I'm the Minister of Mineral and Petroleum Resources in South Africa.
Good afternoon, Commissioners and members. My name is Madikidin Mulato, the Deputy Director General in the Department of Minerals and Petroleum Resources.
Good afternoon, Commissioners. My name is David Msiza. I'm the Chief Inspector of Mines.
Minister, you do have other colleagues that are sitting at the back. If you can you can put their names on record. They don't have to come to the fore. Can we have their names?
My two advisors are here, Gobengundla Konde and Selom Helepi. They are my two advisors. And Clarence Sterek is my Chief of Staff. And who else is here? Ngobile Kanyile is responsible for compliance in the Department of Enforcement. There's Nati Shabangu. He is responsible for my notes. What I'm going to say is written by him. If it's shit, it's him. If it's good, it's me.
Thank you so much, Minister. Minister will then go to our formalities before you then read the good or the bad paper. So may I request that you stand for the for that. May I please have your full names for the record?
I'm Samson Kwaede Mantashe, the Minister of Minerals and Petroleum Resources in South Africa.
Thank you, Minister. Unfortunately, if I speak whilst it's on, that's when I get recorded, and similarly for you. So just pay attention to that. So, Minister, I know my colleague feels so uncomfortable with the issues around age, but it is our law. So may I please have your age on record?
I'm 70 years, 7 months old. 70 years, 7 months old. I'm old, but I look young because I'm handsome.
Thank you so much, Minister. Is it the oath or the affirmation, Minister? Do you have any objection taking the prescribed oath?
No objection at all.
Do you regard the prescribed oath to be binding on your conscience?
Very much so, it is binding.
Do you then swear that the evidence you're about to give will be the truth, the whole truth, nothing but the truth? If that is so, please raise your right hand and say, "So help me God."
So help me God.
Thank you so much, Minister. You may take a seat. We meet again, colleague. I hope you'll have enough time to articulate yourself. Please state your full names for the record.
My name is Madikeledi Muloto, the Deputy Director General in the Department of Mineral and Petroleum Resources, responsible for compliance and enforcement.
Your age, please?
I'm 54.
Is it the oath or the affirmation?
The oath.
Do you have any objection taking the prescribed oath?
No.
Do you regard the prescribed oath to be binding on your conscience?
Yes.
Do you swear that the evidence you're about to give will be the truth, the whole truth, nothing but the truth? If that is so, please raise your right hand and say, "So help me God."
So help me God.
Thank you so much. You may take your seat. May we have the next colleague. May I please have your full names on record and your age?
My name is David Nsiza, the Chief Inspector, and I'm 54 years old.
Is it the oath or the affirmation?
It's the oath.
Do you have any objection taking the prescribed oath?
No.
Do you regard the prescribed oath to be binding on your conscience?
Yes.
Do you swear that the evidence you're about to give will be the truth, the whole truth, nothing but the truth? If that is so, please raise your right hand and say, "So help me God."
So help me God.
Thank you so much. You may also take a seat, Mr. Msiza. Thank you so much, panelists. All the colleagues have been sworn in. Honorable Minister, over to you for the presentation.
Thank you very much, Chairperson of the Commission. Let me start off by explaining that mining for more than a century has been central to South African economic development. And it has continued significantly to contribute to the tax revenue of the country. It is a very significant player on foreign earnings, and it is a very important player on employment creation, and that is mining. However, its history is also marked with structural exclusion. For decades, the mining industry was dominated by large corporations with little to no meaningful participation of disadvantaged South Africans, black in general and Africans in particular. I can confirm that I joined the mining industry some many years ago with my matric, but I couldn't put my hand on a blasting certificate because it was reserved for a scheduled person, which was a white male. The industry has also left a legacy of serious social and environmental challenges, including environmental degradation, the displacement of communities, and adverse health impacts. The dawn of democracy in 1994 marked a decisive break with this past. It ushered in a constitutional order grounded on human dignity, equality, and freedom, and it gave us the opportunity and responsibility to correct the historic injustices. I can assure you, Commissioner, if you go to coal mining is more than 80% owned and managed by black South Africans. That is the effect of change that has been effected in the industry since 1994. For the mining industry, this meant developing regulatory framework that promotes meaningful participation of historical disadvantaged persons, ensure responsible and sustainable mining, and drive socio-economic development. While progress has been made, significant challenges remain. One of the most challenging confronting the sector is illegal mining, which is often conflated with artisanal and small-scale mining. It is generally conflated, it's not the same. These are two fundamental different and most not confused, not to be confused. The government clearly distinguished the two. Illegal mining is a criminal activity. Many people have tried to say to me, I must take responsibility for illegal mining. I say, if you say so, I will agree readily. If you say cash haste belong to the Minister of Finance, and you take stock theft and you say it belongs to the Minister of Agriculture, if you do that, I will readily accept that illegal mining is not a criminal activity but a mining activity. But as it stands now, it is a criminal activity. It is part of a broader organized economic crimes and is often linked to serious offenses, including illicit financial flows, extreme violence, human trafficking, gender-based violence, and femicide, as well as smuggling weapons and explosives. That goes with illegal mining as a criminal activity. Artisanal and small-scale mining, by contrast, is a legitimate and a formalized economic activity, usually undertaken by citizens, legal documented residents within a regulated framework. When you engage me, I will tell you that we have already issued 21 licenses for artisanal and small-scale mining because we're formalizing it. But I will also tell you that that is not a solution to illegal mining. Medium-sized companies are a solution. As you have seen us opening the Kala shaft on the West Rand, it's more impactful than small-scale and artisanal mining in dealing with illegal mining. A disturbing trend emerging from many illegal mining incidents is the involvement of undocumented foreign nationals. Let's give you one example, the Stilfontein, much talked about. There were 1,826 illegal miners surfaced from underground with 93 deaths. When I was sitting here, I heard you asking this question. It was not answered. There were 93 deaths out of 1,826 illegal miners. The majority of those involved were undocumented foreign nationals from Mozambique, Zimbabwe, and Lesotho. Factually, only 21 were South Africans. Only 21 were South Africans. And I hope that number will give you a distinction between desperation of South Africans and the criminal activity against the South African economy. In Barberton, approximately 1,000 illegal miners were arrested, many of whom were undocumented foreign nationals from Mozambique, Zimbabwe, and Lesotho. Again, we must be clear. An individual who enters the country illegally and engages in unlawful economic activity cannot be sanitized and reclassified as an artisanal and a small-scale miner. That is a crime. Entering the country in an undocumented way in itself is a crime. Getting involved into stealing the minerals of the country is another crime. Whereas illegal mining was once largely confined to derelict and ownerless mines, it is now increasingly encroaching into operational and licensed mines, posing serious risk of safety, security, and economic stability. Let me make the distinction. Ownerless and derelict mines are mines whose owners cannot be identified and cannot be found. We discovered 6,100 mines and holdings that were derelict and ownerless as a department. We are closing them. In 2019, the industry estimated illegal mining costing South African economy approximately 49 billion. That is a cost, a leakage in the economy, because it's money that cannot be accounted for. That was estimated at approximately 49 billion of lost revenue. In response, the government adopted a multi-pronged strategy, which includes accelerated rehabilitation of derelict and ownerless mines. And let me make this distinction on rehabilitation. It is in two forms. There is what we call concurrent rehabilitation, which is rehabilitation by operational mines and rehabilitation of ownerless and derelict mines by us as a department. We become the father figure of ownerless and derelict mines. And implementing Operation VALA to clamp down on illegal mining activities, that is a police activity. The streamlining of regulatory framework to formalize artisanal mining and small-scale mining, while strengthening sanctions against illegal mining. When tabling the department's budget last year, we reported on significant strides made by MINTEC, which is an entity in our department that deals with rehabilitation of ownerless and derelict mines. At least 4 asbestos mines in Limpopo and Northern Cape had been rehabilitated, and 280 mine openings had been safely closed. And this was made possible by an additional funding of 180 million rand allocated to the program in the previous financial year. For the current financial year, a further 134 million rand was transferred to MINTEC to continue the important work. It's important for the Commission to note that the annual number of mines to be rehabilitated is dictated by the annual budget allocated received by the National Treasury. And if you look into this, Commissioner, you will appreciate that before 1994, there was no law that regulated rehabilitation. The only law that regulated rehabilitation was passed post-1994. It was actually posted with the MPRDA. Before that, there was no law. Therefore, rehabilitation was no obligation. That's why ownerless and derelict mines left holdings on the ground without rehabilitating them. The department is also closely monitoring rehabilitation and safe closure of operational mines to prevent this operation from becoming a burden on the state. I would imagine that you're going to ask us on who actually conducted the rescue operation in Stilfontein. Let me give you the answer before you ask it. We did that, but the operational man has paid us back. I want you to understand that. That mine, Buffelsfontein, has paid us back. So we have not used state money to rescue the people. We have stood in for the operational mine to actually rescue those people. Basically, it is Buffels that has rescued people in Stilfontein, not us as a Department of State. Okay. I am emphasizing this because I know that you will ask the Attorney General, what is it called? The AG to monitor the money we wasted. We have not wasted that money. That money has been paid back to us by the operational mine, which is Chinese-owned entity. Regarding law enforcement, I'm confident that Minister of Police will has elaborated on what they do. I won't get into that. However, the challenge remains. Many offenders are released due to weakness of existing legal framework. We continue to believe that establishment of a specialized police unit and a stronger legislative provision are necessary to decisively deal with the criminal activity. We believe in that. So the difference between us and you are a human rights commission. You think that there is a lot of human rights that are violated there. We regard that issue as a criminal activity, and it must be dealt with mercilessly because it's a crime. That's why I actually put it in the same level as stock theft, cash heist, ATM blasting, and all that. Those are criminal activities that must be dealt with as such. It's a criminal activity. So it is against this background that there is ongoing review of mineral and petroleum resources development to assist formalized artisanal and small-scale mining. We prohibit illegal mining. We criminalize transportation and trade of minerals without prescribed documentation. Even as this review continues, the department already acted. In 2022, we published a policy on artisanal and small-scale mining for implementation. That was in 2022. That's why I said earlier, already we have issued 21 licenses for artisanal and small-scale miners. We are assessing the next tranche. We want to be systematic about it. It's not a response to illegal mining. It's not. It's an economic activity. It's a lawful economic participation primarily for South African citizens and legal documented individuals if they apply. The last point, let me clear, the policy does not legitimize illegal mining. It creates pathway for lawful, regulated participation while ensuring criminal activity is firmly and decisively dealt with. That is our opening gasp. Will handle the various questions that will come from the Commission.
Thank you so much, Honorable Minister. Honorable Minister, your colleagues, there's nothing to add. We can start probing, especially because I know that Memoloto was not happy with us. In fact, we did receive her communique where she complained that she was only given 10 minutes to articulate herself. And when she was probed, she felt that if she had been given ample time, she would have been able to engage the questions much better. So does she have anything that she wants to submit this morning, or has she been covered by yourself, Minister?
Nothing. I'm covered from what the minister presented.
May you also find out from you, Mr. Msiza?
Thank you, Commissioner. I'm also covered. Thank you.
Thank you so much. We'll then move over to the legal team. We'll start with Mr. Ngonde. Over to you.
Thank you very much, Commissioner. Good afternoon to the Minister and the whole team. We do appreciate the presentation from the Minister. We will For myself, I'll ask few questions, Minister, I promise. I won't be long. But what I want to also bring into your attention, which we will also cover, the department in the previous sitting submitted a response to a number of questions that were put to it. There are 3 files on that table. The response from the department, when I look at the index document, it starts from page 307 to 334. But for the purposes of my section, because we've delegated the work, I will concentrate from page 310 and approximately to 332. I would take it that the minister would still accept that the response given by the department still stands as it is. What was presented today by the minister is just an augmentation. Can I just get that foundation properly before we move forward?
Thank you, Mr. Nkonde. Minister, is that the correct summation?
I will answer questions as directed to me, whether they're based on that submission or on today's submission. I will answer the questions.
The question is more on whether you regard that which was submitted by Memlord with her other colleague on the previous occasion as binding on the department, as people that were delegated at the time to make those submissions.
Submission made at a particular point are binding at that point. I'm making further submission today. They are binding from today.
I suppose they are binding either way, because it's a continuation from the first leg of the inquiry. And again, they are before you, Minister, as Mr. Nkonde has alerted you to the respective pages, 307 to 334, which you will be privy there too. Mr. Nkonde, let's accept that answer from the Minister. Thank you so much.
Thank you very much, Commissioner, and thank you very much, Minister. Can I therefore invite you to go into the pack? Go to page 310. The first one, I think the blue file. The blue file. To page 310. And maybe the first set of questions, Minister, would not necessarily be directed to you, but you can have a bite on them. It is based on the introduction that was forwarded to the Commission by the department. Paragraph 3 of that introduction, the department on page 310, the department recognizes the findings and the recommendation or recommendations of the Commission outlined in the investigative report of 2015 and 2016 respectively. Yes, as I was saying, the department is recognizing the findings and the recommendations of the commission that were made in 2015 and 16 respectively. So maybe as a foundational question, what should be the understanding of the commission, particularly the use of the word that the ministry recognizes the two reports? I don't want to read anything into it. I just want the ministry to tell the commission, which 9 years later, what is it? Can you unpack the recognizing of the findings and the recommendation in this response? Thank you.
As the current minister, long-serving relatively, I became a minister in this department in 2018. So I've been a minister here since 2018. Throughout my period as a minister, I've made a big distinction between artisanal small-scale mining and illegal mining. It's not the same. Those are two concepts, different, serve two different purposes. That's my stand, and that remains my stand.
I think my question remains. I understand what the minister is coming for, where the minister is coming from. But are you saying to the commission, these recommendations were accepted and they were acted upon as they relate to artisanal mining, as these reports
Let me make two distinct answers there. Is that we are here to the Human Rights Commission. You are conducting an inquiry on artisanal and small-scale mining. But your emphasis is on illegal mining. Our starting point is that your framework is wrong. That's where we start. Your framework is wrong. You are having an inquiry on a wrong issue to resolve a different issue. And therefore, this inquiry should be, if it's about illegal mining, focus on illegal mining. And you deal with illegal mining for what it stands for. It's not artisanal and small-scale mining. So if your recommendation, I have not read this report, I must confess, if your recommendation conflates the two, I will be opposed to that.
Thank you, Minister. I think, Commissioner, for this purpose, and particularly Minister, I have not introduced the word or mentioned the word illegal mining. For now, I'm still talking about the recognition of the reports.
You'll recall in our first submission last year in October, you asked the same question, and we responded to say yes, because the issue was, in those reports, the findings was that there was a regulatory framework in what the department is doing and what has been happening on the ground, especially coming to issues of artisanal and small-scale mining. There was an issue that there's a regulatory gap, and we responded to say, based on that, there's a policy of small-scale mining and artisanal mining to address that, and we are augmenting that. Last year, we started with the amendment of the MPRDA, the Mineral Petroleum Resource Development Act, which is our law, to make sure that we close all the gaps. And Minister, in his submission, mentioned that the MPRDA is formalizing artisanal and small-scale mining, is also going to be dealing with criminalizing illegal mining. So yes, on those recommendations, whether we implemented them or not, yes, we have implemented them because we have dealt with the policies and we've dealt with the amendment of the law. Yeah. Thanks for now, Commissioner.
Okay, thank you very much. I think for this conversation, I would stay with you because the document, I think, was presented to the Commission by you. I would come back to the Minister and deal, and I fully understand, Minister, that you have categorized illegal mining and artisanal mining as two distinct activities. I fully comprehend that, and we will deal with that as the time goes on. We are on the same page when it comes to that. Ma'am, the following paragraph, still on page 310, you indicate that, if I may introduce it to the record, Commissioner, for everyone to understand, it reads, the department highlights that the Commission's report from 2015 to 2016 collectively reveal a concerning gap between South Africa's progressive regulatory framework for mining and actual experiences of communities affected by mining activities. Continues to say, although legislation exists to promote sustainable development, inclusive growth, environmental stewardship, the reports indicate widespread non-compliance, poor enforcement, and systemic neglect. I will stop there. To what extent are you agreeing with the findings that I've just alluded to? In fact, they were summed up by you. To what extent are you agreeing with particularly the poor enforcement and systemic neglect? I'm not limiting the response to you. The whole team can take it.
You'll recall in our previous submission, we said that was 2016, 2015, and 2016, back then, not now. And we said at that time, yes, we admitted that there were legislative gaps and then there were poor enforcement and all those back then between 2016 and 2015 and 2016. But since then, we have amended the laws and regulations, and we've introduced new policies to make sure that we close this gap. So this was 2015 and 16 backwards, not forward. But forward, we have since coordinated ourselves properly to make sure that we have closed all these gaps. I can make an example that in terms of the social labor plan, we introduced new regulations on the social labor plan, and those regulations improve on some of the issues that you highlighted in your report in 2015 and 2016. And I'm repeating myself to say things have changed since then. There were policies, regulations, and guidelines and everything to make sure that we close the gap back then. So the situation has changed.
Thank you very much. Are you saying all the gaps have been covered before I continue with my line of questioning?
That cannot be social science. You are dealing with a social science matter as a natural science. Let me tell you the distinction. Social science is about applying a policy and consistently implement it. But natural science is exact. If you mix water and syrup, you produce a cold drink. So you are answering a natural science question in a social science situation. We've closed the gaps. Your question that says all, it cannot be relevant in a social science situation because new issues continue to emerge in a social science situation.
Granted, Minister. Okay.
Emmanuel, maybe let's limit it to this. Of those that as at 2015, 2016 were identified, have those been covered? Maybe if we can have you answer that question. We accept that obviously as time goes on, other issues are likely to come up. Yes, but as the ones that had been identified at that time, were those covered with the amendments and anything else that you have had to do?
Yes, they've been covered because of, you recall at that time the issue of illegal mining, it was not at the stage where it is today. But in terms of the gaps that were identified in the 2015 and 26 reports, yes, through those legislations and regulations, we have addressed them.
Thank you, Commissioner. Then let's flip over and go to page 311 and look at that response that you've just given now, and then reflect or put it against the response, which is still part of your introduction, the third paragraph. And with your leave again, Commissioner, can I introduce it into record? It reads, and I want to put this context to the response that it was given last year, October. And we are considering this response against the response that we've just received now that say most of the gaps have been covered, which were raised back then. Now, the paragraph reads, the department recognizes that despite the existing policies and legislative measures, the artisanal and small-scale farming, in brackets ASM, industry continues to face significant challenges. The industry remains predominantly informal, even though there has been an increase in the number of Section 27 mining permits issued by the department. Section 27 of the MPRDA, which regulates licensing for artisanal mining sector, has been perceived as a barrier to the development and growth of the sector. So now the question is the response that you've given just now in line with what you are submitting on this? Because I think you are raising Section 27 as a barrier to the artisanal mining space.
For us, the answer will remain the same. We have said, or your report 2015-16 said there were legislative gaps. And we've addressed those gaps through what I've indicated, policies, legislation, regulations. And we have said small-scale mining, maybe let me say Section 27 of the MPRDA is where people apply for permits. And one issue that has always been coming out is the issue of the cost of people applying for those permits. And that's why one of the interventions that we came up with is what the minister alluded to, that we've got a fund that we're assisting people to make sure that they go through the hurdles of Section 27, because you need to have money to apply for those permits. And we're assisting those people to go through the process of application. So at a time, the issue of cost was one of the issues that we said is a barrier in terms of development of growth of the sector, in terms of small-scale mining, because they follow the same process that is followed by big companies. And obviously, if you start small and then you don't have enough funds, you obviously that's going to be a barrier, because you'll not be able to participate at the same level with the other companies. And that's why the intervention that we brought as the department is to assist those that are coming through the Section 27 in terms of the running cost of applying for mining permits.
Can we give you additional information? We've started 2 funds there. One is for small-scale exploration. We've found it attractive to various funders. We started with 400 million. It is now at over 2 billion rand. But the small-scale and artisanal mining have not been as attractive as the exploration fund. And that is an inhibiting factor in itself. We are going to work harder to get more money on artisanal and small-scale mining, because you can give them licenses. If they don't have basic capital to start doing what is basic, they're not going to do it. That's why the number remains at 21. It should be at 100. But money doesn't allow us to go that big. And I want you to have that distinction, which is not in the answer you are referring to.
Thank you very much, Minister, for that additional information. Then my next question is, which will also tie in with the number 21. Let me start there. Can you give us, or can you give the Commission a timeline when this 21 has been achieved? From which year, I would assume, to 2026, which we are sitting on today?
It's the first patch. It's not a series of patches, it's one patch. You can explain that, DG.
Maybe let me start by saying our intervention does not necessarily mean that there has not been any mining permits issued, because from the records that we have here, from January 2021 to 27 Jan 2026, we've issued 681 mining permits. Obviously, those people, they got the funding elsewhere. But the gap that we've picked up, that people are struggling to apply, that's when the intervention of the 21 came. So it's not like there were no mining permits issued. So, and they're issued because they are applied on different times, and then the processing of application will also take a different form, that when you apply today, your license is going to be issued after whatever, 6 months, 8 months, whatever period that you would have. So the 21 is an intervention that came, and when we consolidated everything in 24, 25, that's the figure that we are giving you. It's an overall figure, including those that we've been issued throughout since 2021, even beyond.
I thought the Minister wants to chip in.
I just wanted to make the distinction. That is the overall permits, which is general mining permits. 21 is limited to artisanal and small-scale miners. So that distinction is very important to me, because other permits are people who have capability on their own. They raise loans and they do many things, they mine. That's why when you talk BEE in coal mining, I confidently say it is mainly owned by black and managed by black South Africans. It's because they are not dependent on this small scale and artisanal mining. Artisanal miners will be an appendage of a major mining company, because they will not have all the tools. We gave them basic capital to start mining on a small scale. And when we perfect it, even the sale will be going through a major mining company. So we'll have to identify a small scale miner and a major mining company. That will be where the small scale miner will be an appendage to. Okay.
Yeah. Thank you very much, Minister. I will stay on the number 21. How much support have these 21 received from the department, if any at all?
You'll have to define what you mean by that, because the intervention means, and we said the reason why we intervene is because there was an issue of cost of them not affording to go through the application process. The intervention then meant that once they were identified, they were then assisted to go through the process of the application, because the law is very clear on the requirements. Then we take them through the process of application. We even link them with MinTech. Minister mentioned MinTech is one of our state-owned entities that will assist. We'll also link them with Council for Geoscience, which is one of our state-owned entities. We take them through the process and make sure that all the hurdles, they are able to go through them until they get to the position where a permit is issued for them. So we take them through the process in terms of the requirements of the law until a permit is issued. And we also do the monitoring to make sure that the money that is apportioned for them is used. Okay. I was saying, so
Minister, remember you are under oath, and Minister, you said these are the two colleagues that you are going to be testifying with, and individually they must testify. So the other thing that you must avoid is conferring with each other whilst you're there. If somebody knows the answer to the question, they are welcome to answer it. But Minister, unfortunately, you can no longer consult because you have taken oath and the people behind you have not been sworn in. And I wanted to also interject there and say, Memuloto, what does that translate to? That's the question. Instead of you pinpointing this and that, what does that look like? The costs that have been used, or the intervention, what does that look like in terms of finance? That's the question. Otherwise, it looks like we're going to be here for the entire day, and we don't really have to. If you have the information, you're able to speak to it. And of course, if you don't have it, you're welcome to say that I will provide that information at a later stage. But what does that look like? Instead of you telling us, we did that, we did that. Can we talk to the figures if you've got them?
Okay, we do have the figures, and the figures were also presented last year. If I may indicate that the provincial capex allocation was 67.5 million in total that we spent on the assistance to small-scale mining. I can give a breakdown of the project in terms of the provinces. Is Limpopo, 6 project, we spent 26.7 million. Northern Cape, 4 project, 14.6 million. Northwest, 2 project, 10 million. KZN, 2 project, 10 million. Mpumalanga, 1 project, 5 million. So these are the amounts that we spent on the assistance. This is part of the support that we have provided.
Thank you, Commissioner. And I want to make a request that a submission be made to that effect, that aggregates these figures, as you've pointed out, per province, and also aggregates them in terms of what form of support. And also, let's get, I request as part of the consideration when we are looking at the evidence in totality, to look at, let's put the names behind the entities that have been supported. Thank you very much, Commissioner. I think if there's no comment on that, I will step off this question and then move on to something else. Okay, thank you very much. I think now I'd move to issues that involve Ntatem Caesar. And now I want to give you context again. I have stepped out of the issues of artisanal mining. Now, we are looking at the department's response to Stelfontein, which I fully understand, and I think the minister has made it clear that that which happened there is a criminal activity or is illegal. Can I just get a confirmation of that before I move? That I understood you correctly on that.
Correct.
Thank you. Now, page 312, 2.2 talks about Mineral and Petroleum Resources Development Act. Maybe just the understanding, because there's a summarization, the summation of the powers that you have, Minister. And amongst those powers, I think I can imagine that you would not go there and inspect yourself. There are other bodies that, or arms in your department that will assist you. You have one of the powers is to suspend. I think in terms of section 47, suspend a license or cancel it. Is that understanding correct?
There are two sections. 54, you cease operation temporarily. 47, you take the license. Yes.
Thank you. Now we're talking about Stelfontein. I understand it's a criminal activity. 2015, the department submitted, you would correct me if I'm wrong, that the current license holder stopped mining. Is that correct, or my understanding is wrong? I just want to lay proper foundation before we get the 2015, that's when they stopped.
We just need to make sure, are you talking about buffels? Okay. Yes, they stopped active mining at that time because there were issues of liquidation or there were other issues, but they stopped active mining at that time.
Okay. Now, the inspection part, that Caesar. To what extent did your office, I'm saying your office because of the Chief Inspector of Mines, how often was, for context, we are talking about Valfontein. Let's not confuse them with other activities. To what extent was inspections were done in that shaft from 2015 to 2024 when the incident started?
Once again, thank you for the question. And indeed, we do inspections, broad inspections as a department, not only within the health and safety branch, but broad inspections of that we do as a department. Now, as Advocate Malota has indicated, the department has been putting initiatives to address the challenges in working together with the law enforcement people in terms of the criminal activity. Now, if you actually need the details thereof, we do inspections on health and safety, and mainly on legitimate mining. That's what we focus on in terms of the Mine Health and Safety Act. We can actually provide information in that regard. But I must also emphasize that because of the criminal element that the minister has clearly indicated as well, there has been a safety and a security risk to the department officials broadly. And where we can, we also go there with the law enforcement agencies. But if you want the details, we can actually provide the details of the inspections that were done since that time.
Thank you very much, Commissioner. That information would be highly appreciated because it informs, and then I would want to understand whether was there any recommendation to the minister to probably invoke Section 47, particularly on non-compliance issues that you may have picked up during those inspections.
Can I be excused for 2 minutes? I need the bathroom.
Sorry, ma'am, sorry. I want us to then rather go into lunch whilst you also take that comfort break, but we also then observe your right to food at this stage, because lunch is served, it is ready. Yes, so we are only going to take 30 minutes. Please try and, I know it's a limitation, but we have the food. So we know that this food is enough for everybody that is here in this room. So the food is available. Let's make sure that we access the food, and we will come back. It's now 13:08. We are going to come back at 13:38. Thank you so much. You excuse, please remember you're still under oath. Do not discuss with your colleagues at this stage. You are under oath, please. Thank you so much.
Before I start, Commissioner, can the panel or the team from the minister's side be reminded that they are still under oath?
Thank you so much. Honorable Minister, may I just confirm once more if the oath you took in the morning is still binding on your conscience?
It will bind until we finish this process.
Thank you so much. May I also then have the DG, Memoloto, please confirm as well that the oath is still binding?
The oath is still binding. I'm not the DG, I'm a DDG.
I heard people say, I accept. I don't know about you, but anyway, thank you, DTG. May I then also have you, Mr. Msiza, confirm that the oath you took in the morning is still binding?
Thank you, Commissioner. Indeed, it's still binding.
Thank you so much. Over to you, Mr. Nkonde. Thank you so much.
Commissioner, time is against me. Let me just wrap up. I have two questions. I'll leave all the others. Maybe they will be covered in the course of this thing. I'll go back to the last question, Dr. Msiza. From all the inspections done in Buffelsfontein, was there a recommendation made to the minister, because he might not be on the ground, to consider Section 47 in one shape or another, either cancelling because of the criminal activity that you alluded to in your last response, to say you were laying foundation, to say there were criminal activities and it hampered some of your work. So was there a recommendation following all the inspections that you did to the minister to say, hey, there are problems there, can we consider one of the possibilities in terms of Section 47?
As indicated, you initially referred us to Section 2.2 on page 312. I've indicated that we do, as a department, we do various inspections. And Section 2.2 mainly refers to the MPRDA. However, we also do inspections in terms of the Mine Health and Safety Act. And also we work together with the law enforcement on the criminal activity. So through you, Chairperson, if we can be indulged, we can provide the relevant information, including whether there was a 47 that was considered for Buffelsfontein, if we might be indulged on that.
As I said earlier, it was in our interest not to close Buffels because they had to pay us back. We saved, we conducted a rescue operation on their behalf as an operational mine. It was not a derelict, an ownerless mine. It was an operational mine. They had to pay us. So if we closed them, we would have cut our nose to spite our face.
Thank you very much, Minister. But context was given to this question. The owing part, maybe let me understand. They owed you in relation to you conducting the rescue, which you were paid back, right? Fully understand. But my question started from 2015 when they ceased operation and the various monitorings or inspections that were done. Commissioner, it is very difficult for me to accept this response because from the knowledge from the Chief Inspector's Office, I think the magnitude of Stelfontein, the response should be readily available, even though it may not be supported by documents now. But question is, was there a consideration or a recommendation for the minister to consider? Because there are criminal activities that are detected. It's your evidence. Thank you.
No, if I may, and hence I strive to delineate between the MPRD and the Mine Health and Safety Act. So we, as the Health and Safety Inspectorate, we administer the Mine Health and Safety Act. So the Mine Health and Safety Act, if let's say there's transgressions, you can either issue a Section 54 instruction, as Minister has indicated, to stop that particular mine until it's made safe. And also the Section 55 instructions that are issued where there's non-compliance, we issue those. So you indicated that since 2015, and hence I've actually pleaded for your indulgence, because obviously there's also the MPRDA. We'll just have to look since 2015 up to now in terms of the both of the legislation, whether that was done. And clearly the Minister has also indicated that our approach as a department is to promote mining. So where there's challenges, we try to also assist. However, where in terms of the law, however, where there's a challenge, then we consider those, including 54. So hence I was also really pleading for the indulgence through you, Chairperson.
What's problematic about that answer is that you knew that issues relate to Stelfontein. So it's really unacceptable that you should come to an engagement without having made sure that all the information, especially that relates to Stelfontein, because really it is the bone of contention, has been for the longest time. Even your DDG, when she was probed in October, it was around those issues. So it's really unacceptable, Mr. Msiza, that you don't have the information.
We do acknowledge that and respect that sentiment, Commission. But we have also taken an oath to ensure that we provide accurate information since 2015, and we have not also been requested on that. So I think, and hence we are requesting indulgence that let us be given a chance and we respond accordingly and correctly as we requested. Thank you, Chair.
Enough time was given.
Bavswetfontein is a company. It operates a number of shafts. And there was a disaster in one shaft. So when we talk of Bavswetfontein, we can't just close it because in particular shaft, there is a disaster. We ring-fence that shaft and deal with that disaster. That is the information that will be submitted here. But not Bavswetfontein as a company, because it runs a number of shafts.
Minister, that's the information we're looking for. And if a DDG had taken you into her confidence, should have informed you what were the questions that she was asked, which related to which mine and what this department has done in order to ensure that the communities in Stelfontein do not find themselves in that situation that they were once in. Or at least that mine does not attract illegal miners. That is the issue, Minister. And it's very sad. You know, as a commission, we source funding in order to have this engagement. We have had to accommodate the department because on the previous occasion, the DDG could not answer most of the questions that were posed to her. And the promise was that she'll make sure that when she comes on the next occasion, the questions can be answered. Now today, Minister, we have you with your team. Again, it looks like we might go back to the powers that be and say we don't have the information and we have to wait for it. It's very costly for the Commission to engage in this exercise. And if we could, I would say sometimes we wish we were a court of law, because then we can order the department that has wasted the time to be the ones to cover the cost of the next engagement, because the evidence is now going to be submitted, maybe in a report, we don't know, or it's going to be an affidavit, we don't know. And we cannot probe it further. And it's possible that you might present something that wants us to ask more questions. And that is why you've been given this time. So really, Minister, it's unacceptable. It's unacceptable. Stelfontein, Bafosfontein, it has been in the news, and it is the one that has brought us here. And that is why we are now asking all other questions that relates to mining in the country, because we understand that as the minister responsible for it, you are looking into policies, you're looking at the laws, so that whoever wants to operate in that space can do so, but legally, which is the right thing to do. But at the center of it is human rights must be observed and must be realized.
I don't understand you, really. We've tried to the best of our ability to answer your questions. Now we're getting a series of complaints from you that we have not answered questions. What questions have we not answered? Where we have not given you accurate answers, we said, we'll give that to you in writing so that we don't break the oath. That's the only issue that we've raised, but we're trying to answer your questions here. I don't know what is it that you are complaining about. Can you please put us in the light?
Minister, the DDG testified before this commission. At 3:07 to 3:34 is the response that was provided by the department. And even then, we were not expecting the DDG. We expected you to be sitting where you're sitting now, to have these answers. Questions were posed, Minister, and we expected you to then investigate anything that related to those questions and be able to come here with the information, instead of telling us this afternoon that now we have to wait because you are still going to make time to prepare another report. That is unacceptable, Minister. But at this stage, we're going to let it go and hope that in the next 5 days, it will be one of the reports, Mr. Msiza, that we are going to receive to say whether you did consider Section 47 or Section 54, as you have alluded to, whichever that you have considered with regard to that particular shaft. Thank you, Mr. Nkonda. Any further questions?
Just one last aspect. Minister, you invited me to this question in your presentation. Can I invite you to National Environmental Management Act, NEMA, particularly Section 24P. Let me introduce it on record, then I'll step down. The title of that section or that particular portion says financial provision for, it relates to rehabilitation and whatnot. Financial provision for remediation of environmental damage. The section 24P sub 1 says, an applicant for an environmental authorization relating to prospecting, mining, exploration, production, or related activities on prospecting, mining, exploration, or production area must make the prescribed financial provision for the rehabilitation. management and closure of the environmental impact before the minister responsible for mineral resources issues and environmental authorization. My interest is on subsection 2, which the minister said because of the financial issues that the company had, then the ministry had to foot the bill. Subsection 2 says, if any holder or any holder of an old right fails to rehabilitate or to manage any impact on the environment, or is unable to undertake such rehabilitation or to manage such impact, the minister responsible for mineral resources may, under written notice to such holder, use all or part of the financial provision contemplated in subsection 1 to rehabilitate or manage the environmental impact in question. Now, Minister, the question is very simple. How then did the department get to pay the bill if financial provision had to be made prior to you granting the license? That is my last question, then I'm stepping down. Thank you very much, Commissioner.
I will allow Mamloto to give you how the environmental provision is provided for. It's not all in cash.
Coming back to section 24P of NEMA that you've just alluded to, you'd have realized as you read in there that there are various methods of financial provision that will be cash, trust funds, bank guarantees, that the operations or the mining companies will then submit to the department. Now, coming to Buffels had a bank guarantee or a financial provision, if we put it loosely. But you need to put a distinction between a rescue mission and rehabilitation. That rescue mission was not a rehabilitation. We call it a rescue mission. And I must indicate that Buffels is rehabilitating some of the old shafts that they've worked on. And Minister indicated that they've got various shafts that they're operating on. There are those that are old and those that are existing. But for that, we couldn't, because, and you said it correctly, NEMA is very clear on the financial provision. It says financial provision for the remediation of environmental damages. That what was happening at Stelfontein was a rescue mission to get those illegal miners out of a hole to safety. And then later we deal with the issue of financial provision. And that's why in terms of section 24P, we could not use the financial provision that we have to go and perform or conduct a rescue mission, because section 24P is very clear on how the money should be used for rehabilitation. So that's why we had to source funds elsewhere for the rescue mission. But the rehabilitation continues, and as we speak, Buffalo's is currently rehabilitating.
Thank you very much. Just a follow-up on that. I understand that the expense was incurred because of the disaster, and the money was not meant to be used for that. But remember, previously, in your own evidence, you indicated that from 2015, they tried to apply for the closure certificate. You could not give it to them because of a variety of non-compliance. And I think we indicated that about 3 times they did not comply. So my question, the reason why I'm asking this question is that we would not have gotten to the point of disaster had rehabilitation taken place prior to that time. Thank you very much.
Mamloto uzoqalisa. You see, you are doing 2 things. You wanted to imagine what should have happened if X, Y, and Z occurred. Here, with all the omissions that were committed, there was a disaster. And we said this is a crime scene. We didn't go there. But when the order came for a rescue mission, we had to step up and say, let's do the rescue ourselves. And we used the money that was available at the time to rescue the people. The rest followed. That's why refunding followed later. It's not rehabilitation. It's refunding for a rescue mission. Now, if we have to preempt issues in mining, actually there will be no mining. Do you know that? Because mining surprises you all the time. You can't predict a rockfall unless there is a seismic event. Sometimes a rockfall just happened instantly. So you would ask as a lawyer, why did we allow a rockfall? We'll tell you that we couldn't predict a rockfall. It happened without us predicting it because that's how it works. Sometimes there is a seismic event. You will ask us as a lawyer, why did we not preempt a seismic event? Mponeng mines 4 kilometers deep. Seismic event happens randomly. And CGS does predict and actually appreciate the extent of a seismic event. But generally, mining in itself is not something that you can predict accurately on any event. So in Stilfontein, we had people, let me use this term before I step off, called voluntary non-fit injuria marine. It is voluntary assumption of risk. People take a voluntary assumption of risk. It's not a mining activity. They go there on their own, they voluntarily assume a risk, they go underground, and when they go there, a disaster happens, a number of them die. Many of them die. We couldn't predict that because those people knowingly and voluntarily consented to take the risk. And from where we are sitting, that is an illegal activity. It has happened. We could not predict it and prevent it because it is a criminal activity. We don't regulate criminal activities. So you say, if we did this X, this would not have happened. I agree with you. If we did Y, Q should not have happened. I agree with you. But now, we're dealing with the reality that there was an incident and a disaster in Stilfontein. It has happened. We had to respond to a disaster. You want to add?
Nothing further to add?
Commissioner, I committed to step down. I'm not really pleased with the answer, but I'm going to leave it and we will deal with it probably in terms of the report when we are summing up. Thank you very much.
Thank you, Ntate Nkonde. May we then move over to Mr. Sitebe.
Thank you, Commissioner. Afternoon, Minister and your delegation. Unfortunately, I have to ask very few questions owing to time. And unfortunately, my first question will sound argumentative, but that's not the purpose. Minister, you say there was an effort on your part to distance yourself from criminality in the mining sector because the Minister of Finance is not responsible for cash in transit and the Minister of Agriculture is not responsible for stock theft. Therefore, you can't be responsible for zamazamas. Something like that. The question is, owing to the fact that these mines are hubs of criminality, are hubs of human trafficking, are hubs of explosives and possession of firearms, aren't you then concerned that as much as it's criminality and therefore SAPS should deal with it, these people are only drawn because of failures in inverted commas of the department to thoroughly regulate ownerless, derelict, active mines and all manners of things. Therefore, your department somehow is drawing this criminality to itself. If I'm wrong, please correct me and then I move on to less argumentative questions. Sorry.
That is terrible. Let me correct what I said. What I said, illicit mining is a criminal activity. Simple. It is having the same status as cash heist. It has the same status as stock theft. It has the same status as bombing of ATMs. Now, those have no regulations because it's a criminal activity. The same applies to illicit mining. We can't have regulation for illicit mining. That's why of the big number that we got in Stilfontein, only 21 were South Africans. The rest were foreign nationals entered the country illegally. Now, you are expecting us to develop a regulation for a criminal activity. There is no criminal activity that is regulated in the country, not one. Because a criminal activity is a criminal activity. It happens under the cover of darkness. Okay, so it can't be regulated. What I'm expecting of you as a commission to say to us, this is what we can do to minimize this criminal activity. We have subjected in our suggestion 2 things. We said, 1, if we can have a specialized unit focusing on illegal mining, it will help because our observation as a department, she will add to this. We discover that local police get swallowed into activity. They become beneficiaries of criminal proceeds. That we said if there can be a unit at national level that is deployed from time to time will help us. We said number 2, it would help us if we have a combination of an accelerated artisanal and small-scale mining plus medium-sized mining companies. That's why I cited the question of Kala shaft in the West Rand, that it has a bigger impact on illegal mining than artisanal mining. Artisanal mining is too little to impact on illegal mining. So we said those are the 2 interventions that will help. We are working on them. Oh.
Thank you for that clarity. Now, in your response, Minister, you say you meaning the Commission, I'm expecting you, the Commission, to do X, Y, and Z. In 2025, the Commission tells the Department of Minerals and Energy, DMRI submitted that the holder of rights of all times accountable for environmental management of the site, but where the right lapses the mining is terminated, the holder must apply for a closure certificate. Mines that are no longer profitable close their operations without following proper procedure. The Commission is already telling you in 2015. In 2016, the Commission again comes back. It says to the DMRE, the Commission further finds that DMRE has not taken adequate steps to secure financial provision for rehabilitation damage for the environmental, water resources, and their immediate need for, and so on. So we are coming back for the 3rd time to plead to DMRE to deal with rehabilitation issues, to deal with SLP issues, which is the less argumentative question I want to explore with you after this one, to deal with issuing of licenses without consultation to communities and so on and so forth. Let's conclude on this and then we'll move on to lesser questions. Thank you, Minister.
Can we also just refer the Minister to the respective page, Mrs. Sebe?
Minister, I'm sorry. Let me start there. I'm sorry. For your benefit, and because of time, I omitted. But it's custom and tradition that I refer you to page 10 of the submission there, which speaks to the objectives and scope of this inquiry. And then what I was referencing, I lost it. I'll find it and then I'll come back to you.
Is it perhaps part of their previous submissions?
Sorry, I found it. Page 7 of the panel in front of you. Sorry, Commissioners. Yes, I should have mentioned pages.
Both you are mixing visitors and abavakash. It's not the same. Abanye ngabavakashi, abanye visitors. Don't mix them. Rehabilitation, that's why I gave you, rehabilitation is divided into two. There is concurrent rehabilitation, which is an obligation of an operational mine. If you take an inspection in Logo, you go to the Wheatbank area, you will see it happening in practical terms in open cast mines. Because as they mine, they rehabilitate, put back soil, plant trees, plant grass, and all that. That is concurrent rehabilitation. And I said earlier, in rehabilitation, there are ownerless and derelict mines. Owner cannot be identified, we can't find it, and we're mining them systematically as we get a budget from somebody who, actually there's only one person who runs something called funding, money, finance, budget in government, and that is the Minister of Finance. And that minister allocates us an amount. If they allocate a limited amount, we close a limited amount of holes. If they give us a bigger amount, we close more holes. That's why we give you a number in 2024 and said, they gave us additional 180 million rand, and we closed further so many holes and so many asbestos mines. Because what we do is a function of what is allocated on us. So that is how rehabilitation works. And actually, it's a sin we're taking as a legal successor to our predecessors, who had no obligation to rehabilitate anything. That's why we found 6,100 holdings and derelict mines. We are closing those mines systematically, bit by bit. Now, so there's what is concurrent and there's what we are inheriting as a legal successor to our predecessors. That is rehabilitation. SLP is a different concept altogether, because SLP is a social license for mining companies to operate. We said to them, please change the image that mines open holes and leave them. You must be humane in dealing with communities. And we go back to them and say, don't put small projects like your community hall and all that. Build impactful projects. That's why if you follow SLPs in your community, you'll see mining companies building schools, building clinics. In Wheatbank, they have even bought 21 vehicles for police to deal with criminality. And it goes on and on and on, food production and all that, because those projects must have an impact in those communities. If you have just small projects, you don't make the necessary impact on those communities. So that's why I'm saying you are mixing two things that are not the same. Okay.
Minister, respectfully so, Chairperson, I was not mixing. I was addressing your assertion that the Commission ought to have, in this inquiry, ought to tell you to do something. And I'm saying that we have already told you on 3 subjects. I'm not mixing them. I know they're separate issues. We've already told you in 2015, please do this and that with rehabilitation, with this. I'm not saying they're the same. And then we came again in 2016. We said, Minister, please, the department, not yourself, please do X, Y, and Z. So now we're meeting again for the 3rd time. Yes, still Fontaine related. We're going to have recommendations in the report. They're going to speak to issues of SLPs, issues of rehabilitation, is that the department till today would not have addressed. Again, I unless if you are pressed to respond, I wish to move to SLPs because you just touched on them, and it's an important issue of the 2 or 3 questions that are remaining.
May I just give you a short response? We have given you an answer that depending on the budget allocation, we do rehabilitate. Okay. SLPs, let me wait for your questions.
Okay, SLPs, not my submission, not the Commission submission. On page 48 of the bundle that you are busy with, somewhere towards the end of the page, it says, I'll paraphrase, it says, found that on average, only 23% of SLP projects were fully and partially completed. Now, I'm looking for another submission from LHR, speaking a similar language about SLPs, that the fulfillment rate is wholly inadequate. Again, I'm going to the report of the Commission, the page 440. The Commission had already found in one of the two reports that success rate for SLPs is 32%, that it's 36%, that it's 24%, that it's 30%. So what I'm trying to say is this. We've been preaching SLPs and the clinics that you spoke about, good that they built them. But we've been preaching that this number is unacceptable. Last footnote to this question. When Advocate Moloto appeared, I said, you do 271 inspection of SLPs. What is that compared to the amount of mining licenses that you issue annually, 5 years and 10 years? Because if you issue 1,000 mining licenses and you only inspect SLPs as 271, what are the 800 and something plus mines doing? Benzan, what are they doing? Because part of the acquisition of the license was for them to fulfill. I don't want to be long. I want to move on to the next one. Thank you, Minister.
Okay, let's help you so that at least you move on with some understanding. You know, an SLP, if we build J.S. Kenjana High School in Tujo, it's a huge school, it's like a university. It takes a mining company with resources to do so. But if you go to Witbank and you get small mining companies that have one shaft, 2, 3, those are not going to be able to build a school. Until you reconcile the two, you are not going to be appreciative of the impact of SLPs. If you go to Witbank, you'll find a clinic in Paula. That clinic is built by Sereti, but a smaller coal mining company is not going to have capacity to do it unless you pull 5 of them together to build a school. If you go to Tofumvaba, you are going to find a fenced 74 hectares of land, but you'll have to talk to Minister Nyonso to buy 2 tractors so that fenced land must be productive. So it's quite an involved exercise. I'm just giving that to you for information. But if you are a commissioner, you are an inspector, you won't see the complicated process that we get involved in to make it impactful on communities where they are. You go to Rustenburg, you'll find there a mining company building a primary school and a high school at the same time. It's because it has capacity to do so. But if you go to smaller Matikiri, they can't build those schools. You have to nurse them to pull their resources together to have an impact. At least, as a commissioner, I want you to appreciate that and understand it. Yeah.
Brief, and then my last question. You know, the issue of SLPs, Minister, your response still falls short. In your main address, you mentioned economic development, GDP, employment creation. You mentioned quite significant things that the mining industry contributes towards too, right? If you go to Buffelsfontein, Stilfontein, and you show me a clinic that was built by Buffelsfontein as part of an SLP, we went there, there was nothing. There's nothing. You walk, you drive and you walk, there's nothing. There's no good clinic, there's no good school, there's nothing. So where are the SLPs, the Buffelsfontein?
Uyika phezulu mining step. Uyika phezulu kakhulu. And when we go to Stilfontein, you're going to find a long history of Stilfontein mining. You'll find a big history of Buffelsfontein mining. You'll find a long history of Hartbeespoort Fontein. You'll find a long history of Val Reefs if you go to the Orange River. That is history. Okay. Today is actually scrapping what is left over of those major mining companies. Okay. So basically, you are making us pay the price for our predecessors. I was working for Anglophal. I've been in mining for many years since I was young. The only sector I know is mining. I worked there. I played rugby there. I ran there. At that point in time, all those tracks are dead today. You can go to the Free State, you go to Western Holdings, a track that used to have a tartan track is dead today because Anglo built Free State Goldfields 2 years after the Nationalist Party took over, and it pulled out of the Free State Goldfields 2 years after the ANC took power. You may not record that as a commission. I noticed it. Good. 2 years after the Nationalist Party, Anglo-American built Free State Goldfields. 2 years after the ANC took fire in 1996, they pulled out of the Free State Goldfields. And that is the legacy that we must address today with lesser resources. And if you don't appreciate that, you are going to blame Buffels, which is trying to scrap dead shafts and make a living out of them, and say it must have a huge SLP. I will appreciate that it is not going to be having that for the longest of time. I have to nudge them little bit by bit and say to them, please merge your resources with Harmony, which has some shafts in Val Reefs, merge your resources with CPM, which has some shafts in Val Reefs, and pull yourself together and build an SLP. And now, I'm talking to you now as a minister in the sector who appreciates the complexities of the sector. That sector used to make a big contribution to the GDP. It is today make 6.2%. On the last 2 quarters, it has been the biggest contributor to the GDP. But I know that is short term because it is the cyclical behavior of prices of commodity. When those prices go down, that sector has to make a smaller contribution as they pick up, as gold is today, platinum is picking up, silver is picking up. We are making a bigger contribution to the GDP. But I don't celebrate that because I know it's short-lived because prices of commodities are generally cyclical. They move up and down. And therefore, I don't celebrate on that. So you talk of SLP, Buffels, to me, we're pumping life into a dead duck, but we're trying to pump life in it. Okay.
Chair, not to appear to be argumentative with the minister, I'll address this remark to you and then ask my last question. They say they gave 691 mining permits. I don't know the time period which they gave them. To present.
6,001 holdings for rehabilitation.
No.
It's 6,100 holdings for rehabilitation.
No, I'm talking about mining permits. No.
Distinction between a permit and a license. A permit is for exploration. That means you quantify and you also get the quality of the mineral in a particular area. Then once you discover it, then we give you a mining license. Then you mine.
Chair, I understood the department to be saying they issued 691 mining, not the exploration permits. No, I know the distinction between a license and an exploration. So now, of the 691, one would expect then that there would be at least 691 classrooms, not schools, classrooms. But go to any mining town that recently got, go to any mine that recently got a mining license and point me to a container that reflects a fulfillment of your SLP through that container. We've been everywhere. We've been to Velcom, Minister. You know this. We've been to Velcom. We've been to so many mining towns. You can't point to a single resemblance of an SLP, even for mining companies that are making significant amount of money. Let me ask my last question because I don't think we're going to win with the SLP questions. Let me ask my last questions. Sure.
You see, Steve, your visit is not a mining activity. It's a visit. I think you understand that. Now, if you visit and form an opinion out of a visit, you are going to commit major mistakes because you are going to expect a Velcom to have SLPs when Velcom was on the peak of its mining activity. It was under apartheid. It built nothing. Now, Anglo left Velcom in 1996, 2 years after the ANC took power. You are expecting Anglo to go back to Velcom and build SLPs instead of nudging Harmony, which is scrapping on the remains of those subs, to do something that can prove. That's why I was launching 3 months ago a center there for training with MTA, because we're trying to make life out of no life. Anglo was pulled out there 2 years after the ANC took power, and they went there 2 years after the Nationalist Party there. I used to go there every January, have a week training for athletic coaches, because the maize board was linked to Anglo. Once Anglo pulled out, the maize board pulled out. Okay, now as you visit there, please do some research to understand the area. Please, Dr. Put.
Thank you, Minister. When we visit, we engage with communities. People have lived in those communities for many years. And my last question, Chairperson. Minister, of the 6,000 plus ownerless and... Do you want to come in?
Through you, Chair, maybe before you close on the SLP, I just want to make a correction for the records that mining permits are not linked to SLPs. You don't submit an SLP for a mining permit. You only submit SLP for a mining right. So I just thought for the record, it should be clear that you will not expect SLP project to come out of mining permits. Thanks.
Yeah, thank you for that clarity, Nyabong. Of the Minister and the Department, of the 6,000 plus ownerless and derelict mines, how many of them are you unable to trace the owners, even though the rights or the permits were given by the new administration? Thank you.
Ownerless and derelict are old mining rights that were issued by apartheid. This administration cannot identify them. That's why in our report we'll tell you so many asbestos mines, so many this and so many this. All of those have no owners. Okay. The only the concurrent rehabilitation, we have authority over it and we enforce it. But those, we stand as a father figure for people we do not know.
I think the question was, how many are those ownerless mines? How many? Do you know, or do you have the number?
6,100 are ownerless and derelict mines. That means that is the number of holdings on the ground that have no owners. We can't identify owners. We rehabilitate them ourselves as a government.
Chair, that was not the question. The Minister subsequently answered it. The question was, of the 6.1, how many are you responsible for? It could be one. You could have 6,000 that were issued by the apartheid government. Nina, you only issued one and you've since lost track with the owner. That's the question. And then, as I leave, I won't ask any question. Nyabonga, thank you for your time. Appreciate it. Nonke, as you sit there. My parting shot is this. Will we still sit with ownerless and derelict mines? Will we still have an increase from the 6.1 10 years from now, 20 years from now? Thank you, Minister. I'm indebted for your time. Thank you for your patience. Nyabo.
We will not have an increase. We are reducing the 6,100. We continue reducing them. As we close those holdings, we reduce the number. There will be no new one because the concurrent system is forcing an operational mine to declare money sufficient for rehabilitation in case of closure. So we won't have an increase.
Commissioner Bakasha.
Thank you so much, Chair. And I think to the Honourable Minister, I always like to use this opportunity to educate South Africans about some of the questions they have. And in your opening statement, you clearly distinguished between illegal mining activities, artisanal mining, and then you also spoke about small-scale mining and mid-sized companies. These three are part of a broader policy consideration by the department in order to address the 2015 and the 2016 recommendations by the Commission. Can you just perhaps unpack it for us? You know, sometimes we read, but because English is a third or fourth language for some of us in the room, please unpack it for us in a way that those who are watching online can say, oh, I'm able to go to the department and ask for assistance for small-scale mining. Please, Minister.
Lord, you want to talk to the licensing system for artisanal and small-scale miners?
Thanks. As I indicated,
not the licensing systems, how it looks. So we speak about artisanal mining. What would be defined as an artisanal mine in terms of the department? What would be defined as a small-scale mine? And then there's a new term that we've brought today, Minister, mid-sized companies and how they work. Not the licensing process, but how an ordinary South African, when they're sitting at home and they're making notes and there's a community, they may say, oh, based on what we want to do, it falls within the definition of artisanal mining, Minister, not the licensing process. I'll come to that.
Artisanal is chisel and hammer. Okay, that is artisanal, chisel and hammer. You use a chisel and a hammer to break a rock. A medium size works better in other mines than deep mines because they use less resources to mine remnants of what is left of it. It's more applicable to coal, diamond, little bit to manganese. It is very difficult to have small-scale miners in gold mines because they're deep, dangerous, hot, and they're very rockfall prevalent. The medium size is an emerging trend where you'll find your gold one in the East Rand, you'll find your Westwoods in the West Rand, you're going to find your DRD. Those are medium-sized companies that actually mine what is left over by the old major mining companies. That is the distinction we're making. And our new discovery was that these medium-sized companies will be more effective in eradicating illegal mining than artisanal and small-scale mining.
Thank you, Minister, for that, because we really I need people to understand that there's illegal mining and there's these three systems which you are going to use to address histories. One of the complaints we received in terms of the submissions received was that the process communities need to engage in terms of obtaining licenses was quite encumbersome. You know, the environmental impact assessment, small-scale or artisanal miners cannot adhere to SLPs because they're so small, and in terms of what they would be getting, they would not be able, as you said, to make significant impacts in the communities they're operating in. So the complaint was that process is very difficult for them. In terms of your Ms. Moloto's submissions, you said that you reviewed that. How far is it to address those issues raised by community members?
I will add to.
okay. I mentioned earlier this morning when the question came that we're taking the small-scale miners into a process and assist them in terms of the requirements. And I mentioned that unfortunately the requirements, or fortunately the requirements of the MPRDA are the same for whether you are a middle mine, big mine. In health and safety is not compromised, whether you are a small-scale miner or not. And that's the reason why we came up with the intervention to make sure that we assist the small-scale miners to go through the process and the requirements of the law so that they are within still within the requirements of the law, but assisted by the department in terms of that funding that we apportion to them. And I also mentioned that the funding, then the support is in many forms, where we either engage Mintech or Council for Geoscience to assist them further. But they are still within the requirements of the law.
Can I give you a very important example? Royal Bafokeng, as a traditional authority, forms a company. It runs a very successful, profitable platinum mining company. When shares prices go up, they sell that mine to Impala. Now, that is an example of what communities do. We objected to that. We couldn't control it. It's not ours. It's theirs. They sold their right to Impala. They are now a shareholder in Impala, very small shareholder in Impala. To me, that was one of the most important brands of community participation. There's another one in making in the Eastern Limb, where a chief is working with a mining company on a 51-49 arrangement. That mining company, we're hoping it succeeds. We're hoping. Because if it succeeds, it will prove that a traditional authority with its communities can participate in mining. What is unique today that we must deal with every day is that communities don't make a difference between mining and land. And it's not the same. Land belongs to all of them and the traditional leaders, but minerals belong to the surface of the soil, belong to the state on behalf of the people as a whole. There's no location. I can move from Kala and participate in Rustenburg. I can move from Rustenburg and participate everywhere. That's why the richest black billionaire, but is from the northwest, but is all over the country. Because minerals do not belong to those provinces, they belong to the state. The reason that you apply for a permit and a license from the owner, the state, is because minerals below the surface of the soil belong to the state on behalf of the people as a whole. Now, all we are saying, we're encouraging communities to form proper vehicles to participate in mining activities and not only claim geographical location without applying for a mining license or a mining permit to mine the mineral. It is not theirs, it will be theirs if they get a license. Once they get a license, that mineral is theirs, they will trade with it, they will make business out of it. Once you understand that, you are better off than the rest.
Thank you, Minister. Whilst we are there in terms of this issue, we also, as the Commission, received allegations on the corruption in the licensing process of artisanal mining aspects. And we are told today that only 21 licenses have, and this is an allegation, Minister, it's not what we are going to then say it's the truth. It's an allegation from community members that the reason why there's so little licenses that have been issued is the issue of corruption. Is there corruption in that process? If not, then you can say, no, it's just an allegation and I close it there.
No, corruption is a different matter. If you link it to the artisanal and small-scale mining, that's a big mistake because it's people who depend on the state for support financially. So if there's corruption, it will mean you are corrupting, you are actually stealing from the state. Those people who apply, they come, they in numbers, they are assessed and given licenses and given money by the state. So it's an allegation, really. It can be. General issuing of licenses, there may be an element of that in the regions. we'll have to investigate that. I've actually asked the DG to appoint the SIU to do a deep investigation there, because I think that our regional managers do involve themselves in some unacceptable activities. That is a different matter, not small scale and artisanal mining.
Thank you so much, Minister, for that. I know time is constrained and I'm a very slow speaker, but I also want us to have proper engagement. So, Minister, you spoke about budgets, and I'm going to speak about budget allocation because one of my focal areas is pro-human rights budgeting. And at its core, mining in its very nature is extractive and takes away from the community, but from the land. Now, you spoke about the budget, and you said it's very small. You are unable to rehabilitate the owners and the greater mines as you wish. If we're sitting here and we were able to allocate you the necessary budget, how much would you need if we could, as part of if we're going to make recommendations in terms of your budget? How much would your department need, one, to have the necessary inspectors on the ground to ensure that there are no gaps in terms of communication from the provinces to your office timelessly, two, from the mining companies to ensure that rehabilitation takes place successfully, but also three, to ensure that you are not chasing mining companies? Because I've noted in some aspects in terms of what we do in the provinces is that you may not have money to pay experts to ensure that you have an independent report regarding some of the conduct of the mine. So let's talk money, Minister. How much could you, we may not be able to achieve it, but we may get you maybe 10% and maybe it will help in the long run.
I'm going to make a distinction between the two. Minister spoke about rehabilitation of derelict and ownerless mines. Those are the ones that we get in money from the treasury. And the latest report, which is dated 2024, that what was done by an independent service provider, is that the government or department will need about 49 billion to rehabilitate all the derelict and ownerless mines. And that's why I want to make the distinction between the two rehabilitation. That's on the side. But then you have rehabilitation concurrent that is done by mining companies, that is funded by them. And then annually, in terms of the MPRDA, they assess their financial provision based on the liability on the ground, and they submit to the department at various levels, at various times, to say, my mine, that is the life of mine of 30 years, annually is going to have this financial provision, but the provision then, or the liability goes down as and when they do concurrent rehabilitation. So we'll not have a figure here to say all the mines in South Africa, they're going to need R1 to rehabilitate all, because they're mining at different levels, at different phases, and their financial provision vary as well. So it's not a one-size-fits-all. And like I said, annually they revise the financial provision to us. We check as well if it's commensurate with what is on the ground, and then we approve. If not, then we don't approve, and then on as they go and rehabilitate. So the figure will not say for all the mines in South Africa, active mines, you'll need this. But at least for that other one, derelict and ownerless mine, we do have a figure.
No, but I was also asking in terms of the other aspect, having sufficient inspectors on the ground, because one of the other complaints, and we've also seen it in your own submissions, you don't have enough personnel to be on the ground to inspect, write reports. In some aspects, you have a few inspectors, for example, allocated to Northwest and Limpopo. How much would you need for that to be done sufficiently so that you're not caught chasing the reports of mines? Minister, that's what I'm saying. In terms of that aspect, how do we...
No, thank you for that question. So what we've done as a department, we've appointed a service provider to look at our structure. So there's a process that is ensuing that to look at, because if you can recall, we were with our energy colleagues before then we split again. So there's a company that we have appointed to look at our structure and obviously to look at our ever-increasing mandate, including the issue of criminal mining that has been referred to. And thereafter, then we'll then actually consult. We'll actually consult with Treasury to say, based on the structure that we have, we believe that incrementally we might need so much more. So there's a process that we are looking at, and I think we are looking at doing it within the next 6 months. That process to make sure that it helps us in terms of the efficiency and obviously the capacity needs of the department. Thank you.
Again, the question of number of human beings is a function of efficiency. My background is in the trade union movement. We do more with few. Not because we want to, because the situation forces us to do that. And we're very impactful with that. We'll sit with the management team, with that PhD and that Dr. So-and-so, and we sit there as activists. We ground them, we transform the sector. So it depends on the efficiency. My experience in the public service is that you do as little as you can with more. With what we have, we can do more, but we're doing less with what we have. So it will never be sufficient. It will always be having gaps here and there, and that's my view. Now I'm giving you a subjective view, which is personal.
Minister, I've been advised that we have very little time, and I just have one last question. I'm going to limit my questions. The one environmental system, in the last sitting we heard from, I think, Mimolot about it. Is it working in a way that you will want it to work as the minister? Because we saw the gaps in terms of this presentation from your department as well as the Department of Fisheries and Fisheries. Thank you. That's my last question, Chair.
What? You want to answer that?
I think you're talking that on the background of the history of how we started the one environmental system together with DFFE back then and Department of Water. From where we're sitting, it is working, but there are challenges. And then recall the reason why we did this was that as and when this processing of application goes along, maybe let me say this, in terms of the one environmental system, DFFE is responsible for the appeals of the mining. So once we process and everything, somebody raise an objection in terms of the mining, in terms of the EA, environmental authorization, then DFFE will look into that appeal. And then if you apply for a mining right, you then concurrently apply for a water use license at Water Affairs. So the three departments, we've got bilateral meetings every quarter to take stock of all the processes that we said we'll do together. Of course, there are gaps that we're trying to close as and when. Every system will have those gaps as and when we go along. But the engagement is working with those challenges.
All I can add is that if you put ecology versus economics, you are running into problems. If you integrate the two, you have a better chance of succeeding.
Commissioner, you've already said you're done. Can I hand over to you, Mr. Dladla?
Thank you, Commissioner. It's frustrating to come at this time because there won't be enough to engage it. I have so many questions. Firstly, Minister, thank you for clarifying the difference between artisanal mining and small-scale mining. And in your presentation, you did allude to the fact that you've issued, I think it's 21. I don't know whether it was me who did not get it. It was 21 licenses that you issued. Are they for artisanal mining? If you can clarify that.
artisanal and small-scale mining. That distinction is a function of learning.
Thank you, Minister. So out of the 21, all of them are bundled into one. You cannot say 15 is for artisanal and then 6 is for small scale, because I believe that there's a difference between a small scale and an artisanal miner. Like the Minister said, an artisanal miner uses rudimental tools, and a small scale miner uses machinery at a very small scale. So is the licensing regime encompassing everything?
It's everything. It's artisanal and small scale. It's one category. Yes. Yeah, it's one category.
Thank you, then, Minister. When did you begin issuing these licenses? And also the lifespan of these licenses.
Okay, we mentioned earlier that we started the process 2024-25 financial year with this new dispensation.
Am I correct? 2025? Okay. In the MPRDA, does the MPRDA regulate artisanal mining?
We mentioned that we're doing this process in terms of Section 27 of the MPRDA. Yes.
Thank you, then, Minister. So now I would quickly like to zoom into Stilfontein. You've clearly made it known to us that it was a criminal activity and you had nothing to do with it. Yet you explained that you had to fund the rescue. Why did you then participate in a criminal activity?
Criminality is stealing the mining from us. Rescuing life is a different exercise. It's not the same.
I heard the Minister saying there was an order that stated that there must be a rescue. The rescue mission must begin.
We met at cabinet level, and that order came out of the cabinet meeting.
Commissioner, I don't know if I may ask if the inquiry would receive that order so that we could see. And when did that order come? Because I believe the rescue, like Makua had mentioned, and also LHR, they did mention in their submissions that one of the ministers said that people will be smoked out. Therefore, the rescue mission was stalled, because from August, there was the community rescue that was able to save quite a significant number of lives. When the professional rescue started, it was too late, because there were videos that were surfacing from the ground that there were bodies already. So would I be correct if I put it to you that if the rescue came before January, there would have been quite a significant number of lives saved? Thank you.
I have a particular view on this matter. My view is that people knowingly and voluntarily took the risk. That's my view. And if you voluntarily take a risk, you can't transfer that responsibility to the state, because you have voluntarily taken the risk. So it is not falling within the category of human rights. I'm making a submission to that effect. It's not a human rights when people voluntarily take the risk to endanger themselves. It's not a human rights issue. It's a voluntary act, and people do it. What is human is when you save them. When you save them, it's a human intervention. You can't counterpose the two to be one.
did that responsibility lie with your department when it came from cabinet? Because that was a criminal activity that was taken care of by the police.
We worked with the police still. As we did that, police were in the forefront of the activity because it was a criminal activity.
Last one, Minister. How much was used for the rescue that you were able to recoup from Buffelsfontein? And thank you for that after that.
Let me verify the amount. I will give you the amount because it's exact.
Minister and the team, whilst you're looking at the figures, just one last one. Stilfontein was not the first incident of what you refer to as illicit mining, and it won't be the last. We've seen it, and we're still going to see it. Yesterday, the Minister of Police did mention that illegal mining is cumbersome for them alone. As the police, it needs a multi-sectoral intervention. I am worried that you've always said, and you keep on saying that artisanal mining, or sorry, illicit mining, and you put it, is a criminal matter. It must be dealt with by the police. And history of mining in the continent explicitly explains to us that people were encouraged from the very same countries, Mozambique, Zimbabwe, to come to South Africa to work. And the very same people are now found working in these illicit mines. And you are engaging with other countries where they come from. Have you, at any point, had a discussion with them about the movement of their citizens and the illegality of them being here, and also engaging in illegal activities, resulting in what we've seen in Stilfontein, which is a catastrophe?
No, what you will not find is a diplomatic engagement between ourselves and Lesotho on illicit mining, because they have no control over the movement of those people. I hear that you say they are encouraged, but they have no control over those people. Those people move. You go to Mozambique, they have no control over them. They move. Zimbabwe, they move. So you can't have a bilateral agreement with countries on illegal movement. Actually, it is my considered view that illegal movement of people to South Africa should be dealt differently than it is being dealt with here. I think we are soft on it. As a result of that, we become victims of it. Even before they do illegal mining, that illegal movement of people from one country to the other, when there are formal systems for people to move from one country to the other, that in itself should be handled as a criminal activity. No other country allows it. You know, 3 months ago, there were 7 people from South Africa arrested in Zimbabwe. We asked a Zimbabwean staff member of the embassy and say, "You've arrested 7 of our people for going there." You know what he said? He said, "It's because we're not a banana republic. Nobody moved to Zimbabwe without a permit. If they do that, we'll arrest them. If you allow it to your country, it's your choice." And that is the choice that we must try to correct. So people must come here on permit. I worked in the mines where there were quite a big number of people from Lesotho, Mozambique, but they came here on contracts. and worked here, allowed to work here, no complications. Actually, we elected one of them as a president of the NUM, and he became a president for 18 years from Lesotho because he was here legally and had a permit to be here, and we allowed him to work. And I'm saying, let's take few steps back and regulate movement of people into South Africa. Once we do that, we'll go a long way in dealing with illegal mining, because illegal mining is an offshoot of illegal migration. That is what we should be dealing with. How much is it? Be glad.
I'm looking at the invoice from the Mine Rescue Services. It was 11,978,855,78. And maybe to give the context as well, we shared with Mineral Council, so we were responsible for the 5,989,47,89, and that was the sharing between Mineral Council and ourselves.
Thank you so much, Mr. Dlala, and thank you to the chairperson for allowing me to come in. Perhaps can you provide us with clarity? Yesterday, we had the representative from the MEC of Community Safety and Security, but also acting in terms of her capacity as the Civilian Secretariat for Police Service. When she made a presentation, she said an amount of 6 million was used. Now, it's concerning that we're getting different figures from different departments, and all these departments are saying we are the ones who participated in the rescue. Essentially, we are now told that and this is what they received from the rescue team as well. We just need clarity. At the end of the day, who paid for that invoice, so that we know at the end of the day, the funds were allocated to this department, they paid for it, and they have been reimbursed for it.
The rescue operation was carried out by Mine Rescue Services. Okay. We paid for it. We shared the payment with the Mineral Council. Nobody else. Not police, nobody. We did pay for the rescue.
And the amount was 11 million plus based on the invoice, and you paid an amount of 5-point-something million. Is that correct?
The total was about 11,900,000 and something, and it was shared half-half between ourselves and Mineral Council.
Thank you.
It worked out to about 6 million each.
Minister, the submission that we received yesterday said it cost about 6.9 million. You see, perhaps if I can chair through you, can I ask if we can obtain that presentation in hard copy and indicate to the minister what we had received? It was let me just look. COSATMA yesterday. COSATMA. The community, so this is the Northwest Community and Safety Management. So they had presented a presentation, and that is why, Minister, I'm asking if we can pause for a bit. I know that we're running out of time, but just for clarity, because now in the public space, because this is broadcasted, there are 3 departments who are saying we've paid for it. Now, it creates a lot of confusion in the minds of South Africans.
Reality is that we paid, worked with the Mineral Council, we settled the bill. But we recouped that money from an operational mining company. That's the reality. Everybody else is doing thumb sucking.
Thank you so much, Minister. So therefore, we don't have to show you what they have presented to the Commission. You don't need it. Thank you.
Minister, so you've recouped all that money that you used for the operation. because in my opinion, you were lending the operation so that the operational mine could give it back to you. How much did you receive back?
We have received everything, or every cent that we have spent was paid back.
So was the Minerals Council also reimbursed, or you guys have nothing to do with that?
Let them speak for themselves.
Thanks, Commissioner. So another note that the inquiry has to put in is it the mandate of the Minerals Council to ensure that the rescue had to happen, or was it part of the order that came from the cabinet? So I just want to understand why the Minerals Council took part in that, because saving lives is a constitutional mandate of the state. Thank you, man. Thank you, Commissioner.
No, Buffaloes is a member of the Mineral Council. So they have they have rescue missions in various mines. And therefore the Mineral Council does that everywhere there is an operation. It has nothing to do with a constitutional mandate of the state. It is a member who was in trouble and there to save that member. Whether that member has paid them back is a different matter. Am I right? Yeah.
Thank you so much, Minister. Minister, I just want to take you back to the issue around if mines are properly rehabilitated, would we find a situation where illegal miners would have access to those mines?
There are rehabilitated mines where illegal miners blast and reopen. So, but it would be rare. It would not be as prevalent as it is today. The more we rehabilitate, the less the risk.
And what is the challenge for the department to ensure that there's proper rehabilitation of mines?
There's a limited number on the budget allocation. We do what we can. We close at about 40 holes per annum on the amount that is given to us ordinarily. If we would get more budget, we would close more holes.
And also, what is the challenge in ensuring that mines are inspected regularly? And I would think that there's probably is a policy that guides the department on how often these mines are supposed to be monitored and inspected.
Thank you, Commissioner. I think, as I indicated, for various responsibilities in terms of the law, we do, for instance, on health and safety, we do 8,000 inspections, and we issue about 7,000 Section 54 and 55 instructions on licensed mines. The challenge, if I can call it a challenge, indeed it's not a challenge, is that the mining is dynamic. So everything, as the Minister has indicated and Advocate Malota has indicated, the status of 2015 might not be the same as the status now as well. So it's very dynamic, and where we can, we do inspections and we issue instructions to ensure that there's compliance with the legislation.
So is there a report available which will then show the extent to which these inspections have been done that you have now alluded to?
Yes, Commissioner. We do have a report. We can also provide a copy of that report.
Thank you. May that then be provided. Now, Minister, let me just take you back once more to the SLPs. And please correct me if I'm wrong, but my take is this: it doesn't matter how small you are able to produce from a particular mine, but I would think that there must be at least a parameter to say, be able to do so much for this particular community. In any event, you have made something out of the ground which serves this very community. Is there something of that sort, or it is open, it is up to the companies for them to provide?
Every mining license goes with an SLP agreement. But let me emphasize again, it is our own option to say, please do involve yourselves on impactful projects. This thing of smaller projects doesn't work in real life. Impactful projects work for communities. But every license goes with an SLP agreement.
And how is this measured? Because from what I'm hearing is that that's what you drum to them. That's what we encourage them to do. But in terms of that particular SLP that would have been signed with the respective company, who measures this impact? But again, how do we even make sure that at least we do receive something out of this mining company?
Every mining license have an SLP agreement. We're having a section in the department that do SLP inspections. And that unit does make inspection of SLPs everywhere. And those who are not complying, they get a Section 93 notice that you are not complying with the SLP agreement. Please do make up for that SLP.
So how many companies, because South Africans are probably watching, they're saying, what are they even talking about? Here we are in Kunu and we don't have a clinic. Here we are in Rustenburg, we're struggling from just having schools for our children with disabilities and many other issues. Northern Cape, for one, I know for a fact that mothers or parents, let me just not say mothers, but let me say parents in Northern Cape, they are struggling with their children that are suffering from autism, that they have to take them to Kimberley because that's the only place where there's a school. So where is this report? Can we locate it so that we can look at this, at the impact, but again, also where there hasn't been compliance? When did we then ensure that we serve the notices? Do we have those dates? And of course, how far do we follow it up? Is it just issuing notice and then we let it go?
You know, Commissioner, you're making a very wrong example. The Northern Cape. I physically launched a primary and high school in Kuruman. Physically. 4 months ago, 4 months ago, I launched a center for disability in Postmaspec, not in Kimberley, in Postmaspec, where there were already kids that were in that center, because that center talked to issues of those communities. And one of the things I do as a matter of conviction on my part is to be part of launching many of these SLP projects. So they are there. Kulu will be a different matter because there are two things that makes you qualify for an SLP. One, you must be a mining community or you must be a labor-sending community. So I don't want to talk about Konu. I want to talk about mining areas where I've been part of launching SLP projects.
Indeed, Priska, the community there in Northern Cape are really struggling. And yet what became evident in an inquiry that we had with regard to service delivery is that there are mining companies that employ people other than the very community that is there. Whilst South Africans are saying job creation is not there in South Africa. But I'm sure with the SLP, amongst others, Minister, that is how you can say to them, please ensure that you give the people in this very community of Priska an opportunity to work for these mines, so that whilst they work with these mines, they can also then contribute into the economy of their country. But over and above that, schools, Minister, clinics also to be there, hospitals, Minister, all those things. In all the areas, you know, you're pinpointing one aspect. I've already said to you, autism is an issue, particularly in Northern Cape. You're talking about Kurumane. Kurumane is more towards northwest. I'm talking about areas, Postmasburg. Yes, Postmasburg, I accept that. But I'm talking about areas more towards Uppington. I mean, these are some of the people that we have had to consult with who are saying to us, but we have to go all the way to Kimberley. To go to Kimberley would cost about 4 hours on the road. And in terms of monetary value, even worse. And again, we are talking about communities that are really struggling. But is there a report, Minister? Because I just want us to get that. If there's a report, at least let it be submitted so that we can look at this and the follow-up of the Section 93.
You select Priska. Fortunately, I worked there for 7.5 years. Unfortunately. So when you talk of Priska, you talk of a copper mining area which doesn't mine now. There is a company that is doing exploration in the old Copperton. We've mined copper up to 178 meters. We've discovered a huge deposit below that. There is going to be a mine there. So when you talk Priska, you talk of an area I understand very well. Once that mine is operational, it's actually operated by Orion, for your information. It's operated by Orion. They are working at Priska, they are working at Oakip. So all that area is going to have SLP agreements. They have not started mining. They're still doing water pumping and actual exploration. So I've been there physically, unfortunately. So I've been there now as a minister. I think late last year, I've been there at Priska. So I understand what you're talking about clearly, and I appreciate it because I do work in the mines, and I do go to the mines physically. I don't read about the mines, I go there. That's why when you talk Priska, I will tell you exactly what you're talking about. If you talk Uppington, up to Olifantsfontein, Katu area is a mining area. Beyond that, there's no mining to Uppington. So, if you are talking, Kuruman, therefore, and Katu are linked, and Postmasburg. To a less extent, Olifantsfontein. Now, if you deal with that area, and you do your own study of SLP projects there, you will find that there are quite a number of them, including schools and clinics.
That's the information we want you to submit, Minister, so that you can, isn't it, according to you, there has been compliance from your side as the department. This is an agreement, Minister, that you as the department enter into with those companies. So it would be only proper that you provide us that the list of those companies that have indeed complied, and over and above that, those that have not complied. And then I had asked you to also speak to this. What is it that you have done against those that failed to comply, except for issuing a notice? Or is that where it ends it? There's a notice, we are done.
No, it can't be. When we issue a notice, we are saying to the company, have not complied, and we want a report or action. Okay. So Section 93 is not the end. It is a trigger of action of a report.
Okay, Minister, of course not through your officials. We also request that you then submit that report of the different companies, the different mines that you've got these agreements with, and of course the SLPs, and also the information regarding whether there has been compliance, because in fact, Minister, your work speaks to what is expected also of the municipalities who are supposed to also get involved with the IDPs that they are supposed to produce as municipalities. So if you can just have that, that is going to be very, very helpful. But as a question, I wanted to ask you if Buffelsfontein has been issued with a Section 93 notice.
Yes, it has.
And are you able to give us more information on that?
I don't have the Section 93 with me now, but from the report, it was issued a Section 93 on all the issues of non-compliance, and then they're busy working on the issues of those non-compliances.
How long are they usually given regarding being ahead to the issues that cropped up in 2024?
It will depend on the magnitude of the issues. For instance, if it's rehabilitation is ongoing, and as I said earlier on, they are currently rehabilitating as we speak. But then of the SLP, it will depend what kind of transgression was on the SLP. I mean, the SLP is made of different components, so it will depend on the kind of transgression, and then will allow a maximum of at least 60 days for them to wrap around all the issues and come make a representation to the department. Once a representation is made, we go on site to verify if indeed those has been done, and then so on and so forth, and then we monitor the compliance in terms of the plan that they would have submitted, that this is the action plan to rectify all the non-compliances, and we do that monitoring based on that.
Yeah, the period of 60 days would then say, there should be a follow-up thereafter. Is it 60 days? So with Buffelsfontein, are you able to find out when was this issued, and the 60 days, has it still not lapsed? We're in 2026, the 3rd of February.
Unfortunately, I don't have the buffer's order with me on the documents, but we will submit that order. It will have dates as well, and when is it, if it expired or not, and what happened thereafter.
It's disappointing, Ma'am Muloto, because this was some of the issues that were also raised with you, especially regarding Buffelsfontein. One would have expected that at least that information should have been made available. Having said that, so let's then inform you of the different reports that you are going to have to please submit within the next 5 days, Honorable Minister and the colleagues. you. Apologies for that. So, Honorable Minister and the DDG and Mr. Msiza, the first report is that one that I've already alluded to then, of firstly of Buffelsfontein. When was the notice issued? The exact notice must please be attached. What has been done when that period lapsed is going to become very important. In particular for Buffelsfontein, those SLPs, that SLP is very important, that particular one. The mine in Barberton, because it has also been raised, if that can also be attached, their SLP, and if there has been compliance, if there hasn't been, what has been done. The report on inspections that have been done that we alluded to as 7,000 or so. We need the report of the inspections that were done. The report, Minister, with regard to when the Cabinet took an order to say that the department should get involved and to look into the issues around the criminality. If we can also get that report. Remember, it was posed to you about the minister who spoke about, or who made us, who submitted that they should be smoked out. And ultimately, there was a rescue mission. Yes, yes. No, I wanted to jog your memory. I wanted to just jog your memory. Is that helping you? It's not. No, I wanted to jog your memory around the time when this was brought about. So it was because you then alluded to the cabinet meeting that was held where a decision was taken. If we can have either the minutes or it's going to be in form of a report, and this is when the order was made so that the rescue mission could be started with. Does that make sense, Minister? Have sense. So are you saying there was no order that was made by Cabinet? Yes, or the report in relation to that. Thank you, Minister. Also, if we can get a report on the 21 licenses that were issued. Memoloto, you recall that you could not differentiate as to whether maybe 7 of them are small, medium, or small scale or whatever, but or artisanal mining license. So if you can just be able to zoom into that and tell us exactly what were each of these licenses for, without, of course, compromising those that have been granted the license. We are not looking for these specific names of people. And Minister, it is so that the evidence has shown that there were children, but you keep using the Latin term of non-violent infant injuria, which simply means that they voluntarily assume the risk. when they decided to go into in that shaft. But in relation to the children, Minister, whom have already, there's evidence to say that they were not even aware that they were being taken to a mining place, and they found themselves in a very compromised situation. Would you still say that they voluntarily assumed the risk?
You see, when people get into illegal mining situation, they're not screened. It's not like when they go to a mining situation. So I will not make a distinction between a child and an adult. I will know that there are so many people in that shaft having verified that on their rescue. So everybody who goes to an underground situation is doing that voluntarily from where I'm seated. Whether he has been tricked into it by somebody else, that cannot be my responsibility. I don't screen them. But when I go to the mine, I take a contact in Teba, I go to Wenela, I get screened at various points and I end up in the mine. Then I'm legal in the mine. But when people go under their own jump fence, go underground, they are 15 years old and others are 25, others are 60. I don't know that. That is voluntary assumption of a risk by whoever get involved in that.
Minister, maybe you missed this part. I said there's evidence on record. Minister Tolaj has also confirmed that with the colleagues to say, yes, indeed, there were children. Not only her, but also the Minister of Police with their colleagues as well. They've confirmed that there were children, and what they submitted was that they did not go there voluntarily. And that is why charges were dropped, and they were rather diverted in terms of the Child Justice Act instead of being charged. So are you still saying that that legal doctrine, that defense should then be used, should have been used against those children, and therefore it means they shouldn't have been taken to their respective countries?
I have no control over what police do. I have no control at all. And I don't want to have control over what police do. I don't want to have control. If police screen people as they get them out of the shaft and they make certain discoveries, that is a police exercise. It is the police that will, as a post facto issue, say there were children there. They will do that as a post facto, as they screen people who come out, and that is a police exercise. I am not involved in that. And I don't want to be involved, because if I get into a crime scene, I contaminate the crime scene, then tamper with the work of the police. If the police in their work discover that there are children, there are young people, it's their findings as they do their screening post facto.
Minister, the reason why I'm asking you this, it was because of the legal doctrine that you have alluded to. It is because of that. And you have said it against all the illegal miners that were found there. And one would also think that you're probably also talking about the 93 that became deceased as a result of illegal mining. Am I correct to make that summation of what you are saying?
My view is simple. Illegal mining is a criminal activity. It should be treated as such. What is encapsulated in that illegal activity is not my responsibility. That is the responsibility of the police. If police want reinforcement, they will ask, is support of the military. They have a right to do so. I can't do that. Okay. Then military will help them. All I'm saying, if you are in an illegal mining activity, you are committing a crime, irrespective of your age.
In other words, even those that are coerced and even those that are children who could not been able to take those decisions themselves, according to you, they should be treated with one blanket order.
Can I tell you, as a spy, in my village, young people do what is called housebreaking. That is an illegal activity. They are young, they break houses, they take property, and the legal system deals with that. Not me as a victim. Do you get my point? It's not the duty of the victim to deal with that. It is the legal system that deals with that. Same applies to the illegal mining. It's a criminal activity. If people are coerced into it, if they are misled into it, or people are told that there's good job that they are going to do, and they discover later that it's illegal mining, it's their discovery. The legal system must deal with that issue, not the mining department. You know that I can't deal with a firearm with a pen. Actually, I will be dead before you know, because I'm trying to control heavy arms with a pen. Police must do that. They are equipped to do that. They are trained to do that. I am not trained to do that.
According to the ministers that have testified before us, a multi-pronged approach was embarked upon, which involved your department, SARS, DSD, and even to date you are expected to try and collaborate in order to circumvent issues such as human rights being violated, or even having to find mines that are not properly monitored or inspected, to avoid this type of situations. It's a food for thought, Minister.
What a food for thought. Yabala lo mama. Nomye kuthiwa ngobi lokho naba ngemva. Bakula unit by department ekuthiwa compliance and enforcement. They are forced to work with the police because what they do involves the police. They provide the information, they provide the intelligence, they provide everything they come across. We receive reports. When I receive them, I forward them to them because they deal with the issue. They go to nut joints to deal with the situation because it's a criminal activity. And we'll continue doing that. We're involved in the joint effort, but we know that specific issues belong to a particular department that is actually trained and capable of dealing with it.
The response against criminal activity, should it be that you have assumed the risk and you do not care of any other circumstances, is that your take?
Caring is a different issue. It's an emotional feeling. When you begin to take care, you ring-fence the activity and you begin to assume something else. That's why you and me will differ, because you will say, illegal mining, there must be a human rights component. And I will say, it's a criminal activity. If police are use human rights in dealing with it, it's their baby. From where I am, they have stolen 49 billion rand of illicit precious metal trade in 2024. It's a big offense for the country. And that's where I end. Human rights is your call. And from where I'm seated, I will ask you in another day, do you want human rights for criminals and no human rights for the country? I will ask you that question. Because there's still 49 billion rand on the economy, but you say, but human rights, they must be given food, they must be given water to steal. We must give them food, we must give them water to steal. But the economy pays 49 billion rand of leakage in its ability. And to fund this Human Rights Commission, you need that 49 billion rand. You see, to fund this Human Rights Commission. But this is when they're going to say, no, pay a blind eye to these criminals because they are human beings. And this Human Rights Commission still wants its budget. You know, during the COVID, a sector that saved the fiscals was mining. You know why? Can I explain to you? When actually we had that thing closed, where there was a shutdown, we said at level 5, let's allow all open cast to work. At level 4, we said coal mines must work. At level 3, we said all mines must operate. And as a result of that, they saved the fiscus. And that is my concern. When we looked into the quarterly performance of sectors now, mining is the biggest contributor to the GDP currently. And I warned my cabinet colleagues and said to them, listen guys, don't be excited about this. It's because the price of gold, the price of silver, the price of PGMs, and all those are on the up. Please take that into account. We'll come here 2 quarters later. It will be contributing less because the price have collapsed. And that is where I fit in. Criminality, I don't fit in.
With the 49 billion, was it billion, that was lost, had been lost, had it not been, had it been that rather, these minings are properly rehabilitated. There are inspectors on the ground that are making sure that there aren't illegal miners, the zamazamas, that are taking chances. When our borders would have been properly kept, when everyone else who has been earmarked to do their work in terms of our own constitution, which I think, Minister, and I believe you do uphold, which has got human rights in it. The Bill of Rights is very clear. Chapter 2 is there. It's not South African Human Rights Commission that says, here's the Bill of Rights, observe it. It is in terms of our own constitution and according to the government that we have put in power, that is also saying, observe this very constitution. Would the 49 billion have been lost if everyone else, all the stakeholders, were doing their work? Would we have a situation in the country where we've got people that are saying we are not employed? The people in Stelfontein, and I'm happy that you are here when I asked this of the minister, the communities in Stelfontein are complaining that their houses started cracking and so forth due to this illegal mining. Now, if your inspectors, Minister, were on the ground all the time doing their work that they are mandated to do, would we have lost this 49 billion that we need so much in the country? And would we really have our wealth as a country being in the hands of those that are not supposed to have?
You are very artificial about life. You assume that things remaining the same, the outcome would be. That's an economic transaction. Everything remaining the same, the outcome would be X, Y, and Z. But things do not remain the same. Because things don't remain the same, there is what is called bumps in life and economic performance. And this is what we're talking about here. When there is stealing of mine of precious minerals from the system, that is a bump in the economic setup. Though mining is doing well, but there are still bumps. That's why when you say we'll have a 3% inflation target, we still allow 1% below and 1% above to make provision for bumps. And bumps will always be there in real life. And we're making an assumption that if things remain the same, would have done that. If everybody was doing his work, would have done this. And you are making an assumption that if we're all doing our work, there would be no thieves. You are making that assumption. Good, because abajongleyo housebreaking, stock theft, illicit mining, cash heists, there would be nothing. Those are not planned for. If they were regulated, they wouldn't happen. But they are not regulated. People evade regulation to commit those crimes. Now, when people evade regulation to commit harm, it can't be a human rights issue. I make my submission. It's a criminal activity. It's not a human rights issue. It's a criminal activity. People steal our minerals. And that is not a human rights issue. It's a criminal activity. These are thieves. They steal our economy. It's an attack on the economy, and it must be dealt with that. It's a war on the economy. And if you want to make it a human rights issue, it's a choice you're making, but I'm telling you, it's not a human rights issue. It's a war on the economy.
For the country to be able to observe its constitutional democracy, Minister, it's not just about observing human rights. It's about the different departments doing their work. Yeah. And Minister, I have not heard you speak to consequence management, and maybe that should be the parting shot, to say if, Minister, from these reports that we are going to get, and it is evident that there has been instances where some of the officials could have been slacking, are you going to then ensure that those that were not doing their part, they are brought to book in terms of consequence management?
I have a big debate with Parliament on that, because Parliament talks about consequence management as expulsion and punishment. And my own view is that consequence management is punishment, expulsion. Equally, it is incentives. Okay, equally, it is incentive. You incentivize people to perform, and if you incentivize them enough to perform, you limit its space for punishment. Because punishment inflicts pains, but it doesn't instill discipline. It causes resentment. It doesn't cause commitment. And my own view is that I need a department that is committed to what it should do. And I'm submitting to you, Commissioner, this department that I'm running is doing well. Can I tell you that we're running 12 entities. 7 of them got clean audits and 5 get unqualified audits. Not by accident, because we apply our minds to them and we talk to boards and we say, out of these 5 that got unqualified audit, 1 was a regression. And we've asked them, why did you regress from clean audit to this? Because we pay attention. And to me, that is consequence management. So consequence management is not just punishment. Consequence management includes incentive for performance. And I'm a great believer of that. And that is my trade union background, unfortunately. I know that this thing called performance assessment is the worst tool you can ever use anywhere, because it is always flawed. Okay? It's the most flawed process. But consequence management I agree with you in its broad context. Here, my teachers, they all know that I talk to them open and tell them, good, listen, guys, what kind of an executive is this? This is an economic department, but we have more lawyers in the department than economists. We don't have engineers. It's a technical department. I discussed that with them openly. You see, of all my teachers, he is one who is an engineer and another one, two of them. And I said, it's not enough. Who is an economist? None. None of the teachers. Then all of them are lawyers, and then the teacher is an engineer and an MBA. And I pay attention to that because I know that their performance will together, put together, be my performance. And I'm not naive to that. I'm a Cancerian. I invest on the team. I invest in the team for my success. It's not me who must succeed. It's the team that must succeed. Then I take the credit. So consequence, I agree with you in its broadest context.
Thank you so much, Minister. And I hope you also appreciate that as South African Human Rights Commission, we have been earmarked in the country to look at human rights wherever in the country. Human rights must be observed. The culture of human rights is very important, and that is explicit in terms of Section 184. And colleagues, unless, of course, there's nothing, are you happy? Mr. Medise, can I just hear you on record? Are you happy?
I'm happy. Thank you, Commissioner.
Thank you so much. There's nothing untoward that was raised that you'd want to canvass, Mr. Nkonde?
Due to time, Commissioner, we can go.
Thank you so much. Babu Stede. Thank you so much. Commissioner Makwasha.
Simply to just thank the Honorable Minister and his team, just because we've gone over time, just for the availability. I know that this time we gave you sufficient time as a department to respond to every single question. So thank you.
Babu Dladla.
Nothing from my side, Commissioner. Thank you.
Thank you, Minister, and the team. We really appreciate the time, indeed, as Commissioner Makwasha has said, that you have given us in order to be able to try and elicit a number of issues with you and canvass them. And of course, Minister, please do take to heart that in our work, this is what we have been earmarked to do. We have been requested by Parliament that we ensure that there is observance of human rights and there's a realization of these human rights. And I do not recall at any point them being specific to say for those that commit crimes and those that do not commit crimes. So it's a blanket one, Minister. It's for everyone. And of course, that is why we have South African police that is there to ensure that anyone who is found against the law is brought to book. But with the same tone, Minister, and that is why I said even to the Department of Social Development, MEC, rather Minister, to say social security is a mandate. And that's why we expect her to then engage the Stelfontein Committee and make that assessment and of course assist where the need is. Equally, Minister, that's why we are saying your department, you know, Minister, the name of your department, we always call it wrongly. I must just put it out there. So I'm going to try now. Department of Minerals, Petroleum, and Petroleum Resources. I wasn't too far from it. Even this department, Minister, it's a very important department, as you've put it, that deals with the economy of our country, that can give the members of South Africa at large an opportunity to be able to exercise their right to trade, which is also enshrined in terms of Section 22 of our Constitution. It can give them that opportunity. So if we do not probe, Minister, we do not engage you so that you can look ahead, have that forward, looking with regard to the very policies that you have. Once you would have thought that according to you, you're saying, no, these policies, they are there, but if you think they might not work, no, that's exactly what you're supposed to do, Minister, to say, when this does not work, how do we move forward? And even better, we are supposed to be thinking ahead. Other people will even say, you must think like people that commit these offenses, to say, what would they do in this situation, so that you are not caught aback. You are every time a step ahead of them in preparation for ensuring that the mandate is definitely realized. So again, thank you for your time. And we are now excusing you so that you can engage your colleagues as you'd want to. Thank you so much.
Thank you to all of you for giving me the opportunity. I think you'll learn more about mining. The most unfortunate part is that South Africans are in a mining jurisdiction. They don't understand mining, unfortunately.
Is that not within your mandate to teach South Africans, Minister?
I'm trying hard.
May I then just have your names on record?
Good afternoon, Commissioners. My name is Ursula Brown. I'm the Head of Legal at the Minerals Council.
Good afternoon, Commissioners. My name is Stefina Mudau. I head the Environment Department at the Minerals Council. Thank you.
Good afternoon, Commissioners. Alex Kumalo is the name. I look after social performance at the Minerals Council.
Thank you so much. We're just waiting for Commissioner Magwasha to come back, but we do have Commissioner Magwasha, who's going to be sitting on my left-hand side, and we do have Mr. Lala, who is an expert in issues of mining, and my name is Nomatlubi Kwinana, chairing this session, and also a commissioner in the Human Rights Commission. We do also have our colleagues in the room. We do have Mr. Sitebe. Mr. Sitebe, if you can just raise your hand. We do have Mr. Nkonde, and we also have Mr. Mudise. We have Ms. Mabusela, and the other colleagues are from the media space, but also our report writers that are in the room. So maybe we can at least start with the preliminaries. In terms of Section 15 of the South African Human Rights Act, you are required to then give evidence. It can be done under oath or under affirmation. So may I then inquire then, let's have the first person who must please stand. Commissioner Magwasha is the lady who is now sitting next to me. Thank you so much. Once more, may I then have your full names on record?
My name is Ursula Elaine Brown.
May we have your age?
I'm 55 years old.
Apologies, I know it's a difficult moment. Is it the oath or the affirmation?
I'm comfortable with the oath, Commissioner.
Do you have any objection taking the prescribed oath?
I have none.
Do you regard the prescribed oath to be binding on your conscience?
Yes, I do.
Do you swear that the evidence you're about to give will be the truth, the whole truth, nothing but the truth? If that is so, please raise your right hand and say, "So help me God."
So help me God.
Thank you so much. May we then have the next colleague?
My name is Stefina Mudau. I'm 46 years old. What was the next question? So help me God.
All right, so let me just ask you, so it is the oath that you'd want to take?
Yes, it's the oath.
Do you have any objection taking the prescribed oath?
None, ma'am.
Do you regard the oath to be binding on your conscience?
Yes.
Do you swear that the evidence you're about to give will be the truth, the whole truth, nothing but the truth? If that is so, please raise your right hand and say, "So help me God."
So help me God.
Thank you so much. You may take your seat. Your full names once more and your age.
Alexandra Joseph Muziwentlahla Khumalo, age 56.
Babamtungwa, your age?
Age is 56.
And is it the oath or the affirmation?
Affirmation, please.
Do you have any objection in making the affirmation?
I do not.
To regard the affirmation to be binding on your conscience?
Yes, I do.
Do you solemnly affirm that the evidence you're about to give will be the truth, the whole truth, nothing but the truth? If that is so, please raise your right hand and say, I solemnly affirm.
I solemnly affirm.
Thank you. That concludes our preliminary issues. May we then hand over to you to do your presentation, and we will then allow the legal team to engage you on the presentation. Thank you so much.
Thank you for the opportunity, Chair, and perhaps if I can just take this opportunity to apologize on behalf of our CEO. He has also communicated in writing to your office expressing his apologies for not being able to attend this session. Chair, perhaps also to clarify that the presentation will be done jointly between myself and my colleagues on either side. Perhaps just from a context perspective, just to give you an overview of who we are. We are the Minerals Council South Africa. We are an industry advocacy body representing about 70 members, which collectively represent approximately 90% of the industry's mineral production. I think it has been alluded to by the Minister earlier that the mining industry contributes significantly to the economy of the country. We're also a significant employer, a creator of employment. Currently, our members, based on forecasts for 2025, we employ about 470,000 employees in the mining sector. In line of our vision, our mandate is to advocate for conducive policy and legislative environment that facilitates the growth and investment in the mining industry. And in line with that mandate, Chair, we've looked at the terms of reference that was communicated to us, specifically the issues around the regulatory framework in which artisanal mining operates. And pending the finalization of the legislative amendments, again, that was communicated by the previous speaker, we do see we're still operating in a legislative vacuum, specifically from an artisanal mining perspective, unless the artisanal mining is currently underpinned by a mining permit that's provided for in Section 27 of the MPRDA, and irrespective, of whether it is driven by a socio-economic need or driven by criminal intent, that mining is still illegal mining or unlawful mining. And again, Chair, I think we have had the opportunity to listen to the comments that was made by the Minister. It is important to distinguish between the terms artisanal mining and illegal mining. It goes without question that the mining industry are plagued by pervasive illegal mining activities. Specifically in our gold mining sector, which is targeted not just the surface infrastructure, but as well the underground environs of not only the closed and derelict mines, but also the operating mines. And illegal mining presents and continues to present a significant threat to the security of the state. And to the extent that we are talking about the formalization of artisanal mining, we iterate the importance of, distinguishing clearly between artisanal mining and illegal mining. When it comes to the formalization then of artisanal mining, one of the big challenges that we sit, not just as a country but globally, is that there's no internationally accepted definition of artisanal mining. We've seen that different jurisdictions define artisanal mining based on different criteria, which then leads to the inconsistencies in the classification, and also, the misalignment when we talk to illegal mining, artisanal mining, and we'll see now small-scale mining as well. So what we do believe is that there needs to be a common understanding and a broad alignment of what it is that we mean when we talk to the issue of artisanal mining. And given the absence of that broad alignment and understanding, we also see how it emanates in, the policy's intent and the challenges that we have experienced in defining appropriate policies to govern artisanal mining. I think what was also evident from the previous communication was the distinction between artisanal mining and small-scale mining, and how these terms are often used interchangeably and how these terms are often conflated. Our understanding of artisanal mining, small-scale mining, is what is currently, sanctioned and approved through a valid mining right or mining permit as provided for in the mining legislation. And it also then includes the concepts of junior mining and emerging mining, which is a different level of categorization of, the small-scale mining. So based on the socio-economic context, if you distinguish between these concepts of artisanal mining and small-scale mining, it varies from subsistence mining, which is more aligned to artisanal mining, compared to the commercially viable operations, which is then sanctioned by a small-scale mining permit. The environmental and safety impacts emanating from these types of mining then also vary based on the scale of the operations as well as the technologies that are being employed. If we want to define artisanal mining, and this is our definition of artisanal mining, you need to look at the characteristics of the operation. It is typically characterized by its small scale, it's temporary in nature. It often involves very few individuals or family units that then also use rudimentary material and techniques to extract the minerals. The technology that is utilized is premised on manual tools such as picks and shovels. It does not include, the large-scale mechanized mining. And from an economic viability perspective, it is subsistence-focused, providing an immediate income for the miners and their families. There has been quite a number of developments around the formalization or the regularization of artisanal mining, but it still remains a challenge. We've seen in 2022 the publication of the artisanal and small-scale mining policy, which at that stage was published for implementation. We have now seen with the amendments that has come through through the Mineral Resources Development Bill, which seeks to amend the MPRDA, the introduction of a proposed licensing regime to regulate artisanal miners. And this legislative regime talks to a specific, scope or extent of the mining operation. It is limited to 1.5 hectares in extent, and the period for which the license will then be issued will also be limited to a 2-year period. So it's very much aligned to the mining permit that we currently see in the MPRDA, but there's also a separate provision for a small-scale mining permit, which is then envisaged to endure for a period of 5 years. We are encouraged by these processes to formalize artisanal mining, but there are still some concerns regarding, how the artisanal mining will be implemented from an environmental, health and safety perspective. I think the comments has already been made, that there needs to be a fit-for-purpose environmental, mine health and safety regime. And we support that. We also support that there needs to be a coordinated process between the various governmental departments that will enable the effective and sustainable implementation of the artisanal mining permit. And again, we reiterate, that criminal-inspired illegal mining cannot be managed through mining legislation. And we need to keep those terms or distinguish clearly between those terms. I think what is also important, Chair, to ensure the sustainable implementation of artisanal mining once it is properly formalized is that there needs to be, appropriate measures to ensure the artisanal miners have access to capital. There needs to be appropriate support from a technology perspective. Obviously, there needs to be appropriate managed, fit-for-purpose environmental, mine health and safety compliance, and there needs to be appropriate markets through which, the products can be disposed, failing which it will fall, obviously, in the illicit economy. Chair, I will hand over to my colleague, Alex.
Thanks, Ursula. Commissioners, the issue of artisanal mining to us is very clear in terms of the impacts that it could potentially have in the South African context, particularly in as far as the economic benefits. But in the absence of a regulatory framework, the Minister and the DMPR did indicate that some 21 licenses have been issued. The bottom line is that there's still gaps in terms of how you regulate that activity within the current dispensation. So we are actually looking forward to perhaps regulations to the MRD bill when it becomes an act that will deal specifically with that, because at present, the split of the Section 27 that Ursula was referring to does not cater for the full management of the activity. So in terms of the impacts that mining has on communities, particularly the one that we're considering today, we find that because it is not permitted, it remains illicit or illegal. The majority of illegal activities tend to be clandestine in nature. So while we might know in communities the people that are at the forefront, there's somebody at the back that we do not know. So it effectively remains a clandestine activity. We have seen in a number of communities where these activities have led to an increase in violence against children, against women, and in just levels of crime in general. The influx of so-called minors into these communities can be challenging because it's clandestine. You often find that there's very little control or understanding of what the communities, of what these people are bringing, including sometimes weapons, because again, it is a clandestine activity. We have heard and seen instances where, and Stefina will talk about the environmental issues, where chemicals and even explosives have been used. And Mr. Msiza, who is responsible for mine health and safety, could have gone into detail around the kind of controls that are there when it comes to the use of things that could pose dangers in terms of safety and health of people involved in the activity. We are also aware of the fact that levels of coercion in these communities do increase. Communities like to live in peace. Often, illegal activities, any criminal activity breaks that peace. And finally, the minister put it very differently, but we've seen that recruitment of community members sometimes is under the incorrect pretext that this is a legal activity, promises of high rewards, but the risk is downplayed. So it is important to understand that often, because of the desperate nature that we find in terms of the socioeconomics of host communities to these mines, it is sometimes easy to recruit members of the community to take part in these illegal activities. I'm not going to go into the other elements because they don't really fall into the artisanal space. But Commissioner is happy to address some of the community issues, especially around social and labor plans. But again, the caveat is that artisanal mining, small-scale mining, generally is not required to perform in any of that area in terms of social and labor plans. I'm going to hand over to my colleague Stefina, who's going to take us through some of the environmental inputs we'd like to make.
Thank you very much, Mr. Kumalo, and thanks to the commissioners for the opportunity. I'm going to speak broadly about the principles of environmental management in the mining industry, and also taking cognizance of the comments that were made earlier on by my colleagues of the fact that the current regulatory regime for environmental management in the country is not necessarily fit for purpose for the artisanal mining operators, given their scale, in that they are very small scale, and most of them are not necessarily equipped from a financial and also technical point of view to be able to carry on the current regulatory requirements in as far as environmental management is concerned. So by way of background, I think we need to state that as the mining industry, we acknowledge the fact that mining is a destructive activity to the environment and also to land surfaces. So there is no question on whether mining has got environmental impacts or not. Hence the issue is, how can we avoid those environmental impacts? In instances where we cannot avoid them, how do we prevent, put in place the mitigation measures? And in instances where mitigation measures are in place, how do we manage those impacts and also ensure that the rehabilitation techniques that are employed adequately deals with the prevailing environmental impacts coming out of the mining activities? We operate in the context wherein there is myriad of issues interfacing with the current operational mines that ranges regulated under. We do have the mandatory legal frameworks in terms of the various legislations and I'll speak more about that later on. The mining industry also operates within the confines of strict licensing conditions in terms of the various licenses that are required for one to mine. And there's also, over and above that, there's also continuous oversight, enforcement, and also compliance monitoring to ensure that indeed the objects of those legislative requirements are met. So even though we do have quite stringent regulatory frameworks dealing with mine environmental management in the country, it has been earlier on articulated that those regulatory frameworks are not fit for purpose for your artisanal mining operations. So in light of the fact that mining has happened in this country for many, many years, you would appreciate that there has been an evolution of legislative development in as far as mine environmental management is concerned. And this legislative evolution dates back from your Mines and Works Act through to the Minerals Act of 1991, which is really where more comprehensive environmental requirements were introduced, and also moving to the MPRDA that was gazetted in 2002 and implemented in 2004. Here we saw strong emphasis on sustainability issues, the contribution of mining to sustainable development, mandatory requirements for an EIA, and also approval and implementation of the environmental management programs, the requirements for financial provision for rehabilitation and mine closure planning, more effective environmental management, and also the requirements for concurrent rehabilitation. And from there, there was also a shift to a more integrated environmental system that was adopted through the One Environmental System, wherein there was a migration of the regulatory requirements from the MPRDA for mining to NEMA to enable a more streamlined authorization process for environmental issues in the mining industry. And that's where we saw then the movement from the MPRDA to NEMA in terms of the regulation of the issues in the mining industry. And there was also an agreement that the Minister of Mineral Resources will then become the competent authority to implement NEMA and its regulations, which is your NEMA EIA regulations, the NEMA regulations for public consultations, the NEMA financial provision regulations. So as I've indicated, the mining industry operates under layers of approvals and licenses. So even if one has a mining license or a mining permit, one is not able to exercise that right. You also need additional authorizations in the form of your environmental authorization, your water use license, your atmospheric emissions license, your waste management license. It's quite a very long list of the licenses or the approvals that are required in order for one to mine, and all that is required in order to, uphold the environmental stewardship and to, most importantly, ensure that mining happens in a sustainable and environmental friendly manner. Another key aspect on environmental management that the mining industry takes, very seriously is the issue around water stewardship. As the industry, water is taken as an integral and essential component of the mining activity or the mining business. As you would probably aware that mining happens in South Africa in diverse geographical regions with different levels in terms of the water availability. We've got mining operations happening in, you know, water-stressed catchments. We've got mining operations happening in catchments where there is excess water. And as a result, mining is taken as a very important, you know, business risk issue for the industry. We do have the, you know, instances where indeed the shortage or excess of water impacts on the viability of the mining operations, which in essence also dovetail into socio-economic implications such as job creation, community development, and also restrictions in terms of the expansion of the infrastructure to support the mines. And as I've indicated earlier on, access to adequate water quantities of water and also non-availability of water is recognized by the mining industry as a very serious business risk. Hence, the mining industry has taken proactive steps and measures to safeguard the, both the quantity and also the water quality, and to address any constraints that might impact or impede on the continued you know, production or operational efficiency. In this regard, the industry operates within the confines of the requisite regulatory requirements in terms of the National Water Act, the Water Services Act, and all the regulations that have been promulgated under all the national water legislation. And most importantly, there are also a number of instances wherein the industry has gone beyond the regulatory requirements in terms of the adoption and the implementation of the available best practices in as far as the water resources management is concerned. Having indicated that the mining industry is heavily regulated, obviously in terms of the legislations that I've indicated earlier on, there are consequences for non-compliance, be it in terms of those legislation providing for criminal offenses, penalties, and even going to an extent of, you know, holding the directors of the mining companies personally liable for any transgressions against the environmental laws. With that context, indeed, non-compliance for the mining industry carries operational and financial risks. Hence, there has been concerted effort to ensure that mining companies operate within the confines of the law and all the regulatory requirements. And in those instances where there are breaches, there has been willingness and the effort to correct those failures in order to ensure that there is that business continuity in terms of the viability of the mining operations. This brings me to the end of my input. I'll hand over back to my colleague, Ms. Brown.
Thank you, Stefina. Chair, and just to conclude, and at the risk of not of repeating what we've said, I'll be short. So I think the mining industry supports the regularization of artisanal mining within, you know, the framework that we have defined. We also believe it is important that there is clarity from a regulatory perspective as to what it is we mean when we talk about artisanal mining, to avoid the conflation and confusion. What we are looking forward to is effective implementation, and then obviously collaborative governance across the various departments to ensure artisanal mining is addressed in a sustainable manner. I'll conclude there. Thank you, Chair.
Thank you so much. I'm going to then hand over to Commissioner Makwasha. She just needs to put something on record before I hand over to the colleagues.
Thank you, Chair. Chair, in terms of the procedures, I just want to disclose that Mr. Tebalo Chabane is a member of my Section 11 committee. So for the proceedings to be fair, I just need to disclose that, and he is also a member of the Minerals Council, South Africa.
Thank you so much for that. Colleagues, are you ready? Mr. Nkonde?
Thank you very much, Commissioner. I'll be very short. That is and colleagues. A few questions from me. I'll just be direct and go straight to the Stelfontein issue. I think you've been following throughout the day that most parties have categorized it as a criminal activity. The Commission has not taken a position. We are still gathering evidence, and we will consider everything in totality. We understand that you were engaged to come into the party in terms of the rescue mission in Stelfontein, particularly to that shaft, Buffelsfontein, and I think it's the name of the mine, but shaft 10 and 11, when the crisis happened. Can you confirm that?
Through you, Chair, Commissioner, yes. Our principals were engaged through the Department of Mineral Resources and Energy, specifically the Minister of Mineral Resources, to support with the safe extraction of the miners that were underground. Based on the information that was provided by the Mine Rescue Services regarding the risk assessment that they have done, and the costs associated with the rescue mission, the Minerals Council agreed then to support, to provide, support through the Mine Rescue Services to assist with the rescue. And from a monetary perspective, we agreed, that we will contribute 50% of the costs of the rescue mission. Thank you.
Okay, thank you very much. I will not go into the actual figures. How were you engaged? Was it in writing? And can we have that? How were you engaged, and when in particular were you engaged to come into the party?
Chair, I speak under correction, and I might have to go back just to confirm. But I do believe that there was a request from the Minister of Mineral Resources to meet with our principals, and our principals are the office bearers of the Minerals Council. It happened towards the end of December last 2024, and I have to go back to the date. Perhaps if you just allow me a minute, I can perhaps confirm the date. But it was a request from the Minister to our principals to support with the rescue mission. I do not recall that there was any request in writing. It was a discussion between the Minister and our principals. Thank you.
I would request that that information be provided, because one of the issues that the Commission will have to determine is from the time you were engaged, or from the time when the incident happened, or the crisis happened, what were the steps and how did you fit in? Were there any delays? And if there were delays, who contributed and what not? We are looking at the entire issue. So timelines are very important as to where and who fitted in at the particular time. Can we get that? I understand that if you don't have it in writing, particularly now that the CEO, you're saying the CEO is not here, and you are referring to your principals, can we have that, a proper confirmation? And I would request, Commissioner, as well, that coupled with that request, can we get a confirmation as to when did they agree to actually assist?
Yes, Chair, we can provide that in writing.
I think my second question would be, is Buffelsfontein one of your members?
Chair, we just need to clarify that. I think the Minister did indicate that they are a member of the Minerals Council. That is obvious. That is not correct. Buffelsfontein is not a Minerals Council member.
Thank you very much for the clarification. Then my question would be, now it's a hypothetical question, but we would want to understand that if one of your members was not compliant, how then do you give support to them? If they have been issued with notices and they are not complying, do you give them support, or do you wait until there's some sort of a crisis in order to intervene?
Chair, I'm not sure if you're requesting me to answer, because you did say it's a hypothetical question, so.
Let me be direct then. Have you intervened in issues where some of your members have been found wanting in either way in one of the regulatory frameworks? And if you have, to what extent?
So I think that is a complex question. Firstly, just to put it on record again, that Buffelsfontein is not a member of the Minerals Council. There was specific conversations and discussions with our principals, and I think, as you are very much aware, what happened at Stilfontein was defined or termed as a humanitarian disaster. The Minerals Council, as a gesture of good faith, based on what has developed at Stilfontein at that particular point in time, and based on the requests from the ministry, agreed to provide the support through the mine rescue services who undertook the rescue activities. In the past, we have supported a company, and I again would speak under correction, but we have supported, or provided support to the Jagersfontein disaster that happened. When was that? A couple of years ago. Again, Chair, there was a crisis that had emanated, and to assist with the mitigation of the issues, and following due processes, following engagement with our members and getting appropriate mandates from our membership, we did agree to support to mitigate the issue. The question that you've asked is whether or not we've provided support to our members that are non-compliant. I think that is perhaps a bit too broad a question to provide you with a specific answer. I think we need to be very specific, and we will be happy to answer a very specific question, but I think it's a bit generalized at this point in time. My colleague just want to answer as well.
Thank you for the opportunity. Perhaps I should try to give a broad response, seeing that it's a very broad question. Maybe just to also indicate the fact that all member companies of the Minerals Council are expected to comply with the membership compact. And if you look at that membership compact, which each and every member of the Minerals Council has signed and also sort of committed to comply with, there is quite a huge element around compliance, wherein a member company commits to comply with all the regulatory requirements. So us being an advocacy body and also providing thought leadership on a number of issues, we do support our members in terms of, assisting them in, clarifying certain regulatory requirements and also assisting through the development of the best practice and also the guideline with a number of aspects. All those are done in order to give the necessary support to our members in order for them to comply with the relevant or the requisite regulatory environment. So in instances, as you've stated, hypothetically, if there's an area of non-compliance, obviously as the Minerals Council and also having that pact with our member, we'll then take it upon ourselves to engage on the issue to understand where the areas of non-compliance are and also provide the technical support in terms of how it can be done in order for that particular company to comply. Thanks.
One last question. Jagersfontein, we have a provincial manager from Free State. To what extent did you provide support in that crisis? Or maybe you could convert it into financial contributions. How far did you go?
No, thanks, Commissioner. Jagersfontein, the mining company that was operating there was also not a member. I must put that on record. But when the crisis happened and the TSF failed, we as the Minerals Council, again, came together and offered to assist in terms of the humanitarian side of things. We were requested, for instance, by the municipality to repair some of the damage to the infrastructure. But our response was that remains solely the responsibility of the owners of Jagersfontein. We were more than happy to assist in the humanitarian space, like provision of water to schools that were no longer receiving water, assisting where we could, but by not displacing or taking away the responsibility from those that were responsible for the disaster. In terms of financial provisioning, we had to go out to members and request voluntary contributions, which we did receive, put it into a separate account, and manage those funds from there. We are more than happy to, in writing, to provide you with the figure that was collected, but the monies that were collected were used to provide emergency food, provide water through the Gift of the Givers and other NGOs that are operating in the area, but none of those resources were used to take away responsibility from the owners of the mine.
Thank you, Mrs. Chebe.
Thank you, Chairperson, and good afternoon. I have 4 questions at best. And maybe let me preface my questioning with this. Because they are short questions, they are not antagonistic. I just want to make clear of that. And the purpose of these questions are more educational for members of the public, for us as evidence leaders, and for commissioners. So you say the Minerals Council South Africa is an industry advocacy body. Am I correct then to assume that your concern is only of those, the interest of your members are your only concern. The communities with which they operate, it's a concern of people like the South African Human Rights Commission and other NGOs. You don't enter that space.
That is incorrect.
But with the amount of mine-related violations happening in communities, absence of SLPs, contamination of water, cracking of houses, and so on and so forth, how is that still not correct? It may still not be correct, but what do you say to that? Thank you.
We have indicated the plethora of legislation that guides our activities as a sector. And each one of those has got a regulator that looks after that. We are not the regulator. We are a voluntary membership-based organization. And as Stefina was saying, we do have a membership compact that our members do sign up to. One of the roles that I play as a member of the Women's Council, as an employee of the Women's Council, I work with members to improve the outcomes of their community development activities. It is not a true science, community development. And we know that there are shortcomings. But at the end of the day, our host communities who bear the brunt of the activities that we carry out as miners are very close to us. Hence my being here, hence my working with our members, the municipalities that we operate in, provinces that we operate in, and even a number of the national departments that have got community development elements in their portfolios.
Yeah, thank you. And I appreciate that you are not a regulatory body. So it's not for you to go and see that all the regulations required are ticked and all the I's are dotted and the T's are crossed. But come with me here on page, no need to go there, I'll read it for you, it's very simple. On page 454 of that file, the first line, for example, says, it's self-evident, so I don't have to give you much context. The Commission finds that the current SLP system does not adequately address the negative impact of mining activities and that the systemic issues in the design of or compliance with SLP commitments limit their ability to drive socio-economic transformation in mining. As someone who's on the ground in your previous response, this is a consistent theme. You don't have to hear from the Commission saying the SLP doesn't work. Go to any mining community, they'll tell you that the SLP don't work. We have another study, I'll find it for you if you want, that says SLP achievement is 23%. The Commission's found similar numbers there. So as much as you're not a regulatory body, are you still adamant that your members are fully compliant with the regulation and they are fully in concert with the communities with which they operate in? Thank you.
I did not say they are fully compliant.
No, I accept that. I think it's an indication that maybe, for example, this recommendation was not directed at the Mining Council, it was directed at the MRE. I think maybe going forward, the Commission should also start seeing how it can make recommendations to advocacy groups like yours. And they may not be binding because you yourself are not regulatory bodies, but maybe they'll find a way. So that's minus 2 questions. One interesting question I have is this. There are no zamazamas in Australia. There are no zamazamas in Canada. There are no zamazamas in the US. And these countries have been doing mining for hundreds of years, even earlier than we started. Has the Minerals Council ever done a study, comparative or just inquisitive, to say why are we beset by these problems? Why are your members beset by these problems, yet comparative to other countries, that's not the case? It's just an exploratory question. If you don't have an answer, I'll still accept that. Thank you.
Although we haven't done a study along those lines, just the basic socioeconomics paint a very different picture. The US has got 4.5% unemployment rate. It's a very law-abiding society in Australia. And Canada has got a very different way of operating in terms of mining. It's a very big country where you actually hardly have host communities in mining. In fact, in Australia, it's common to have a fly-in, fly-out arrangement because the mine has got no communities around it. They literally fly people in for 2 or 3 weeks, and they go home for 2 to 3 weeks. So it is a very different operating environment. South Africa is besieged with high levels of unemployment, high levels of poverty, and high levels of inequality. Some of that we owe to our history. When the minister was talking about things that changed after 1994, one of the reasons why social and labor plans became a mandatory CSI activity, because that's what SLPs are. They are CSI, but now it's mandatory for you to retain, to gain and retain your license to operate. The reason then we have the scourge of illicit activities lies primarily in the fact that there are high levels of deprivation. In fact, if you go to a town such as Kathu in the Northern Cape, where the guys that deal with numbers, they'll tell you that the per capita income of a taxpayer in Kathu is in the top 10 in the country. That in isolation, heading that in isolation, you would not expect 50% youth unemployment. I need to find that. The Gini coefficient of the JTG district is 0.67, although there's some 28 mines along that Kalahari Basin. So the 3 jurisdictions that you're referring to are very different, and ours is highly influenced by the fact that we have got very high levels of unemployment and very high levels of poverty.
Commissioner, I don't know how we're going to fit in that. It's quite insightful how we're going to fit that into our report, because we find ourselves in South Africa. It's not that we're finding ourselves between a country that is between Canada and South Africa, and therefore we can maneuver ourselves towards the Canadian model rather than South African one. So, but it's insightful, and that was the whole point of that question. My last question is one of the mandate of oh, sorry.
Apologies, Commissioner, and perhaps if I can just add to that. I mean, when we talk about illegal mining in South Africa, it's not merely a case of someone operating without a mining authorization or a license. The Zama Zama mining activity is it's significantly different. I mean, it is embedded in criminal activities, criminals, transnational criminal syndicates, that undertake these activities. The nature and the manner in which they operate is very violent. You do not see that necessarily in other countries. I think from a mining sector perspective, we have seen instances where these illegal miners are armed with R5 and assault rifles. The manner in which they operate is very military orientated, and you cannot equate that type of conduct to someone who's merely mining without a lawful authorization. So I think from a comparative perspective, it's also important to understand the differences and the manner in which illegal mining is manifesting in the South African jurisdiction. Thank you.
Last question. There was a concession, I can't recall which speaker it was, that mining by its nature is very extractive and it takes a toll on the communities with which it's done. It's true. During this questioning, that was also evident. I wonder what mechanisms in the future, what mechanisms is the Minerals Council looking into to mitigate that hard blow to the communities? Why am I saying in the future? It's because where mining companies have left, whether they were members or they're not members, it's dire. You can't live there. The roads are done, the schools are dilapidated, no employment, and so on and so forth. So is there an effort by the Mineral Council to say, whilst we operate, we're going to put some effort after we operate, our members should still put a certain level of effort. It's not if there's no such, it's also acceptable to me. But I think this exercise is aimed at seeing that the Commission doesn't produce another report without lessons to be learned going forward. Again, thank you for your time. Thank you for the insights you've shared. Chairperson, that would be my last question.
Thank you very much, Commissioner. I'll respond from an environmental perspective, but your question also has some socio-economic aspects as well, post-mining. I think from an environmental perspective, we are confident to the fact that there is sufficient safeguard in terms of the environmental management programs that are currently in place, that all the prevailing environmental issues are managed accordingly. And also, I mean, if you look at the legal requirements, each and every company operating in South Africa is expected to have a very comprehensive rehabilitation plan that clearly stipulates your rehab plan, the actual and land use objective that you have to meet in your rehabilitation activities, and most importantly, the plan that needs to be put in place post-mine closure. And now, as the industry, we are moving from rehabilitating just to fulfill the environmental requirements to also look at successive economies post-mining. So in essence, with the current thinking and also with the current trend, we should not, with the current operational mines, we should not see any ghost towns, we should not see any unrehabilitated mining lands. I think the example that you gave, Commissioner, is mainly, it can be attributed mainly to your derelict and ownerless mines or abandoned mines. But in terms of the current operational mines, as the Minerals Council, we are quite confident that with the mine closure plans that are currently in place, the rehabilitation plans that are being implemented, we should see mining lands being rehabilitated satisfactory to a manner where if there's any residual and latent impact, there are funds that have been set aside in a form of financial provision to deal with those environmental impacts or latent impacts that might arise in the future post the implementation of the closure plan and also post the issuance of the closure certificate. So I thought I'd give a response from an environmental perspective. I'll hand over to my colleague, Mr. Khumalo, to respond on socio-economic aspects of mine closure. Thanks.
No, thanks, Stefina. The reality is that, yes, we are extractive, but the biggest reality is that the way that we plan is inadequate. From the regulator, in fact, the laws that guide what we do, to the way that we execute certain things. By way of example, the minister spoke about a school in Itujwa, in the Eastern Cape. That school cost 70 million rand. He cut the ribbon together with the mining company that built the school, handed the school over to the MEC for education in the Eastern Cape, and the company returned to Gauteng. That was it. It was a project. Project has got a beginning and an end. The end came when we cut the ribbon at that school. What happens 5 years down the road? Will there be windows? Will the water system and the toilets still be working? The electricity, will they pay for that? Will they still have it? It's something very different. And I think the same applies when you look at the way that social labor plans have been, the framework that guides that has been put together. It's a 5-year plan that has got projects. Often, cycle 1 projects don't talk to cycle 2 projects. So if you think about development, it's incremental, but projects tend to be these discrete buckets. So you might actually have had a clinic built over there. 10 years later, the clinic is closed, grass has grown around it, because things have changed. Somebody hasn't looked after it, or the resources have been reallocated to elsewhere. Maybe community dynamics have changed, because the mine closed, people moved out. There's a number of dynamics that take place in the development space. So we are aware of the shortcomings of the way that we plan. We need to have sustainability in mind when we do the planning. The current SLP guidelines don't provide for that. Even though the law does say that the way that you think about your communities and you plan should be guided by your life of mine. But I have yet still to see an SLP that says this is year 1, we are going to plan for the next 5 years. But we know that we'll be here for 20 years. So in 20 years' time, this is where we need to be. I have never seen a regional manager not approving an SLP because it's myopic. It's looking at the 5 years that are in front of them. Hence the challenges that you have with development. We know that our industry, we come and go. Goldfields in Western area, they've got 70 years of life. A number of mines that we see coming up in Mpumalanga have got 5 years, 10 years, they're short. They leave a hole in the ground. More importantly, they leave a community that wasn't there before, and we depart. But the way that we plan the economy of mining and the economy of development, those two don't talk to each other. That's what we need to work on. Our view is that we need to rethink the whole issue of SLPs. We need to revisit what we consider to be development. Because development, in our view, can't be treated as a project. Because, believe me or not, you can do these projects if they are not interconnected and they also don't talk to the IDPs of the municipality, which will always be there after we leave. That becomes a problem. You might say that, IDPs were supposed to choose projects from IDPs. Again, even IDPs themselves are a challenge. Because again, they've got these 5-year buckets, which might change depending on politicians, on budgeting, on a number of things. They generally don't talk to the special development plan that actually the municipality has, because they are projects. So I agree, there is a lot more that we need to do. We need to refocus our activities while we are still mining, and do plan for alternative economies when we leave. Because in South Africa, we continue, maybe except for Johannesburg, we continue to have mining towns. The ideal situation is to have a town with mining as one of the economic activities that are taking place there, so that when the mines close, the other activities continue to happen, and the communities continue to thrive, and you avoid Carltonville, Velcom, and all of these other areas that are in decline, because mining, Danhauser and Utrecht in KZN, that are in decline because mining activities have stopped, and no economic activity was there to continue sustaining the communities. So I agree, there's work that we need to do, but we also need that regulatory framework that would allow us to be able to do that and do it effectively.
Thank you so much, Commissioner Makwasha.
I would like to thank you so much, and I'd just like to rephrase the question that was posed, I think, by Mr. Nkonde, regarding Jagersfontein as well as Buffelsfontein. Now, they asked if there are members. My question is rephrased: have these two mining companies ever been members of the Minerals Council?
No, they've never been members. Actually, Jagersfontein is not really categorized as a mine from a legal perspective. So they're not authorized in terms of the MPRDA. Thanks.
And I note that you state that you're not a regulatory body, but I think you have influence on the conduct of your members. Is that correct?
Absolutely.
Now, if you have influence on the conduct of your members, would you not be concerned regarding the ongoing public perception of the mining industry as a whole? And the reason I'm saying this, in our 2024-2025 State of Human Address, or State of Human Rights report, outside government, our biggest private human right violators was Anglo Platinum. Noting that, and noting that you have influence on your members, how do you ensure or influence your members not only to adhere to the laws, but to ensure that their conduct does not violate human rights?
Anglo-American Platinum, Valterra, I suppose they're always on the spotlight. I haven't seen your report in terms of the aspects of human rights violations that you are referring to, but I'm going to premise my response on what I understand that to be. The challenge is that the likes of Anglo-American Platinum then, or Valterra now, faced largely around environmental issues. They're around the impacts of blasting. They are around relocations. Perhaps not enough inputs in terms of socioeconomic development. Could be water issues as well, depending on whether you're talking about Mogalakwena or the Feist and Limb operations such as Twickenham. We do work with our members as a voluntary organization. We can only advise our members in terms of some of the challenges that our communities are facing, be it on the environmental front, be it on the legal front, or on the community development front. If you were to ask any one of our members around the importance of human rights, everyone says we all cherish and we will do everything possible to protect human rights, just like we as individuals would like ours to be protected. The reality of our activity, however, doesn't always point to that. So if, for instance, you talk about resettlement, resettlement is a challenge in the sense that on paper, it might look good. In the long term, it generally turns bad. There have been very, very few resettlements that have led to prosperity in the eyes of, or in the lived prosperity of the people that were relocated. So we'll have a look at your report, and I am convinced that the violations that are reported, it's probably not just Anglo-American Platinum. They probably stick out because they're a significant player. But it would be good for us to have a look at the report and then put in place plans to support our members to improve in those areas.
Through you, Madam Chair, if I may also add to that, I think it's important that we see the report. It is very difficult and challenging for us to respond without understanding the details specifically. I think from a Minerals Council perspective, our members do respond and adhere to responsible mining principles. And we also adhere to the human rights principles. I think the Commissioner has carried the conversation by saying there are perceptions. So I think it is very important that we do not legitimize perceptions. And I think Anglo-American Platinum, Valterra as they are now known, as well as any other mining company, would probably have responded specifically to those type of allegations. And in the absence of seeing the report, their responses, I think it's very challenging for us to answer to that question. Thank you.
I'm glad we agree that SLPs do not effectively work in the current design, because I think one of the concerns we've seen is how mining towns become ghost towns. And because they become ghost towns, they're open to issues of illegal mining because, one, there is no proper closure of those mining operations. There is no proper rehabilitation. And rehabilitation cannot look like you just simply close the mining activities and leave and say, we've closed the mining holes, therefore we are compliant as a mining company. Now, coming back to that, when the department and the minister testified, they stated that Section 93 notices are issued to a number of license holders. Do your members come to you for assistance when they have been issued with Section 93 notices?
Commissioner, the Minerals Council is an industry advocacy body that represents the interests of our members as a collective. When there is a notice that is limited to a specific operation, it is not necessarily the situation that they would inform us. You would also know that the Section 93 notice, companies do have a right of response, and they might not necessarily agree with the notice that has been issued. So I think it depends. The circumstances will vary, and it depends on the issues that are being identified in the Section 93 notice. But to the extent, generally, if it's issues that's impacting the industry as a whole, we would be informed about those issues, and determining on what the issues are, I mean, that will obviously inform the response as well.
My last question is, have you as a voluntary organization expelled a member for failing to comply with the laws of the Republic or to protect the provisions of the Constitution, human rights? Because we cannot operate in communities without adhering to human rights. Have you expelled a member for failing to adhere to the laws or to any other provision?
To my knowledge, we have not terminated any membership for failure to comply with human rights obligations. There has been instances in the past where we have terminated memberships based on, the issues that had presented at that particular time. I think it's also important to note that we do have a constitution that companies need to comply with. And following due processes in terms of the Constitution, companies were afforded, opportunities to address issues and subsequently continued to deal with that. That might have resulted then in a termination of membership.
Commissioner, just one question. I finally received the email that I was looking for. In preparation for the inquiry, and apologies for this, in preparation for the inquiry, we wrote to Buffelsfontein and asked them to appear before us. In one of the responses, they said, because we have invited the Minerals Council and you're mandated to be the spokesperson of the industry, they would align themselves to what you would be submitting to the Commission. Noting that they're not a member of the Minerals Council, what is your response to that statement to the Commission?
Commissioner, we do not have a mandate to speak on behalf of Buffelsfontein mine, and I think they would have to address that question themselves.
Thank you, Mr. Dlala.
Thank you, Commissioner, and good afternoon, Minerals Council members. Is it acting or former acting police provincial commissioner in the Northwest informed us that you guys sit on the net joints? can you confirm to the inquiry if you guys do sit on the net joints?
We do not formally sit on the NAT joints. We do attend NAT joints meetings as invited guests, and sometimes, you know, we also approach the NAT joints, you know, to engage on issues, specifically the criminal issues and security issues that's impacting the mining industry. But we do not have a formal seat on the NAT joints.
Thank you. In your presentation, you speak about the membership compact. Can you please expand? What is it? Is it a document? Is it a framework? Just explain to us, what is it?
So, as I said, we are a voluntary industry association representing member companies, so their participation is voluntary. Our membership conduct compact sets out, you know, the values in terms of which, you know, we operate and we require our membership to operate. And it then, you know, informs a commitment to align with the values and align with the compact. It is not a regulatory instrument. It has no enforcement powers. We are not a regulator, so we cannot enforce. So it is an agreement, a voluntary agreement that sets out the terms of engagement.
So it's only works between you and your members, I guess so.
That is correct.
Have you ever, what happens if a member transgresses? Or have you ever experienced something like that before? And how often, because I believe that you have the power to engage with your members, and how often do you monitor their conduct against this membership compact?
Through you, Madam Chair, I think, as I've indicated previously, there has been instances, or an instance where the membership of a particular member was terminated for non-adherence, you know, to our constitution and, you know, the compact. So, yeah, generally, I think from a Minerals Council perspective, we do not often find ourselves in the situation of, you know, where we have to address our members for non-adherence to the values as espoused in the compact. But I think in instances where it has happened previously, where we've identified a situation, opportunities were given to engage on the issue, and, you know, following those due processes, you know, it did result in a termination. But it's something that doesn't happen on a regular basis. I think I have mentioned previously, our members, in addition to compliance with the laws of the country in relation to mining and other legislation, they also adhere to voluntary principles as set out in the human rights framework, responsibility for responsible mining. Fortunately, we do not find ourselves in the position, you know, where we have to address our members on these issues.
Commissioner, I'm trying to ascertain here whether this membership compact is one of the mechanisms used by the Minerals Council to ensure that their members are working within the agreements and the values. And my concern is what happens if they are not, if they are in breach of those values, That's one. Maybe what I should be asking is that known to the communities where your members are operating? And if so, can a community member come to you and report a mining company to say, this mining company has violated the membership compact by doing 1, 2, 3?
No, thanks, Mr. Dladla. The membership compact, we do not take it out to communities, but it is on our website. There is a community in Velcom that I'm currently working with. In fact, they've written to the President of the Republic and to the House of Lords. And the one of the provisions in that letter is looking at our membership compact and the fact that one of our members in the Free State is not compliant. So it is accessible to communities because it is on our website, but we do not actively disseminate it to communities. But if you're looking for it, it is easy to find just under the membership section that is open to the public.
Why is it not disseminated to communities? Is there a reason?
It is not actively disseminated, but if anyone asks any one of us or even members, to provide them with the compact, they would gladly do so.
Can a community member come to you and complain that your member is not adhering to the Minerals Council's compact?
Yes, they can, and they have. In the case of the community from Velcom, it was on that basis that they contacted me in particular to help them deal with a member that in their view was not compliant or was not listening to their demands.
So how do you then expect people to know about the compact if you are not taking it upon yourself to ensure that they have the right to come to you to complain about a member who's in transgression of the very same compact of the Minerals Council?
We remain an advocacy body, but as I said, there is transparency in terms of the compact because it is easily accessible on our website.
Thank you, Mtungu. Now, let's focus on Stilfontein. Your role in Stilfontein, did you have any role besides funding the rescue?
No, we didn't.
Thank you. I don't know if, Commissioner, you've heard it on record, the process of ensuring that the Minerals Council ends up paying 50%. And I'm not sure if you know that the government, the Department of Mineral and Petroleum Resources Development Act got back their 50%, which was paid for, said the minister, by Buffelsfontein. When you were paying for the rescue, were you expecting anything back, or what was it?
So at the time that the request was made, there was a crisis unfolding at the Stilfontein mine. There was a suggestion that this is a humanitarian crisis, and I think from the media coverage that we had seen, there was a suggestion that, this situation can evolve in an imminent disaster. Based on that, there was a request at a particular point in time, and as I've indicated, we'll come back with the specific dates when the request was made to our principals. There was a request to the Minerals Council to support, the safe extraction of the miners that were still underground. We've considered the request, and we've considered the seriousness of the issue, and following due processes by engaging our members, we agreed to contribute support, technical support, to the mine rescue services to undertake the extraction activities. Our contribution was made to the mine rescue services. At the particular point in time when the contribution was made, there was no expectation that, you know, the monies be paid back.
Am I correct in thinking or concluding that you funded 50% of the operation or the rescue operation?
We have communicated that in our earlier discussion, so that is correct.
Did you know what was the rescue plan, or was the rescue plan discussed with you at all?
The rescue plan, to my knowledge, was not discussed with us specifically. The rescue mission was undertaken by the Mine Rescue Services. They have done their own risk assessment based on the situation as they had seen it, and they had defined the rescue plan without any engagement, discussion, or consultation with us.
Were you ever interested in the rescue plan?
The Mine Rescue Services, you know, is an independent body that the mining industry work with from time to time, specifically in instances of emergencies, and to undertake, you know, these type of services, because they've got the technical expertise to do that. Based on what we understand was happening at Stilfontein, a disaster was imminent. The Mine Rescue Services, whom we understand have been engaged to undertake the rescue mission, have done the necessary risk assessments, and they were and are the appropriate people to determine, you know, the appropriate rescue approach that needed to be adopted. So we were not involved in the rescue mission, if that is your question.
Commissioner, I find this a bit puzzling, because they funded the rescue. They were issued an invoice that had the services that they were paying for, yet they did not understand what they were paying for. The rescue was meant to take more than 5 days, as communicated by the then minister, but it went on for 2 days only. Right now, there are families that have members that they believe that were underground. It's a year and so many months after, those people have never resurfaced. Now my question again is, you funded the rescue mission because they had the expertise. Are you sure that everybody that was underground was rescued?
Commissioner, through you, I cannot answer that question. The rescue mission was undertaken by the Mine Rescue Services. They have done the risk assessment. They have ascertained, and I think from the media communications that we have received, there were requests by the illegal miners to come out. What transpired at operational level as to why, if you're saying there are still some people that are underground, why they have not afforded themselves the opportunity to come out, I cannot answer on that. Yeah, I cannot respond to that question.
I put it to you, it was impossible to come out through shaft 11 on your own. Shaft 10, we've heard from other testimonies, was so difficult because going from shaft 11 to go to shaft 10, it was said that it would take about 3 to 4 days, and there's water around that area. And for one to resurface out of the Margaret shaft, even the operational mine that's there did mention that it was nearly impossible. And it is believed that there were people that died trying to move from shaft 10 to shaft 11. So the notion of saying people should have voluntarily come out was nearly next to impossible. Yes, there are those that came out, but no one has explained how did they come out. Because on shaft 10 on its own, as you would see, it's about 4 kilometers going down. That's where the Community Rescue Mission was able to extract bodies, and they were able to take down the food portions that were meant to come out. So the notion that people did not want to come out is not a true reflection of what really transpired down in shaft 11. I think my last one, Commissioner, in your conclusion in your presentation today, you do mention that artisanal mining presents significant challenges to the industry. And there's an absence of regulatory frameworks aligned to it. Now, the minister was explaining to us today what is artisanal mining, what is illicit mining, what is small-scale mining, and now there's junior mining, and now there's middle-scale mining. And then I asked, what regulates artisanal mining? Is it regulated within the MPRDA? And he said yes. Now, how is this a problem, a framework problem, if the MPRDA regulates artisanal mining in the country?
So currently the MPRDA talks to a mining right that you can obtain in terms of Section 22 of the MPRDA. It also talks to a mining permit. Now that mining in terms of Section 27, that mining permit is not defined as a small-scale mining permit or an artisanal mining permit. So in terms of Section 27 of the MPRDA, you can undertake artisanal mining provided the scale and the size of your operation if you are authorized with a permit that is issued in terms of Section 27. The amendments to the MPRDA through the MRD bill now specifically distinguish between the term artisanal mining permit and a small-scale mining permit. An artisanal mining permit, that process, you know, the requirements for artisanal mining permit is now defined in terms of Section 27A of the proposed amendments, but the process of, you know, finalizing the legislation has not been concluded. I think I spoke earlier with regard to, you know, the terminology that we are utilizing, and there's no clarity on the terms, and this results in confusion, misalignment of terms. So it is conceivable that in terms of the Section 27 of the MPRDA, the current legislative regime, that, you know, incumbent in that is also the reference to an artisanal mining permit, although it is not specifically defined as such. Our understanding of what an artisanal mining permit is, I think we have communicated that in our presentation.
Thank you so much. Just the last one, maybe just a quick yes or no, and then I hand over to you, Commissioner. So, after the rescue mission in Stilfontein, have you ever engaged with the mine rescue services regarding, have you ever had any reports from them regarding the rescue mission, technicalities, difficulties, anything that you've ever get as communication from the mine rescue services. Thank you so much. Thank you, Commissioner.
Chair, through you, I will have to go back and engage our CEO or our principals. Me personally, I have not engaged with the mine rescue services, so we will come back with that response.
Thank you so much, Mr. Dladla. My question is on the environmental laws. I think, Ms. Stefina, you have submitted that we do have laws and to a large extent it would look like they are functional, but then one would have to ask, when you look at Bafosfontein, would you say there was compliance with the environmental laws and the regulations that relate thereto?
Thank you, Commissioner Kunana. I think that's a very difficult question, really, without being privy to their authorizations, be it their environmental authorizations, their water use license authorization, privy to the extent to which they're complying with their environmental management program, or any conditions that are attributed to the various licenses that they hold. So at this point in time, really, it will be difficult to indicate whether they are complying or not without being privy to those documents. Thanks. And I think the DMPR should be really best placed to indicate the compliance level of that mine. Thanks.
If you can just once more state those documents, because it would mean we need to go back to them and request them.
All right, I think you need to request for their environmental authorization, their water use license authorization, depending also on whether they've got a waste management activity. They might also be eligible for a waste management license. And also, obviously, you will also need to check as to whether they have adequate financial provision for rehabilitation or not, and also assess as well their rehabilitation plan. And the obvious one would be their mining right as well. Thanks.
Thank you so much. And you still maintain that as for the laws of our country and the regulations, there's no need to relook into them?
Whilst we do have quite comprehensive legislation, there are gaps, there are areas of improvement, especially in as far as the integration of all these fragmented environmental requirements. And the process had started in terms of, streamlining and integrating all the licenses that one requires in order to mine in terms of the one environmental management system. So whilst there is comprehensive regulatory requirements, for me there is room for improvement. Thanks. And there is a process currently underway between the DMPR, the Department of Forestry, Fisheries and Environment, and Water Affairs to streamline those regulatory requirements. Thanks.
Thank you so much. May I then come to you, Mr. Khumalo. You alluded to the SLPs, and you are saying some of these projects does not look like one had the foresight to say what becomes of them after having handed over the project. And in fact, you quoted the school that the minister has alluded to, which was in Ituchwa, which was for 70 million. And you've spoken to the fact that one would then be worried about when things start falling apart? Is there a plan? So how would you say we should approach this? What would be your recommendation?
Commissioner, there isn't a simple solution to this, but perhaps one of the areas where we can improve is to remove the notion of a project, but have a longer term commitment where we continue walking the path with the communities where we operate. Because we know that there are shortcomings in the recipients of especially infrastructure projects, be it roads, clinics, water infrastructure that we put in place. There are often shortcomings where, I'm not sure if the Department of Education in the Eastern Cape, for instance, is going to provide educators that will produce engineers from the 70 million rand school. I do not know if they will have mathematics, pure mathematics being taught at that school. I've come across a school in Marikana that was built, handed over in February. In August, the Department of Education in the Northwest had not equipped the laboratories as per the MOU. So you had a school built by a mining company in Marikana without a laboratory. And yet we wanted to produce engineers, scientists, and so on. So for me and I think the Ministers' Council, it's important that we approach development a bit differently and move away from treating it as this discrete projects, but look at it as a continuum that we work on with the various stakeholders that are there. So for instance, in the school in the Eastern Cape, I would want the mining company that built the school to be able to put a budget aside to ensure that if the departments fall short on maintenance, they're able to do that. If there is a storm that blows away that school, that repairs can be done. But also, a lot of changes that are deep and long-lasting require other changes. Culture change. Is the school leadership team equipped to utilize this asset? Is the school governing body equipped to hold the SLT, to task in terms of providing, ensuring that education is at a level where it can be? So for me, it's really about how we see development, how we move away from seeing it as a project and rather as a partnership that is there. In the case of municipalities, I know that it's a very hot space, but there are companies that have put together programs, they call them municipal capacity support, where you know that this municipality is going to fail or is failing. The Aegis report tell you that. But then the question is, do you hand over a project that they can't maintain, that they can't budget for, or do you also assist them in equipping the municipality with the capabilities that they require to manage that project? So these are the things that we generally don't look at when we look at SLPs, but there's room for improvement in moving us in that direction.
Thank you so much, Mr. Kumalo. You've also alluded to the legal framework, and I think it is your take that one would still have to look at it. Are you able to speak to that in terms of a recommendation?
The SLP guidelines are from 2010. We have had 20 odd years of SLPs. And if communities who are supposed to be beneficiaries are still complaining about our ability to deliver to their expectations, something is wrong with that picture. But we continue to be guided by those SLP guidelines. The regional managers continue approving SLPs based on those guidelines. To me, it's very clear that something needs to change, and perhaps the instrument that guides how we construct, how we put together these SLPs needs to change. Hence my saying that we probably need to look at what regulates the space in which SLPs exist.
Thank you so much. Of these recommendations, do you perhaps have them in writing, or are you willing to at least assist us with those recommendations that you have alluded to in writing within the next 5 days?
We can put them on paper, Commissioner.
Thank you so much. Let me appreciate your time that you have spent with us. I was a bit worried when you started. You were engaging so much the presentation of the minister, but I think as you continued, we could hear your thoughts, because the reason why you are before us this afternoon was for us to be able to elicit more evidence with regard to the mining industry, but also to hear what recommendations you have which will assist the Commission in making findings, but also ultimately recommendations that will assist the entire industry in ensuring that it thrives. So you are excused. Thank you so much. But because you are the last witnesses of the day, rather wait for us so that we can conclude. Okay, it looks like there's something from Mr. Modise.
Thank you, Chairperson. Of interest, Mrs. Brown, I just want to ask this question. Mrs. Brown mentioned that they represent their members. What does this represent mean? I think it's a general statement for Commission to understand your work. Do you speak on behalf of your members for what, on what, so that we clearly understand that representation? I know you've got a compact agreement. Because you are a lawyer, do you represent them when there's issues against them? And so I think that is very important for Commission to be able to understand before we leave, when you represent your members, what you really do. Thank you.
Chair, through you, I think from the onset of our discussion, we did indicate, what our mandate is and what our vision is, and how that mandate and vision translate into action. So we represent our members. We're an industry advocacy body. There are quite a number of policy and legislative challenges that impacts the industry as a whole. So from that perspective, our mandate is to advocate for a policy and legislative environment on behalf of our members that will promote investment and growth in the industry. So it is from that perspective that our mandate informs our actions.
Thank you. Thank you so much, Mr. Modise. Once more, thank you, colleagues. And also thank you to the language operators for staying on. I know you're supposed to have left at past. Thank you so much for sacrificing in order to allow us to just finalize properly. Thank you so much, everyone, the report writers, our media personnel, our legal team, my two panelists. It's been a long day. So we are adjourning until tomorrow. Let us be on time once more for 8:30. You're all excused.